All right.
Can we go back to number one?
Number one. All right. Mr. Kendrick, Mr. Harvey. All right, we'll keep moving. Mr. Harvey, come back and see me when you have an announcement.
I've got one announcement, Your Honor.
Not ready?
Well, I don't know which case you're talking about, but there's a camera here.
Yeah.
I don't know whether it has anything to do with one of my cases. And if it does, I'm objecting to it. There's been no notice to us. There's been no hearing. I don't know whether any order has been entered. I haven't been provided an order. So I have a problem
Okay.
with the presence of the camera.
Okay. Well, we'll take it up in a little while.
So that's my first objection.
Okay.
My next one is the notice of intent to lying, no matter what it is.
Oh, Bruce, we've known each other for over 40 years. The Apollo Bird. Mr.
That's also Mr. Harvey's case, Mr. Bird.
All right, number three, Judge.
Do you have an announcement on Mr. Bird?
Well, isn't this the status calendar?
This is in
Yes,
person.
Status conference, yes.
Yep.
Okay, we have like a day's worth of motions that are still outstanding on Mr. Bird, correct?
Yes, Judge, we came before the court to address some motions when a potential conflict was discovered. And I think we wrote from that to allow
That's right.
Mr. Harvey time to consult with his client and a potential state's witness about those conflicts and secure outside representation or consultation.
That's right. And one of the outside counsel that has talked with one of the individuals is present here today. So that I'm halfway through resolving a potential conflict. I have outside counsel who's talked to one party, but not outside counsel that has talked to the other party.
Okay.
And this young man who used to have a ponytail and has lost all of his strength and valor by cutting his ponytail is present today.
All right.
Good morning, Your Honor.
Good morning.
I still have hair.
Okay.
Yeah, but it's kind of weak. I got to say.
And so are we going to further notice it at this point?
Yes.
For when? February 3rd?
Well, Judge, you can further notice it to whatever calendar you would like, and it just depends on
Yeah.
whether and I will work on getting that resolved, number one. Number two, I know I'm gonna be on trial during the February 3rd period. So that's an advance notice of conflict. But put it on there, and if something comes up, we'll be able to make it.
You want to do some other date?
I don't want to give a date yet, Judge.
You don't want to give a date, period,
This,
or the 3rd?
they need to, when will the conflict be resolved? Do we know? Can it be resolved this week possibly?
No. I started a trial out of the continental United States on the day after Martin Luther King holiday, and I anticipate that will last at least 2 weeks. So I'll be in trial away from here.
Do you know how long that trial is supposed to last?
Yeah, a couple of weeks.
All right, so we're talking 3rd week in February.
Well, just put it down.
Okay.
I've got a conflict. I can't. I've got a conflict until 2026 at this point. And Max can verify that. He's my witness.
I don't know where I got that February 3rd date.
Oh, okay.
I'm not gonna be
Okay, you'll receive a notice.
All right. Can I just run back and tell Mr. Bird what's shaking?
Sure.
Not while the judge is on
Yeah,
the bench.
yeah. Momentarily you can.
Okay.
All right, did we need to, Judge, here's a note, and if we can address the Kendrick situation, so we can move on.
All right.
Ralph, don't leave.
No, we're talking about the other matter.
Okay, well, as far as Rule 22 goes, I understand that it was filed and decided before you made an appearance.
Okay, well, we're still, I think the rule says after notice and hearing.
All right.
doesn't it?
I don't know if there's a hearing or not. Okay, I'll reread it
Okay, please.
and we'll be in touch. Don't leave the courthouse.
No, I was waiting to go see Mr. Bird, and
Okay,
we're gonna talk with everybody with regard to the other matter.
okay. All right,
And I still have my two witnesses here, just in case.
okay, good. Number 4, Sharon, yes,
Mr. Belgrave hasn't been brought up yet.
he has not been brought up. Okay. Woolens Pierre,
Yes, Your Honor, Mr. Pierre is up, and he can come out if you want. We do have an announcement.
all right. Okay.
This Mr. Woolens,
Mr.
Mr. Pierre,
Mr. Pierre.
Lawrence is his first name.
Pierre, Mr. Pierre.
Yeah, Mr. Pierre.
All right, what's the announcement on Mr. Pierre?
Mr. Pierre, by the way, has positions 5 and 6 on the calendar, Your Honor.
Okay,
Or, yeah. Yeah, right now, we're just gonna have him move to a trial calendar. We're not accepting the offer. Mr. Pierre faces immigration issues that we're still trying to deal with, and these types of charges definitely put him in the ability that he may be deported. At this point, we're just gonna go forward to the trial calendar.
all right. For the notice trial calendar, do you have an approximate date on that?
Judge, it may be the, February or, March trial calendar, I'm not sure.
Okay, all right. Good luck to you, Mr. Pierre.
And that's my case, Ms. Rosser, 88 Hall.
Okay. Both cases, Ms. Hall?
Yes, Ms. Rosser.
Okay.
Joseph Wheat,
Your Honor, my understanding, he's not been brought up yet.
okay. Jamel Fisher,
I don't know, oh, Mr. Fisher, Your Honor, it has to be reset. He is still on loan to Brady, as they say, so he is not available.
He wasn't brought over, Pilgrim.
No, still in Brady.
Okay.
all right. Cherish Okafor,
I believe that they have not been brought over yet either.
all right.
Here or not up?
I'm not brought up. Oh, okay, Weeks here?
Okay, we'll come back to this, that a pretrial.
Yes, that's a good one.
Pre-trial and Wheat. Okay,
Well, on, Okafor, Judge, number 9.
Okafor has 2, I believe that they've been brought up, that it's female.
Okafor is not here. I don't know. I called down the petition, see if he's maybe in route or what he said, but he's not here.
It's a female.
Oh, female? Oh. All right, I'll get.
Hambrick,
Is here.
He's here?
what's the announcement on Hambrick?
Hold right now, I believe that Ms. Dog just got here, we just need to talk to her real quick to see if there's, a response from the police.
All right. That's two cases, 11 and 12. Torrance Roebuck.
Yeah, we're fine, we can bring him out if you want.
All right, is he up? Yep.
Yes, sir.
You're gonna waive formal arraignment and
Yeah, we
move
just
on?
want to address the failure to appear as well.
All right. Miss Nix, you're here on behalf of Roebuck.
I just don't like the show. Come and do what you got to do. And move on.
Mr. Torrance, Ron.
All right. Come on out, Mr. Roebuck. Stand at the podium next to your attorney.
Yes, Your Honor, this is Mr. Torrance Roebuck, number 13 on the jail calendar, 24 SC 000139. We plead not guilty and waive formal reading. We'd like to address the failure to appear. He had a court date on 10/10/2024, for which he failed to appear, and there was a bench warrant issued. In talking with him and checking on the system as well, what it appears to be, it was a address mishap. They had his address in there as 1033 Hollowell, Well, HOLLOWELL, which is, I don't even think it's a street in Atlanta. It was corrected when he got arrested. The correct address is in there. I verified that with him. It's 1033 Hollywood Road, Northwest, apartment R3, Atlanta, Georgia, 30318. So it is correct in there now, but it was not correct, so he did not get notice. So we are going to ask for you to lift the warrant and reinstate the bond. I've checked the bonds. They've not come off them, so they're still good. And he has the correct bonds on the correct charges. So just ask to have the warrant lift and bond reinstated.
What say the state?
Judge, it looks like he was arrested on the bench warrant just a couple weeks after his failure to appear, so the state is in a position.
He was arrested on the bench warrant for the failure to appear.
Yes, sir.
All right.
This case was in non-complex and it was just transferred up here.
All right.
The judicial hold lift order was signed on October 22nd, so he was arrested at some point that day or before.
All right. Mr. Roebuck, is the 1033 Hollywood Road address a good address?
Yes, sir.
And who lives there with you?
This is my friend of mine's apartment where I stay.
All right. And as far as you know, your friend's still there.
Yeah, they still there.
You still allowed to go there?
Yes, sir.
All right. If you change your address, you need to tell your attorney, you need to come down and tell the clerk's office
Yes, sir.
also.
Yes, sir.
You understand that?
Yes, sir.
All right. Do you have your attorney's telephone number?
Yes. Oh, no, not yet, not yet.
Okay. Well, she'll give it to you before you leave. Stay in touch with her.
Make sure I have it.
I'll set aside the bench warrant.
Okay, thank you, sir.
Thank you, Your Honor. That's it.
Next court date will be February the 5th.
February the 5th.
Yep.
Okay, thank you.
Be here whether or not you receive a notice or not.
Okay, then.
Goes for all those other dates, guys. It's February the 5th, not the 3rd. Sorry.
Yeah. Jansen Williams. Anybody here on Mr. Williams' behalf?
Judge, that one, they were gonna file a waiver and I asked the deputies not to bring him up.
Okay.
I've been in touch with Mr. King
All right.
and, we'll probably reset that one to the 3rd.
Or the 5th. 3rd or the 5th?
I mean, the 5th.
All right.
I don't know why we keep saying the 3rd, Judge. It's the 5th. February the 5th.
You're the one who told me the 3rd.
I know, but I don't want you to keep saying it.
Andrew Sybeck.
Because these are,
Bring him out, Your Honor.
Okay.
what's in the game?
Sybeck, number 15. Andrew.
Is Mr. Hawkins still in here?
I'm here.
Mr. Hawkins, was Jason Williams, is that gonna be you?
Yes, Your Honor, or yes, Ms. Ross.
Okay, Mr. King, he was gonna file, he had a conflict for today. He may
Okay.
have been included on that. He's gonna file a waiver. He also filed a motion for bond. I didn't see where one was had. So we'll probably put it on for February the fifth.
Oh, case management and bond.
And yeah,
Okay, got it.
All right.
Thank you.
All right, thank you.
And Your Honor, Mr. Civic waives formal arraignment and enters a not guilty plea.
Okay, Mr. Civic, stay in touch with your attorney. And when's the next reasonable court date? February 5th. All right? Larry Shoemaker,
I'm not sure if he's
that's the one that's in the hospital.
Okay.
He was supposed to be a video judge and, but he's in the hospital at the prison, so we're gonna reset him. I may try to get him on next week, but, cause it's just an arraignment.
all right,
Or probably, that date will be to be determined. How about that?
okay.
That works.
Jasmine Worthhams,
Through the space now, I brought female out of.
okay. That takes care of 18 and 19 and 20. Isaiah Madison,
I believe he's also appearing via video.
he's appearing via video.
Yeah,
Yes,
and I may have given them a 10:30 time. I don't see anybody in the waiting room from the prison, so let's give them a few more minutes.
All right. Demetrius Clay,
He is, he's
Be Mr. Lawumba.
Mr. Luemba, we lose him again. He's in the courthouse, so can you text him, ask him to come back down? Okay, we'll put a question
I'll
mark.
try to find him.
Philando Hunter,
in custody, he's up.
Yeah, hold, Your Honor, just so we can follow up with Ms. Jolly for any recommendations for the probation.
all right, so you'd like to hold for your announcement?
Yeah.
All right. Zachary Pearson,
In custody,
Was that
he's up.
I didn't get a chance to speak with him, Your Honor, because I was still downstairs.
all right, we'll set it down for a plea.
I don't know if Mr. Pearson would like that.
Deja Smith Johnson,
She hasn't been brought up yet, Your Honor.
okay.
I hope y'all was able to just hear me. But Valerie, I don't know what the price was.
He's never been arraigned on this
No,
charge?
he has not.
No, he has not.
All right. Well,
So if we can do it that way,
I mean, is it of the nature that would be right for a plea?
negatory.
All right. Okay.
Well, it would be right, but that's all it would be. We're still, well, we're talking,
All right.
okay?
He's got multiple cases, Judge. He's got one in Judge McBurney.
Right.
It's a more serious case. So I think we're potentially discussing how to resolve that if we can.
So the best way is status quo at this particular
So,
point.
so you're looking for a universal settlement?
Yes.
Okay. All right.
So may we do the arraignment in that fashion?
Sure.
Okay.
Yeah.
And Madam Clerk, may I get the paperwork?
Yes, you may.
Sorry to get you down here for nothing. Of course, I didn't have anything to do with getting, no, I'm talking about the cameraman.
I thought you were talking to me.
No. But it doesn't look like anything's going to happen with Mr. Kendrick's case today.
Trust me, they will come anyway.
Are you working with Mr. Harvey?
Yes,
What's your name?
Attorney Nicole Westmore.
Okay, Mr. Westmoreland. All right, nice to meet you.
She's the brains and beauty. I'm just the aging boy. It's cold out there. Kind of guy. You know, I thought this morning that if you're over 70, you should be exempted from coming out in any weather that's below 30 degrees.
Good luck with that one.
I was looking for the exemption.
All right, so it sounds like Bruce is looking for something more universal. I'm gonna have to rewind it back a little bit because I kind of missed I missed a little bit of it. They started talking about him having another case that's in front of Judge McBurney, which were the actual charges that he acquired while he was in custody. And then this one was supposed to be the I thought it was the arraignment for here we go.
Okay.
Let them sign that.
Yeah. We'll get Mr. Harvey out.
Yeah, it's only the arraignment today, so it's only him coming in and making a plea on his issue. All right, so I've got an update from Kathy Roosen. She says we've muted the stream and are showing the seal while the judge handles other cases. And she mentions that YAK has not been called yet. And then we got Miss Sylvia out here letting us know that it's only arraignment today, which is what I thought too. Yeah. I didn't think that this was. Yeah. Here's the thing with the arraignment too. There's like not much that's really going to happen today. So it's not a bond hearing. So he's not going to get a bond. He has a probation revocation hearing in February. So I feel like that one really sets the tone for what's to happen next. Oh, per Thurgood Daily, the probation hearing was changed to today. So that would make sense on why Bruce said he's looking for a universal solution. That would make sense.
Why not take an Ambien, half an Ambien?
So a few times I have flown 4 hours. We've had flights in the evening, so it's just coming back in the morning.
That would make sense, y'all. All right, so they're not even on yet. So what I'm gonna do is run it back so we can actually hear what was discussed.
You ever watch Air Disasters on the Smithsonian Channel?
And I don't have to watch that. It's on the news.
It's pretty interesting.
All right, let me run it back so we can actually hear what.
Negatory.
All right. Okay.
Well, it would be ripe, but that's all it would be. We're still, well, we're talking.
All right.
Okay.
He's got multiple cases, Judge. He's got one in like Judge McBurney.
Right.
It's a more serious case. So I
Hey.
think we're potentially discussing
Girl.
how to resolve that if we can.
So the best way is status quo at this particular
So,
point?
so you're looking for a universal settlement?
Yes.
Okay. All right.
So may we do the arraignment in that fashion?
Sure.
Okay.
Yeah.
And Madam Clerk, may I get the paper?
Yes, you may.
Sorry to get you down here for nothing. Of course, I didn't have anything to do with getting. No, I'm talking about the cameraman.
I thought you were talking to me.
No. but it doesn't look like anything's going to happen with Mr. Kendrick's case today.
Trust me, they were coming anyway.
Are you working with Mr. Harvey?
Yes, sir.
What's your name?
Attorney Nicole Westmore.
Okay, Ms. Westmoreland. All right, nice to meet you.
She's the brains and beauty. I'm just the aging boy. It's cold out there kind of guy. You know, I thought this morning that if you're over 70, you should be exempted from coming out in any weather that's below 30 degrees.
Good luck with that one.
I was looking for
All right. So honestly, y'all, nothing is happening today. So if you, we're gonna have to wait to see what happens with YAK or if any other hearings are scheduled, if there will or will not be a camera, but nothing is gonna happen today. So this is pretty much the end, the beginning and the end of his arraignment hearing. So I don't know what to say at this point. Again, I just think that Bruce is trying to get it all. Yes, Morley is all over the place this morning, Cindy. I think Bruce is trying to get it all in one swat, one whoop. So again, nothing to see here today. So nothing is going to happen with this case today. No, ma'am. No, Miss J. Nothing is happening today. Nothing is happening today. So we are going to switch over to what we were watching on yesterday, which is the recusal for YNW Melly prosecutor, for the YNW Melly prosecutor. This is a rewatch. So we're just rewatching it. And I'll put up a banner to let everybody know if anybody popped in or basically just didn't hear the update, but nothing is happening today for YAK. So we'll get it swapped over. All right, Taylor Gang, let's get to it.
And I just get handed the file here. Go ahead and investigate this case.
Okay, so you subpoenaed Ms. Hagan for a investigative statement.
Correct.
And she missed the trap.
Correct. And when I say out of the norm, I don't mean that there's anything negative about that. I just mean that there are instances, like with maybe attorneys, we investigate attorneys and they aren't public officials. So it's really just on a case by case basis, and Mr. Killer makes those decisions with Ms. Falk and Mr. Pryor. And I just get handed the file, here, go ahead and investigate this case.
Okay, so you subpoenaed Ms. Hagan for a investigative statement,
Correct,
and she was the traffic judge.
correct. On the 7th floor of the state attorney's office.
Okay, and is it in a special room within the store?
There's a hallway in, when you get off the elevators on the 7th floor, and there's bathrooms there, and right before you make the right to go towards the bathrooms, there's a very small conference room.
Okay, can you estimate the size of this room?
I'm not very good at estimating, but I would say it's like a 6 by 6 room, but it's a small room.
So, what happened in that room? Let's start off.
So the first thing that happened is Detective Moretti and I were sitting on one side of the table. Ms. King and Mr. Trackman were sitting on the other side of the table. When we initially began the statement,
Have you ever met Detective Moretti before?
I have not met him before. Oh, excuse me, I met him the day before because we had a meeting about this case, but I hadn't worked cases with him in the past.
You had no ill will or goodwill about that?
I had really no information at all, other, than he was the detective that was investigating this tampering case, and no ill will, no history.
And I'm not looking for that. Haven't you with Ms. Bradley? Any problems with Ms. Bradley during the course of the 20 years you worked there?
No history with Ms. Bradley either. We've always been very cordial towards each other.
So let's go back. Now, you're there in this whole room. What happened?
So initially, Sergeant from Broward Sheriff's Office, Sergeant Hendricks, who I do know, was standing in the room. I didn't really think very much about it. I had approved the search warrant the day before. I didn't speak with Detective Moretti about when he was going to serve the search warrant. He was there. I didn't really think about it, and we started the statement. And then at that point, Sergeant Hendricks left the room.
Okay.
Once he left the room, the questioning.
Sustain. Ask a question.
After he left the room, what happened?
After he left the room, the statement continued. Detective Moretti asked most of the questions during the statement.
And as you said, they were not all just focusing on tampering, a lot of you in the murder case.
I remember at one point that we were talking, and Ms. King asked Mr. Detective Moretti why he was asking questions about her son's case. And he said something like, well, they're related in some way. And I tried to explain to her that some of the questions that there's, they were intertwined just because of the nature of the charge. It wasn't that she was tampering on a separate case. The allegation was that she was tampering with witnesses on Mr. Demon's case. So during the questioning, at a certain point in a lull, Detective Moretti made a decision that I was unaware of at the time to serve the search warrant.
That wasn't in your thought process at all that was happening during the time?
It wasn't, but I didn't tell him not to. We just didn't discuss it. It wasn't something that came up. I approved the search warrant. I assumed he would serve it that night, the next day. I really hadn't thought about it.
And who was in the room at that time?
During the service of the search warrant, it was Mr. Trackman, Ms. King, Detective Moretti, and myself.
Okay. Anybody from BSO?
No.
Okay. You said you described the room as being 6 by 6. Okay. If there was a BSO deputy in that room, could anybody miss that person?
Yeah, the room is so small that you could practically touch the person standing at the door.
So anyhow, what happens when he starts the search warrant?
Ms. King reached into her purse and she was fumbling with her phone.
Did you know what she was doing?
It's a phone, so she has this phone. I couldn't tell you what type of phone she had. She was pressing buttons on it. And Detective Moretti was saying over and over again, don't turn off that phone, don't turn off that phone. I knew she was doing something on her phone. I just couldn't swear to exactly what it was that she was doing on the phone. It looked like she was turning off her phone or sending a message or doing something on it. I just couldn't tell. There was a scuffle going on.
Okay, and what did Detective Moretti do?
Detective Moretti physically took the phone from her.
Okay, now, there was no BSO deputy in the room, correct?
Correct.
And this was BSO jurisdiction, the courthouse, correct?
Correct.
Okay. So Detective Moretti did not have the authority to serve that search warrant, correct?
I would always recommend that if you're not in your jurisdiction, that there's case law that suggests that you should have somebody from the jurisdiction that you're serving a search warrant or an arrest warrant in. I hadn't done that research for a long time. I just knew that it was probably not what he should have been doing without a BSO deputy there.
Okay. Do you know if his actions, and I have to know if his actions were lawful in taking that phone since he did not have the jurisdiction in the courthouse?
I can't reach that conclusion. I mean, I'm not a legal scholar. I would assume that if she had standing, if there were a case, that she would have grounds to file in good faith a motion to suppress. What a judge decided is up to the judge, not up to the state. So I would, if I had known about it, I would have said to him, you need to wait for PSO to get here. And it's always better to err on the side of caution than it is to create a situation.
So anyhow, the search warrant, she's fumbling with buttons on the phone. You're not sure exactly what she's pushing. What happened?
So I'm mimicking Detective Moretti, and I'm trying to calm everybody down. So I was like, you really need to give over your phone. It looks like you're trying to turn off your phone. You need to, it's a search warrant. And Mr. Trackman was very upset. And he did tell her she needed to give up the phone. And eventually Detective Moretti got the phone from her. He got the phone from her physically. He physically took it out of her hand.
During that, her giving the phone or having it taken from her, did you hear any exclamation from her that indicated that she had been hurt?
It was a yelp. It was like a yelp. It was like I can't really describe it any other way, but there was physical contact between Detective Moretti and Miss King. And during that physical contact of him taking the phone, Miss King, she yelped.
The physical contact was instituted by Detective Moretti, correct?
Correct.
During that physical contact, did he come in contact with anybody else?
I think he brushed up against Mr. Trackman. He definitely bumped him or brushed him or something. That was unintentional, though. I don't believe he did that intentionally.
What happened after he got the phone?
After he got the phone, Mr. Trackman and Miss King were both very upset. Miss King needed to call her employer, she said, and she asked if she could please have her phone to call her employer. Detective Moretti would not allow her to have her phone. I said that she could use my phone, and I asked to get the number, but he couldn't get into the phone, and that wasn't going to work out. So I tried to talk to Detective Moretti in front of Mr. Trackman and Miss King to see how long it would take him to do what he needed to do with her phone. And I don't remember what his exact words were, but he suggested that he would get it back to her as soon as possible, maybe even that day.
Okay. Do you know if he gave it back to her that day?
He did not.
Do you understand? I don't believe it's ever been given back.
I understand because I read Mr. Trackman's motion to return property.
So after he says he can give them back in the day, even maybe by the end of the day, what happens?
So at that point, I walk out. I can't recall if I called Mr. Killer in or I saw him in person because it was probably close to the lunch hour. And I told him, I said, listen, I can't work with Detective Moretti anymore.
I think you jumped ahead.
I did.
Because something happened after they left as far as another deputy coming up.
Oh, I'm sorry. Yes. So Deputy Gorell came in.
Let's just, Mr. Trackman and Ms. King leave.
They leave the room.
Okay, what happens?
Once they leave the room, Deputy Gorell, who I didn't know his name, he came into the room, and Detective Moretti looked at him and said, "You need to." Deputy Moretti said Detective Moretti said to Deputy Morell, "You need to say you were here when I served that search warrant." And it was kind of like an awkward moment. Someone described it just kind of getting punched twice in the head. So there's a search warrant that gets served, and I'm like, what's going on? And then the next thing, he's asking this deputy to lie for him. And again, I'm like, this is like, I'm in the twilight zone. Like, this can't really be happening. Deputy Gorell didn't say anything of any substance. I think he said, "Is there anything I'm needed for anymore?" or something like that. I don't remember if he said anything at all. It was just a very awkward moment after Detective Moretti said that to me.
And you specifically remember what was said?
I vividly remember what was said, yes.
So after that was said and after Gorell leaves, do you say anything to Moretti?
No, I don't say anything to Moretti. I leave the room. I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Why?
Because I don't work with detectives that solicit lies.
Okay, what did you do then?
I reported it immediately on that day
To whom?
to Mr. Pillar.
And Mr. Children is your immediate supervisor?
Correct.
And what happened then?
So the next day, after I reported it, I asked Mr. Pillar, and what did administration say about this?
Your Honor, this is not, I'm not asking for opinions on how they're going to try a case or anything like this. I'm asking for factual things, what occurred. It has nothing to do with the preparation of the case. It is not work product that is presented.
That's factual knowledge. And all that is presented at this point, because at least it's always going forward. And anything that you write, you can find any possible privilege or work product writing that available in case closed. Well, oral testimony, never. is allowed for services or product or investigated the inside workings of the office.
How is a complaint that an officer lied and what should be done as far as investigating an officer that lied? How is that work product in this case?
We're going back to Brady.
Anything else?
This is simply facts, and that is discoverable. I'm not asking for your opinions, your theories, or anything like that. Just facts about her.
Hold on. Anything else?
This is what I was trying to report about, we're moving out of the realm of motion to hear on that. On the office. Into the Brady, version of Brady.
I want to know if you want any further argument on this issue right now.
On the issue of,
I know. Thank you. Objection sustained. Action next question.
Okay. So I'm correct, you asked, you spoke to Mr. Killeran. Mr. Killeran talked to administration. That's where you get sustainable, correct?
I sustained the last question, so I don't want to recap. You just ask your next question.
Do you know who Mr. Killeran spoke with?
Yes, he spoke with Mr. Pryor and Ms. Falk.
Okay. Did he relate to you that he had spoken with?
Yes,
And did he relate to you that the substance of the conversation was what you had told him?
he,
Sustained.
Sir, I'm not offering this to you.
I sustained the objection. Ask your next question.
Did you talk?
what I did at that point when I hadn't heard anything back as to the information that I relayed to Mr. Killeran is I called the meeting.
Okay.
I asked Chris to set up a meeting with Mr. Pryor and him and Ms. Falk.
Okay, when was this?
The meeting took place on October 18th, 2022. I
And
apologize.
the event that occurred as far as the lying and whatnot, that was on the 12th.
Correct, October 12th, 2022.
Talking weeks later.
It was a Monday or Tuesday.
So you set up the meeting.
I asked for a meeting. I don't set it up. I say, Chris, I need to speak to the administration about this. Can you please set up a meeting?
And was the meeting set up?
It was.
And were you able to speak to whom? That?
I spoke to Ms. Falk, Mr. Pryor, and Mr. Killeran.
And you told them what you told the board.
We're going to change the earlier that now we're starting to get into the investigators and portions of the office. And also it's a leading question. And one, you go right into that area where now we're going to turn to work product, investigative information. That is why the case law that was in the motion today, referring to says if this is allowed to go, if these kind of questions are allowed to go on, which is from a state attorney's office, it's going to bring the whole office down to the wall. They always have to find someone have to be there, why they do what they do, what kind of investigations they do, and of course it said in the case of in the motion today, even it's not permissible.
My understanding, counsel, is that Ms. Boutros was deposed, there was no objection by the state attorney's office as to her deposition being taken. There was no issue, any work product issue as to Ms. Boutros had been waived. She was presented for deposition, and she had an attorney there with her. Ms. Huffman was there for the deposition, and she answered questions. There was no objection at the time. This is just an extension of that. As far as the what she did, and I don't want to say she, I'm talking about Ms. Boutros, but she did or she said, the objection notice overruled. She can answer that question. Not so much what Mr. Killeran did or said, or not what Mr. Pryor did or said, but that's what you did and what you said. I'm overruling the objection.
So for the 20th, and you're having this meeting.
Yes,
Okay. And at this meeting, did you voice again what occurred in front of you?
I described exactly what happened as I described it today.
Okay. And without going into what was said to you, when you got done with the meeting, did you have an impression of what was going to occur?
No, I didn't have an impression until probably 2 days later.
Okay, what happened 2 days later?
I learned that Ms. Bradley told administration that already told her that he was joking when he said what he said.
Sustained.
You heard that Ms. Bradley gave another statement to the administration.
I heard,
You correct. I sustained that objection. Ask
I
me
did not
that
ask
question.
I did not ask what the substance of it was.
I sustain the objection. Ask the next question.
What did you do next?
I didn't do anything next. After I had the meeting with Mr. Killeran and he relayed to me what he relayed to me about what Ms. Bradley had told administration, my assumption was that it was handled.
Okay, and this was when?
This was probably the same week.
So we're talking October, maybe towards the beginning of November, whatever, but October probably of 2020.
It was just a few days before he told me.
And that was the end of your involvement?
Correct. Until I believe it was that the defense filed a motion trying to compel my name and the, oh, I'm sorry.
I didn't hear that. I'm sorry.
I apologize. I misspoke anyway. The next thing that happened was that I got a message that Internal Affairs in Miramar wanted to take my statement.
Okay, and what did you do when you got that message?
I called Mr. Killeran. I said, I got a request to give a statement to Internal Affairs. Please ask Mr. Pryor if I'm permitted to do so. And I subsequently gave the statement to IA.
Okay. And then what happened next for your involvement?
I gave my statement to IA and nothing really happened until the defense filed a motion. I believe it was the motion to compel my name for the investigation. And if I could refer to my notes.
That's going to help you refresh your recollection?
Yes.
Go ahead. Counsel, you want to restate your question? Refresh your recollection.
Sometime prior to November 18th, maybe a few days before, and I don't have the pleadings in front of me, I learned that there was a motion to compel my name. I revisited this conversation with Mr. Killer, and I'm like, well, what happened with that? And he didn't know. I'm like, talk to the administration, what happened with that? And I'm kind of a pest, so I kind of kept on it. And then there was a hearing on September 15th of 2023, and I saw Ms. Bradley announce on the record that the IA investigation had been closed.
You know it had been closed?
I did not know.
Okay.
Again, I gave my statement and I was kind of done. So I was out of it.
Okay. And when you heard that, what did that cause you to do?
I kept bringing it up to Mr. Killer, and I was pissed about it. Like, there's zero notice. I kept checking on safes like 100 times to see if a notice had been filed, because we did have a meeting after it was closed, again, with Mr. Pryor, Mr. Killer, and myself. Ms. Falk wasn't present at that meeting. And during that meeting, I said, I really feel like this needs to be disclosed. And Mr. Pryor agreed with me.
Sustain.
You wrote that it needed to be disclosed.
Yes.
And this is after you got the word that the IA had completed sometime in July of 2023. So this was somewhere.
Sustain. Counsel, just ask a question, all right?
When was this?
This was on the meeting was on the 18th. It was on the 18th of September 2023.
Okay.
I had began back before then, kind of looking into it.
There's no question pending. Ask your next question.
Did you do anything before that?
I learned that a video was pulled from BSO and given to Internal Affairs. And I learned that Ms. Bradley called Internal Affairs.
Sustain.
Okay. I'm not going to ask you what Ms. Bradley's.
Okay.
So you learned that. What did you do next?
Well, that's when I started bringing it up again. I started bringing up, what's going on with this case? What's going on with, who knows about what happened with Detective Moretti?
Okay. And who were you bringing this up with?
Mr. Killer.
And were you getting answers or did you not know?
He was trying.
Sustain.
I was asking Mr. Killer
Excuse me. I sustain the objection. Ask another question.
What else did you say to Mr. Killer?
that I wanted to have another meeting with administration.
And was that arranged?
That was the meeting on September 18th, 2023.
And at that meeting, you said,
I said, this is what happened again. And I said, you were told this by Ms. Bradley back in October of 2022.
Excuse me, what's the objection? Here's what you saying to Bradley. Thank you. Any objection noted? Overruled. You can proceed.
I reminded Mr. Pryor that this had happened, that she had explained that Moretti said it, but he was joking back in October of 2022. And at that point, we all agreed there was going to be a notice sent.
You reminded Mr. Pryor.
Yes. Not that he had forgotten, I was like, this is what was said, he said it, and Christine said he said it, but he was joking.
Okay, as far as this joking, obviously, you don't know exactly what was in the mind of Detective Moretti.
No,
when you said it.
I do not.
But were there any overt signs that you saw of joking? Meaning he laughed, he chuckled, he winked, or anything?
No.
You took it as a true statement.
Correct.
So after this meeting, were you reminded Mr. Pryor of the meeting a year or so earlier? What happened then? Or your father?
There was a meeting between Mr. Pryor, Mr. Killoran, and Ms. Falk, where Christine was asked again.
Excuse me, were you present at the meeting?
I was not.
All right, so I want you to talk about what you did, what your involvement. I don't want you to go forward with other things, all right?
Did something happen, or did you do something after they had a meeting?
Mr. Killoran drafted a draft of a Brady notice after that meeting.
Okay. Did you see that?
I did. It was sent to me via email.
Okay. And what happened with that draft?
That draft was not filed.
Let me ask you, why would the head of the Public Corruptions Unit be filing a Brady notice in this sort of case?
Again, she can't see for what Mr. Killoran was doing, can't see why he was doing it. Also, there you go again, we're going to the issue of false policy.
Thank you. The objection sustained. Could we just have a clarification as to what date we're talking about, to council?
What date we're talking?
The draft?
Yes.
May I refer to my notes?
Just going to refresh your recollection.
September 20th, 2023, Mr. Killoran sent me a draft of the proposed Brady notice that was to be signed by Christine Bradley with her name on it.
Okay, and what happened with that Brady?
Mr. Killoran delivered it to Ms. Bradley's secretary, Anna, and she was told to sign it and file it, and it was not.
She being Ms. Bradley?
Correct.
Did Ms. Bradley sign it?
No.
What happened with that?
Nothing happened with that notice. No notice was filed at that time.
What happened next?
The next thing that happened was that a Brady notice was filed. And I'm sorry. The next thing that happened is Mr. Benjamin called me. And that was on Friday. May I refresh my recollection with my notes?
Yes, you may.
Nine 22-23.
Without going into what Mr. Benjamin said to you, what did you do in relation to that?
I asked for permission to speak with Mr. Benjamin. I sent a text message to Mr. Pryor and to Mr. Killoran. And then Mr. Killoran called me.
You know what they said, or they texted back. Only what you do.
Thank you. I sustained the objection. I don't want to know what you were advised by the administration, but as far as what you did or what happened next that you were involved with, you're more than welcome to answer the question.
Upon Mr. Killoran returning my phone call, I returned Mr. Benjamin's phone call, and I discussed with him what had happened on the October 12th statement and everything thereafter.
What did you tell Mr. Benjamin?
I told Mr. Benjamin about the incident on the 12th. I told Mr. Benjamin about the discussions related to whether Moretti said it was joking. I told Mr. Benjamin that Ms. Bradley had said to administration.
She is saying that she told me that.
Thank you. Objection, no, it's overruled. You can answer the question. Is what you said or did. Go ahead.
I told Mr. Benjamin that I had reported it to Mr. Killeran, that he had reported it to administration, that administration had called in Ms. Bradley, that Ms. Bradley said that Moretti said it, but he was joking. I told Mr. Benjamin that a motion to return the phone had been filed in November of 22 and heard in December or February of 23. That I told him that I saw the hearing where the IA investigation had been closed. I told him that a video had been pulled and discussions had been had with internal affairs, with Ms. Bradley and Sergeant Brittany Parker that I heard, and that I don't know for a fact. I told him that the administration brought Ms. Bradley in again and asked her again.
Is it later out? What do you think here today? By being allowed to do it? The same, just giving out the
Your Honor, may I respond? Your Honor, the list of these objections, and I've done my best to abide by these court's rulings, I think I have. But we're losing track of where we're going. And the bottom line of this is through our motions, we are not only accusing Ms. Bradley of needing to be reduced, but the entire state attorney's office needs to be reduced. And part of that is to show institutional prejudice or institutional action. So the things that you have not permitted us to go into as to what did the administration do and whatnot, that goes directly to whether or not we have the administration, the state attorney's office actively involved in suppressing this information or turning a blind eye on it to allow Ms. Bradley to get away with Brady violations and violations of my client's 14th Amendment rights and 6th Amendment rights. And we're losing sight of that. We have the right to go into what did administration know, what did they say, when did they know it, when did they say it, and what did they do. That's the only way that we can show institutional prejudice.
Thank you. Counsel, the objection was pending as to what she advised in this conversation with your co-counsel, Mr. Benjamin, and that objection will proceed.
Did you tell Mr. Benjamin about the various meetings that had taken place as far as with you and members of the administration?
I did. There were several discussions between me and Mr. Killeran. I explained to him that I had spoken to Mr. Killeran about whether a notice had been sent. I explained that I had spoken to our appellate division, that that you wanted to depose me, and that we had further discussed whether this needed to be disclosed. I explained that Mr. Pryor and Ms. Falk summoned Ms. Bradley to come into their office. They, with Mr. Killeran and Mr. Pryor, specifically asked her again, who told you that Moretti was joking?
My objection, and I was also, counsel was talking about institutionality. None of that in his motion we are hearing today. He's on the outside four corners of the motion they filed you are hearing today. It is completely insufficient. The hearing, I have the hearing ends, and they file that amended motion for the state not to be ambushed by what this line. Their mention today is totally insufficient. It doesn't meet any requirements necessary to keep the office. If they want to file an amended motion so the state not ambushed, and then continue the hearing, that would be the problem. So we do not have a problem.
Counsel, my understanding is that the state attorney's office allowed Ms. Kruger to give a deposition, and she was opposed to that matters, and it was discussed. There's no claim of privilege or work product or anything like that, because she testified it, and the way I understood the deposition, she testified it with the knowledge and consent of the administration that she was permitted to do that. So your objection noted is overruled. Counsel, you may proceed.
I was just finishing up with what else you would have told Mr. Benjamin.
So I went through my notes, basically.
Mr. Trackman, I don't know what you're doing here. I don't know if you're a witness in this case, but they've asked to have the rule of sequestration imposed. I don't know if you're a witness. If you are, you need to step outside.
We will not be calling.
My understanding was, Your Honor, that I was not listed as a witness.
Thank you, sir.
Thank you, Your Honor.
I think I had a question that you about to answer, not my question, but.
So I basically went through the sequence of events with Mr. Benjamin. I went through the sequence of events with Mr. Benjamin. So the last thing I was telling you is that Mr. Pryor asked Mr. Benjamin.
Excuse me, I don't want to know what Mr. Pryor asked Mr. Benjamin unless this is part of the conversation that you advised Mr. Benjamin.
It was, I told Mr. Benjamin that upon hearing what was going on, they resummoned Christine into the office and asked her again, who told you that Moretti said he was joking? And she said, Moretti did. And then I told Mr. Benjamin that later that day, that was at the time that, and I might be getting my dates mixed up, but that Christine sent a text message to Ms. Falk that stated that she never said,
You're lying. Yeah. Thank objections, no, it's over, proceed.
she never said that it was Moretti, and I didn't see the text message, but I told him that she said that it was Burrell that said it.
Okay, so if I'm understanding, you're telling Mr. Benjamin that originally she said it was Detective Moretti said it was a joke, and then she later on changed it to Deputy Gorell that said it was a joke.
Yes, I told Mr. Benjamin that she told administration and Mr. Killoran that it was Detective Moretti in September of 23. I told Mr. Benjamin that back in October of 22, she told administration that it was Moretti and that he was joking. I told Mr. Benjamin that my statement to IA included that Ms. Bradley had said that it was Moretti and he was joking to my administration. After that, I don't think anything had happened after the conversation with Mr. Benjamin. The next thing that happened was that I received the Brady notice that Mr. Benjamin sent me on the 24th of September of 23.
Okay, are we up to where Mr. Deputy Gorell is mentioned?
That's the first Brady notice that I received that Mr. Benjamin forwarded to me on Sunday, the 24th of September, 2023. That included a copy of the Brady notice that had been filed.
And what day was that Brady notice?
It was September 23rd, 2023. Yes.
You said that Mr. Benjamin sent you an email along with an attachment,
Correct.
and that was on the joining of this one.
Correct.
And with that attachment was a copy of the Brady notice.
Correct.
Let me show you what's been marked as Defense Exhibit G. Identification.
I recognize this.
You do, but you recognize this as
It's a notice pursuant to Rule 3.220B4, signed by Christine Bradley on the 23rd of September, 2023.
is that a copy of what Mr. Benjamin sent you?
I have to read it. Correct. This is what Mr. Benjamin sent. Yes, it is.
Your Honor, this time I'd like to have the evidence of Defense Exhibit 1.
Objection? Want to give the clerk a note, Mark? Want to give the clerk a mark?
Mr. Bouchos, in the defense's exhibit 1, which you have looked at, it states, the undersigned spoke with Detective Moretti.
What's the objection?
These are referred to the court while they are busy.
Thank you. Objection noted. Sustained. Counsel, we don't need to publish that. I've read it. I got a copy of it. Proceed. Ask your next question.
Your Honor, then with all due respect to the court, can I assume that every exhibit that we have filed is now going to be considered as part of the record for this motion?
Whatever's admitted will be part of the record.
Well,
So far you've admitted, my understanding is one, is that correct?
all right, but you're saying that you reviewed other stuff and that's.
No, I've reviewed the notices. All I'm saying is I've reviewed the Brady notice.
Okay. I can still ask the question related.
Sure you can.
Okay.
I just didn't want you to read the whole notice.
No, I'm reading the last line of it, actually. Okay. It says here, the undersigned spoke with Detective Moretti in regards to this incident, and Detective Moretti said he asked Deputy Worrell if Deputy Worrell was there when the phone was seized. Deputy Worrell responded something to the effect of, I can be if you need me to be. Did that occur?
No, it did not.
Okay. And as far as Detective Moretti asking if Deputy Worrell, if he was there when the phone was seized, the room, as you said, was small enough that he would know that he was there or not, correct?
I can't testify as to what Detective Moretti knew, but it would, in my opinion, it would be impossible not to know if somebody was in that room.
Well, you'd expect the lead investigator on the first degree murder case to be able to see who's in the room of 6 months.
Don't argue with the witness, counsel. Counsel sustained. Don't argue with it.
Okay, so Mr. Benjamin, did you talk about this after?
I responded to Mr. Benjamin and explained that that was not accurate. I actually blind copied Mr. Pryor, Ms. Falk, and Mr. Killeran on that email. And I reiterated what I told him during that conversation.
Okay, and you copied them.
I did.
Did they respond to you
No.
without saying what they responded?
They didn't.
What happened next in the course you were involved in?
Can I look at my notes to refresh my recollection?
The refresh my recollection she made.
I asked Mr. Killeran Monday morning, the 25th, or Tuesday morning, I think the 25th was a holiday.
It was a Saturday.
It was.
22nd, you said it was Friday, so that's right. The 23rd was like Saturday.
So I might be mixing up my dates. Maybe the 24th is when Mr. Benjamin sent me the email.
That'd be Sunday.
Okay, so he sent it to me on a Sunday, but Monday was a holiday, I believe, that Monday. Maybe it wasn't. I don't remember. I know the next thing that did was the beginning of that next week. I asked Mr. Killeran, what is this and why was this filed? Because no one had responded me to this Brady notice.
Whether we just walked in there.
Yes,
Okay. And you asked what this was.
yes. And I requested the emails that went back and forth that resulted in that Brady notice from the night of the 22nd of September, 2023. I requested on email.
Did you get that?
I did.
And did that explain to you how this notice went out?
No. The emails that I reviewed were directions that that should not be filed because it was inaccurate.
Now, no longer testifying what she told me. She's telling what the year is inside.
Thank you. Objection sustained.
Okay. What happened next? What did you do?
I'm refreshing my recollection again. I received a call on 9/26/23 from Mr. Pryor.
Okay. And relating to this incident.
Correct.
What did you do in relation to that call? Did you meet with somebody?
No, I didn't. He just called me.
And you spoke about it without going into what
Correct.
said, if this was discussed with Mr. Pryor?
That's correct.
What happened then?
They asked me to join a meeting with them at 3:30 p.m. on September 26th, 23.
Did you go to that meeting?
I did.
And what did you say at that meeting?
We just discussed that there was going to be a new Brady notice.
Sustained.
I was just asking what you said. If you don't remember specifically what you said, then
I asked if a new Brady notice was going to go out to correct the one that was sent out on the 24th or the 23rd of September.
I'm sorry, I'm not, that's hearing.
So I wanted there to be a correction to the Brady notice that was sent out by Ms. Bradley on the 23rd or the 24th of September.
That is what you voiced.
Yes.
And what occurred after?
They requested another meeting on the 27th of 2023 at 9 a.m. in the morning.
Were you there?
I was.
Without going to what other people said, did you say anything?
Yes, I did. I suggested that Ms. Bradley probably shouldn't be calling me a liar in this situation because I had learned that she had done that the day before in front of a group of people in the office.
Did you say you were lying?
Yes.
Anything else that you said that time?
No. I mean, other than there was a Brady notice in between that time. So there was a new Brady notice. We discussed that.
Is that the one that Mr. Killer said?
Yes, that was on the 26th of September, 2023.
I'm gonna have to drive you crazy today, because I'm not this one. And just because you said that on the 27th, whatever it was, you had a meeting, and in between that time, there had been another Brady notice.
Correct.
Did you ever see that Brady?
I did.
And who signed that Brady?
Mr. Killeran.
Let me show you what the department has evidence exhibit that to identification.
Yes.
Do you recognize?
I recognize this. It's a Brady notice, amended notice pursuant to Rule 3.220B4, signed by Mr. Killeran.
And is it an exact copy of what you had seen previously?
It is.
Your Honor, I'd like to move this into evidence.
Admitted. Present to the court, please. No marking.
It's- yeah. Now, in this notice, go to the last paragraph. It says the lead ASA assigned to this matter related to SAO administrator that she spoke with Detective Moretti in regards to this incident, and Detective Moretti explained that his statement to Deputy Gorell was a joke. The lead ASA subsequently filed a Brady notice with the court on September 23rd, 2023, which stated that Detective Moretti told her that Detective Moretti asked Deputy Gorell if Deputy Gorell was there when the phone was seized, and Deputy Gorell responded something to the effect of, "I can be if you need me to do." Again, that did not occur. Yes, before.
Counsel, can you restate the date on that Brady notice, please?
The Brady notice is the 26th of September 2023.
Proceed.
Then the last part of that says, additionally, the lead ASA relayed to a state attorney office administrator that the deputy was the one trying to be funny. Was Deputy Gorell trying to be funny?
No.
Did you even hear him say anything that?
No.
Okay. Do you know if Deputy Gorell was ever contacted?
I don't know.
Would it be up to Ms. Bradley to contact Deputy Gorell?
I don't believe so. He's not a witness on her case.
Okay, so if she went out and she contacted Deputy Gorell to appear with Detective Moretti, that would not be false policy.
I don't really.
What's the question? What's the objection? Sustained.
As a homicide prosecutor, would it be a homicide prosecutor's job to speak with a witness that deals with a tampering investigation as far as whether another witness lied?
I'm not really sure what you mean. Are you asking me if Ms. Bradley would have normally contacted Detective or Deputy Gorell to see if?
Yes, is that normal?
I can't say that that's normal or not normal. I mean, that's a different crime, a different investigation.
What happened next?
You took my deposition on Friday last week.
Well, did another Brady notice come out?
Oh, yes, I apologize. So the next thing that happened was that during that deposition that you took of me last Friday, you showed me a copy of the Brady notice that was filed on the 28th. I hadn't seen that prior to our deposition.
Okay. Were you expecting another Brady notice to be filed?
I was,
Okay, why is that?
because that's what I was told that was going to happen,
And
against the wishes of administration.
The same.
let me show you what has been marked as defense speech. Do you recognize this?
I do.
What is it?
It's a copy of a second amended notice pursuant to Rule 3.220 before signed by Ms. Bradley on the 28th day of September 2023.
And that had been presented to you prior to your deposition.
You know, you presented it to me during my deposition, or Mr. Benjamin did. Somebody presented it to me during my deposition.
And this is, and the testimony in your deposition reflects some of the things that are in this document.
Correct.
Your Honor, I'd like to move this to heaven.
Suggestion? What you have, sorry. It's admitted.
Now, in this one, I'll just read the last part of it. It says, the undersigned inaccurately relayed to the state attorney SAO administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Burrell was a joke, when she intended to relay that which is contained in the Brady notice filed on September 23rd, 2023. Additionally, the undersigned relayed to a state attorney administrator that the deputy was one trying to be funny. Is this accurate, this Brady notice, as far as what you know facts do?
No, but I don't see that as a fact notice. It's her saying she accidentally said something.
Just accidentally saying something, or Detective Moretti saying it was a joke, or not saying it was a joke, or whatever. How many times did you hear her say that she spoke to Detective Moretti?
Did I personally hear her say?
Yeah.
I didn't ever hear her personally say
So
that.
that was all through administration.
It was all through administration and through Mr. Killeran's Brady notice, and I heard it through Chris Killeran and Mr. Pryor, and that's how I heard it. I haven't spoken to Ms. Bradley about this case since October of 2022.
Did you do anything else in this case after you gave us the deposition?
No.
There are 92 seconds to speak with that.
Yes.
Just real brief, I promise. You said that there were emails that were going back and forth through the office starting in July of 2020, October 2022, dealing with this issue Brady.
I don't know if there were emails that went back and forth between administration and Chris. I wouldn't know. I wouldn't have been included on those emails. There were emails that went on over the last month or so related to this issue, but I don't know what was sent back and forth.
How about text messages?
not with me. I wasn't part of any of those text messages if they existed.
Thank you so much.
Thank you.
Any questions?
Very, very, very. One. Well, I know this didn't happen. I just want to clarify, I did on direct, you said that the investigation you were working on, one was there, tracking, and I believe
Right.
was completely separate from murder.
That's not what I testified to. It was supposed to be, but that's not how it turned out.
But was that evidence of murder or the murder trial? Evidence of the murder trial, I mean, how did that investigation? This is the investigation of the case, why the search was on. Okay.
So I think that I'm not understanding your question. I'm not trying to be evasive.
Restate your question.
On to clarify, the investigation or which we're working on.
The tampering of Ms. King, okay?
Part of the murder case, or was it separate?
Well, it would have been a separate charge because Ms. King isn't a suspect or being accused of the homicide case, but the evidence itself could have been admitted if she and Mr. Demons had been tampering, if that's how Ms. Bradley decided to try her case. It depends on the circumstances. That's a strategic decision, and I wouldn't be able to answer that question. If something came out of that deposition or that statement that somehow was describing that Ms. King and Mr. Demons had paid one of the witnesses or something, I would assume it would be part of the murder trial to show that they were tampering and consciousness of guilt. But that again I'm not very familiar with all the facts and circumstances of the actual homicide, so I can't really answer that question. But I think I said that it was a separate crime. Is that what you're referring to? That's not what I was talking about when I said that.
And I've been reading so much, but it's also unclear about mentioned carefully, Mr. Trackman, stated that definitely to.
I spoke to Mr. Trackman at the time. I don't remember everything I told him. I told him about the deputy not being in the room and that I thought that was an issue. I apologized to him for how everything went down. I don't know if I told him what Moretti's statement was because I had reported that to administration and to Chris. But I wanted to make sure he understood where I stood on the service of the search warrant. But I did speak with him.
And it was short. You remember how long?
It must have been the same day, maybe the next day, but this is back in October of 22. So I know that the first thing was to report it to my supervisors. The next thing was for me to report it to the attorney that I was working with that had his client's phone seized at the time. So that's correct.
Excuse. Thank you. You may sit down. You're excused.
Thank you.
It's now 12 o'clock. We'll see everybody back at, let's say, 1:15. All right. Thank you. Have a nice one.
May I be excused for the day, Your Honor?
Thank you. Talk about that. During July 10th.
I mean, people switch attorneys all the time, so I don't. I get it, but
the BSO deputy's report. The only thing that mentioned any conversation between the two of them was in the BSO deputy's report.
Now, did you ever reach out to Deputy Gore?
I did not. He actually approached me for the first time last week.
Okay. And what did he tell you?
That the recollection and whatever he said at that time, that there was no request for anyone to lie or anything to that nature.
But, okay, let's go back to it. So, Detective Moretti, you know that Ms. Boutros is never going to work with Detective Moretti again and call him slimy and untrustworthy.
Correct.
Sustain. Rephrase your question.
When you find that out, you talk to Detective Moretti, correct? You just focus.
I asked him to write a report. I did not speak anything about what Ms. Boutros said to me or anything of that nature.
Okay. what's the next thing you do on this as far as this statement?
In terms of after his report is issued,
Well, as far as the incident that occurred in which Ms. Boutros is claiming that he was soliciting Deputy Garl to lie, what's the next thing that you do after, I guess it's 5 days later, 7 days later after this occurs? You talk to Brady, what happens next?
after I got his report and made no indication about any request to lie or to have BSO say that they were there when they were not, I at some point reviewed parts of the statement. I had requested copies of, in the sheriff's office to preserve any and all surveillance that existed to see on timeframes as to anything that had happened.
Did you talk to Ms. Boutros about it?
No, the only conversation I had with her was on October 17th when she called me. She does not come into the office on a regular basis. It's my understanding she works remotely.
Okay. So you never questioned Detective Morgan already as far as what he actually said on that statement, or did you question him at some later date?
At some later date, I couldn't tell you exactly when.
Can you give us a rough estimate?
I could not.
Was it before or after the last trial?
Before.
And do you know who was around when the internal affairs investigation was over? Before that?
It was before that.
Did you have any input in the internal affairs investigation?
None at all. In fact, I only became aware of it when Mr. Edelstein told me that it was ongoing.
You didn't talk to the AI sergeant?
IA sergeant, perhaps you mean?
Whatever.
So once I became aware that there was an investigation, I contacted the Miramar Police Department to find out the status of the complaint, because it's my understanding it was never elevated to an actual investigation because they found it without merit. And I said, I have a copy of the surveillance footage from that. If there's anything that you need and I can provide, I'd be happy to do so.
Now, you did say that you spoke to Detective Moretti prior to the IA report being concluded.
Yes.
And you don't know exactly when, but you know it was before.
That's correct.
Okay. And the subject of that conversation dealt with the allegations against him as far as trying to get Deputy Garl to lie.
Yes.
Okay. Tell me about that conversation.
The best record of what was said is what was filed in the, I believe, September 23rd, Brady notice, in which is the first one that I filed that I drafted on with regards to what was said.
Okay, so the IA investigation is done basically around July 20th of 2022.
I don't know the dates on that one, my apologies. I was not expecting to testify today, so I didn't review.
Is it a fair statement to say numerous months went by between the time you talked to Detective Moretti and you issued that Brady notice that you said on September 23rd?
That is correct.
Okay, do you know how many months?
I do not.
Did the trial go on in between those two times, between your first trial?
It did.
Excuse me?
It did.
Okay, so you had talked to Moretti about the allegations of his trying to get a deputy to lie prior to the first trial, but you did not reveal that in any Brady notice, did you?
So the discussions were that he denied that any such conversation took place, that no such event happened. Again, I'm paraphrasing on this one, but he stated that the deputy showed up, he didn't even know who it was, and the deputy was lost. So there was about 5 or 6 minutes in between when the sergeant had left before the deputy showed up. At that point, when the deputy showed up, Detective Moretti asked him something to the effect of, were you outside when this all happened?
Outside?
Yes, when this all happened. Detective Grell replied something to the effect of, I can be if you needed me to. Basically, Detective Grell, if you reviewed the surveillance footage, went to the wrong conference room and was on his phone wandering about the 7th floor trying to find him.
That was all well and good, but my question really is, you had a discussion with him that he was being accused of trying to get an officer to lie. This was months before the first trial.
This was at some point, I would say, before April of 2023, yes.
Okay, and then I said you did not turn that over to the defense and you started going to what Moretti said. But you also had, didn't you, a statement by a fellow prosecutor who'd been prosecuting for 20 years plus that said Moretti did say he's leading at the time.
And all these arguments, the area that they're close to.
Thank you. Counsel, I don't want you to argue with the witness. You're just giving a recitation of facts and demanding in some way she agreed with it. I don't mind you asking questions about it, but I don't want you to be arguing with it, all right? Restate it.
When you spoke to Detective Moretti, and we're talking about the conversation that you actually finally had with him prior to the first trial.
Yes.
Did you let him know that there were allegations made by Ms. Boutros and what they were?
Yes, because I asked him if there was any validity to it. I asked him if there was any validity,
Okay.
and that was his response.
And his response is what you just had told us about?
That's correct.
Okay. Did you speak to Ms. Boudreaux's staffing?
No.
But based upon Detective Moretti's representation to you, you decided not to file Brady notice. Is that fair statement?
No, based on Detective Moretti's statement, Deputy Burrell's report that also denied any such thing as had.
Their reports don't jive though. Doesn't Detective Moretti say it was a joke and Detective Burrell say it didn't occur?
Deputy Burrell says he was told he was not needed in his report. Detective Moretti doesn't mention anything about BSO assisting.
So you decided not to send out a Brady notice disregarding what a fellow prosecutor said that she heard and took the word of the deputies. Is that fair?
Objection, Your Honor, now. Going into the reasons why she's making decisions in her case. And that's clearly not allowed.
Sustain.
It is a fact though that you did have a fellow prosecutor who did say this did occur, correct?
Yes, and said fellow prosecutor also did not request any police reports to be done or do any additional documentation if something had happened to immediately follow up on such event if it had occurred.
Did there come a time when you did issue the Brady notice?
The first Brady notice that was filed in this case, I believe, was in February of 2023 with regards to Miss King being under investigation.
Okay, and then let's get to the Brady notices that really deal with this issue here. There was one that you issued on the 23rd of September, correct?
I'd have to look at it to know exactly which one you're speaking about.
I'm going to show you the Brady evidence as Defense Exhibit 1.
Thank you, sir. Yes,
Okay, you recognize that?
I do.
What is it?
This is the Brady notice that I drafted that is an accurate statement of what happened.
Okay, why was this sent out in September of 2023?
Mr. Judge, I am going to, or any of the work on it, and asking her why she did what she did related to the case.
Thank you, Sustain.
You sent this out in September of 2023. In fact, September 23rd of 2023, correct?
That's correct.
Okay. Was there more that you learned about this incident between the time you spoke to Detective Moretti and September 23rd?
Could you clarify what you mean by
When
that?
you spoke to Detective Moretti, we don't know when, but we know this before the first trial.
Yes.
And he told you that it was a joke, and then you looked at Burrell's report, the whole thing like that. And then it's in September 23rd of 2023, you filed this Brady notice.
Yes.
So I'm asking you, what transpired between the time you talked to Moretti and the time you filed this Brady notice?
I reviewed the contents of the statement again on that. That was the most recent thing I did before filing that particular Brady notice.
The contents of whose statement?
Ms. King's statement with regards to the witness tampering.
Okay, but there was nothing about the lying incident in there.
No, there was not.
So how did that change as far as your filing Brady in September, as opposed to what you knew back when you talked to Moretti, whether it was January, February, whatever, of 2022?
In terms of what I had learned from conversations with other people in the office, is that what you're asking?
I'm asking you, what changed that you talked to Moretti in, let's just say, the spring of 2023? You talked to him then, you learned his side of it, you checked with on Burrell's report, and then no Brady is filed. And I'm asking you, what changed until September 23rd, 2023?
I was not
changed.
a party to any of the meetings or anything that Ms. Boudreaux had, so I couldn't tell you on that.
As far as you're concerned, what changed?
In terms of filing,
You don't give the Brady notice before the first trial. You give one now in September 23rd. What changed in that period of time?
Her legal thinking, and
But you can answer that.
Excuse me. Hang on, go ahead.
What changed?
in terms of there was additional discussions and conversations among the attorneys in the office.
Okay. And who were these conversations with?
I'm going to it's going to proceed in the office now, drafting those procedures and keeping about the case, a case or any case. That's all privileged or fine.
Thanks. Mr. Speaker.
Yes, Your Honor. First of all, the only question was who she met with or who she talked to. I didn't even ask the substance of the conversation. Secondly, if I was to ask that, the bottom line of it is, this is not work product that is not discoverable. This is work product that is discoverable. And if you like, I'll go into that argument.
Go ahead.
Your Honor, first of all, I'll cite to the court the case of State versus Raven. It's 495 Southern Second 257, 1986.
Sorry, one more time, 495 Southern Second.
495 Southern Second 257, 1986. It's a third DCA case. I'm going to be honest with the court and tell the court there's very little law as far as what's in the direct on fact versus opinion, type of evidence and whatnot. So I'm not going to tell the court there's a stream of case law. I'm going to just explain what it is.
Do you have a copy of that case?
I'm sure we have others floating around here, so let me give you this.
Copy. Thank you. You have that site, Council?
We have a case on.
The one I have just has some highlights underneath it, underlined. Any objection to that?
No. As you see on page 4 of what we were given, work product can be divided into 2 categories. Factual product, factual information which pertains to the client's case and is prepared or gathered in connection therewith. This is an investigation dealing with whether or not a witness lied and whether or not that witness is suitable to basically testify in court, and much to be done as far as Brady. This was not done in preparation of their case.
Thank you. Yes, sir. I'm sorry, what Council said.
Factual product is subject to upon the showing of need and undue hardship, while opinion work product is protected from disclosure. Again, this is not opinion, we're not asking for it. That's State versus Loman, 721 Southern Second, 1249.
Thank you. Yes, sir.
And then lastly, Your Honor, it's going to be Kidder versus State, 117 Southern Third, 1166, 2013. It's a second DCA case. Backward product traditionally protects that information which relates to the case and is gathered in anticipation of litigation. This evidence has nothing to do with the case in chief. This has to do with the credibility of a witness. They didn't prepare the credibility of a witness for their case in chief. This came upon their desk because the witness is a liar.
Thank you. Yes.
Thank you. I disagree. I believe when the case counsel originally touched your arm, State versus Raven, 195 is exactly what they're trying to do and what they're trying to ask the witness. I believe they were quoting from or looking at number 5 on page number 4 of that opinion, where they're talking about being divided into 2 categories. It says it is pared down the connection therewith and opinion work product, i.e., the attorney's mental impressions, conclusions, opinions, and theories concerning his client's case. And that's exactly what you're going into for mental conclusions or for dealing with other attorneys and discussing the case, your opinions. That is exactly what you're saying you can't testify to. Also, the court inside the state attorney's motion to quash the opinion and or court protective orders on page 4, number 7. There's a quote, Ian versus Imano, June 9-4, 7-2, 639, 864. The prosecutors must necessarily perform investigatory functions incident to the primary to prosecute in all cases. It is unnecessarily burdensome to subject them summarily to discovery by oral deposition on the ground that they acted in investigatory that opposed to a prosecutorial capacity. Subjecting prosecutors to this type of discovery of their investigation would require disclosure of the work product, seriously impede criminal prosecution.
Anything else? Anything else?
This was not an investigation. Ms. Bradley was not in charge of investigating this. This is information that came up during a statement given, and with that information, the state attorney's office, from top to bottom, looked into whether or not it was Brady material and whether it should be given. This is not in preparation of your case. This is a function of the state attorney's office, making sure that they don't present perjured testimony. It's not for their case.
Hold on.
Do you think?
Are you hold on?
Yes.
Thank you, Judge. Notes sustained. Back next week.
Ms. Bradley, how many meetings were you present at with administration meeting, either Ms. Hall or Mr. Pryor, where the subject of this Brady information came?
I couldn't tell you. I was in trial continuously from about late August of 2023 with the Honorable Judge Fine until last week. I finished 2 murder trials in that time frame.
Yeah, any estimate how many meetings you had with that?
That I was present at?
Yeah.
I would say 2, perhaps 3. I couldn't tell you exactly.
And without going into the resolutions of it or anything like that, the subject was though whether this should be given out as Brady.
In turn.
Sustained.
Okay. Let's look at that first Brady notice.
This. Okay. Are you sure that's the first one? I believe there was one that was
There was
filed
one before that, the first one dealing with
the complaint, yes.
Okay, in this notice here, it says, according to information from Ms. ASA Boutros, Deputy Gorwell, or any other BSO deputy was present in the conference room when this case statement was taking place, when the search warrant was executed and the phone was seized by Detective Barrett.
Yes.
Did you find that to be true or not?
Yes, that's a true statement.
Okay. The undersigned spoke with Detective Barretti in regards to this incident, and Detective Barretti said he asked Deputy Gorell if Deputy Gorell was there when the phone was seized. Deputy Gorell responded something to the effect, "I can be if you need me." If you needed me to be.
Yes.
Okay. Is that stated in Deputy Gorell's report?
Deputy Gorell's report says something to the effect I was told I was not needed and left.
Okay. So you do have a conflict then. Gorell's report said the only thing was he was told he was not needed, and here you have a statement by Barretti attributing it to Deputy Gorell.
Yes, there is a conflict.
Did you talk to Deputy Gorell?
Not until last week when he approached me in court.
Now, you sent this out on the 23rd.
Yes, sir.
And that was after you had received this letter from Mr. Adelstein. Usually use the mark as defense exhibit I.
Yes, this was received, I think, Friday evening. Yes.
Is that an accurate copy of what you received?
That is correct. That is an accurate email that I received.
I'd like to admit this again.
Any objection? Any objection?
You received this from Mr. Adelstein, and the next day is when you produced the brief.
That is correct.
Is this a coincidence?
In terms of,
Response to this?
no, not at all. Actually, that letter was an incorrect, what Mr. Adelstein said in accusing me of having a copy of the internal affairs report was not true. I personally was not in possession of the internal affairs report. My understanding about a week or so later, maybe a little bit longer, was that Mr. Killeran had received the internal affairs report but failed to disclose it or let me know that it had been turned over to the state attorney's office. The only thing that I had at the time of the court date on the 22nd was the letter closing out the complaint as unfounded or unsubstantiated.
Okay, now, on the 26th, where has already been put into evidence as defense exhibit 2, this was sent out by Mr. Killeran.
Yes.
Have you seen this?
I saw it after it was filed. I did not review it prior to it being filed.
Okay. This was your case, not Mr. Killeran's.
Correct.
Why would Mr. Killeran be sending this out?
You'd have to ask him. I couldn't tell you as to what he did or didn't do.
You did not authorize it.
I did not.
Do you disagree with what's contained in it?
I do. I do not think it is an accurate statement of how I relayed the information.
So let me read the operable part. And you put that in history.
Would you be so kind as to bring it up here, because I can do much better when I can read along.
It's like you can look.
Thank you.
Grab it, yeah?
Yes.
I'll tell you what. Why don't you
Okay.
read that out?
Sure. As to the first paragraph,
I was gonna say, let's go down to where you start talking about this.
correct. The first sentence indicates that the lead ASA assigned to this matter related to SAO administrators, that she spoke with Detective Moretti.
Well, please.
Sorry.
I thought this.
That she spoke with Detective Moretti in regards to this incident, and that Detective Moretti explained that his statement to Deputy Garrell was a joke.
Okay, so is that true that Detective already said to you that what he said was a joke?
No, what was intended to be conveyed was that Deputy Garrell, his response was flippant in nature. That was the joking aspect of it.
Okay, so if somebody from your office sends out a Brady notice in this case, not authorized by you, correct?
That is correct.
And in that Brady notice that I just showed you, you're saying that there are incorrect statements of that.
That is correct.
And the incorrect statement is that you were not told by Moretti that he was joking.
That is correct. The indication has always been, and if it was inartfully conveyed at some point, the indication has always been that Deputy Garrell responded in a very flippant manner when asked about showing up.
Flippant manner to whom?
To Detective Moretti.
Does he say that in his court report, Garrell?
I don't believe so.
Okay, so the flippant manner came from Moretti, and somehow you communicated that Moretti said it was a joke. Is that what we're putting together?
I did not say that Moretti said that he had made a joke in any way, shape, or form.
So you've never made a statement that Moretti said he was joking?
My statement was, at all times, and if it was ever not clear or misinterpreted by whoever was listening to it, was that Deputy Garrell made a statement that was of a flippant nature.
Okay, so again, my statement that you never said that Moretti said it was a joke, that is a true statement. You've never said that.
You can answer the question.
That is correct.
Then on the 28th, you filed another Brady motion. The notice, and that's that's defense exhibit. I can't read it. No, it's identification of nature. Let me show you defense three.
Sure.
And why don't we read again that last operable paragraph?
The undersigned inaccurately relayed to SAO administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Garrell was a joke, when she intended to relay that which is contained in the Brady notice filed on September 23rd, 2023. Additionally, the undersigned relayed to a SAO administrator that the deputy was the one trying to be funny.
How did you know the deputy was trying to be funny?
That is the same statement that is contained in the one on the September 23rd notice.
I'm just asking you that statement, that the deputy was trying to be funny. Whom did you get that information from?
That is how Detective Moretti relayed the conversation to me.
Okay.
That it was a flippant, off-the-cuff remark that was not intended to be any sort of, and not taken as serious by Detective Moretti. Detective Moretti didn't use any sort of information or did not try and say that Deputy Garrell was present or assisted in the search warrant in any way, shape, or form.
What exactly did Moretti say that Garrell said?
Something to the effect of, I can be there if you needed me to.
Was that a response to something Moretti said?
My understanding is from Deputy Garrell said that Detective Moretti asked for his name and CCN, and if he had been outside when all this happened. And so also, if you will, remember, Mr. Aronson, this time, when all of this happened, it was brought to my attention initially when I was speaking to Detective Moretti that there was an allegation of a battery by Ms. King.
What I'm getting to right now is, if I have it correct, Moretti says that Garrell made that statement. And I was asking, what would Moretti have said, or did he tell you anything that prompted Garrell to say, I could be here if you want me to, or I can say if you want me to, whatever the exact word is. What did Moretti tell you he said that prompted?
Detective Moretti, I don't have an exact recollection of anything that he asked or said on that, because my question to him was, what did you say? Did you ask Deputy Garrell or any BSO deputy to say they were there during the warrant?
And he responded, do you know Deputy Garrell said to me, I can be here if you want me to?
Yes.
Unprompted by this.
Deputy Garrell's version was that Detective Moretti asked, were you the one that was outside, or something to that effect? I was not present. Can't tell you exactly what happened.
Well, Moretti denies that, doesn't he?
I haven't talked to him about it since then.
So you're not sure whether Moretti disagrees with Moretti. You know that Burrell doesn't agree with the fact that he doesn't put in anything about this and has never said that in fact he made these statements. And then you have a prosecutor who says it did happen. So that's the information you had from, correct?
I'm not even a meeting comment. It's not about this week. I don't like arguments, respectfully, but I think these things are established.
Now, let me ask you some other questions.
Sure.
At the trial, so first of all, as far as Detective Moretti goes, he is the applicant on almost every search warrant in this case.
Quite a number of them, yes.
His credibility is an issue.
Of course.
Because he's the applicant. Okay. And you never let the defense know about this possible credibility issue before any of those motions were denied.
Relevant, also now going into, again, her taking a shot at what she did today. Hasn't it already been established? I'm asking, hasn't it already been established?
Probably not. What did, we know that Detective Moretti had a lot to do with search warrants. He's on the affidavit that we made, correct?
Yes, almost
He executed it, correct?
a lot of them.
At most of them, he received the evidence from whether it was Facebook or whatever social media, he received that evidence.
Correct.
He's the one that had to ferret out whether it was relevant, correct?
In terms of that would have been something that I would have done as well as a prosecutor on the case.
Okay. What else did he testify to? What other subjects?
In terms of other subjects, he testified to being present at the collection of evidence, receiving information from the medical examiner's office. He testified for about 3 days, so I couldn't go into every single area off the top of my head.
Okay, but his credibility as to all the things he testified to certainly would be an issue, correct?
And it was attacked vigorously by prior counsel.
There was a motion to suppress the Judge Siegel, correct?
A couple of them, I believe, about 3.
And there was no police report, if I'm understanding correctly what I'm told, and that the only evidence in that motion to suppress was what Detective Moretti testified to.
You'd have to be a little bit more clear as to which motion to suppress or which specific issue you're talking about.
Fair enough. But did some situation like that occur where there was only this testimony, there were no other documents or anything?
No, not to my recollection.
Were you ever told that if you filed the September 28th Brady notice, that your license to practice would be revoked?
No.
Were you ever instructed to file the Brady notice?
Yes,
Did you comply with it?
I did.
That is not why Mr. Killoran ended up sending out one that you did not comply?
I don't know why Mr. Killoran sent out what he did. I couldn't tell you. He did not consult with me.
Something we have to do?
Yes.
Thank you, Your Honor.
That's all, Counsel. You ready to proceed? No.
Sorry.
I'm sorry, you did something?
No, I thought you said that.
I just didn't hear you.
Oh, I thought you were asking if I might ask a question. Yeah.
All right, well, counsel asked for a 2-minute break if we wanted to speak with his colleagues, and I gave him that, so if you're ready, you may continue. But we're all ready to proceed. Go ahead.
Just a couple of questions. I think you answered it, but other people don't think you did. You did meet with Mr. Pryor or Ms. Hawk several times about the Brady issue.
At least 2 that I
I
recall.
think you said 2, correct?
Yes.
My recollection. And did you go over the specific notices? I'm not asking you whether you changed it or anything. Did you go over the notices?
I'm just trying to read that again. Each time you read that way, they told me to, be invoiced to the office and what she did with their superiors and the decision.
Thank you, sustain.
Was the subject of Brady notice?
At times.
Without going into what you already said, did you explain to Mr. Pryor the thought and Mr. Killerman what was said by Detective Gray? Like I said, I don't need to go into what it was. Did you just explain it to them?
Just as I stated on the September 23rd Brady list, that was how it was explained.
Thank you.
Hold on, Council. Any questions? Thank you. Next step down. I'm quite actually.
All the same people that are here.
All right, so we'll make sure. Yes.
I just wanted to explain some case law that maybe Your Honor isn't familiar with about what work product is and what fact work product is. And the threshold that we must argue to have Your Honor persuade Your Honor that information should come in. And we just haven't gotten there. I know that Your Honor made a ruling, but I'd like to have Your Honor maybe listen to a little legal argument now.
Go ahead.
So
Am I supposed to speak or am I supposed to answer?
You're not called anymore. You're the lead counsel in the case. I'd rather have you here.
So both sides talked about the Sam Brady case from the Third District Court of Appeals. And the side on it, Your Honor, is 495 Southern 2nd, 257. This case differentiates between two types of work product: fact work product and opinion work product. The questions that we're asking and the information we're seeking isn't about other people's opinions about what maybe the law is. What we're seeking is, and why we've alleged what we have alleged against the elected state attorney and the others listed, is that they had knowledge about what had occurred in October of 22, where the allegation and the sworn testimony against Brady trying to solicit perjury happened. And what they did between that day, October of 22, and where we sit today, where these flurry of Brady notices occurred that are in conflict. So those are the differences of fact about what they did. Was there an investigation? Did they consult anybody? Did they tell Ms. Bradley to file something that she refused to file? Did they realize that a first-degree murder case occurred in its entirety before the information about the lead detective trying to suborn perjury was known to the defense before that entire trial happened? And we've asked to recuse the whole office because we wanted to show that all had occurred, that nothing was investigated, that they sat on it for that whole time, and the knowledge of it and what, if anything, wasn't done went all the way up to Mr. Pryor. So they moved to quash it based upon the 5 days, which in the statute itself says that time limit can be altered for good cause. And the case law is clear that the subject matter of it is only protected under work product, under the statute they cited, if it's opinion work product, not fact. The facts we want to allege is who knew what when, whether anything was done about it, not the reasons why, not the opinions of law, but the facts of who knew what when, and what happened that we're sitting here a couple days before trial without the benefit of knowing all that, and whose fault it was that we're sitting here 2 days before trial, years after this happened, without knowing that. So the case law says that fact work product is admissible and subject to discovery upon the showing of need. And whereas opinion testimony is absolutely or nearly impossible to be, and is privileged. So this is a black letter law from the 3rd DCA under the Reagan case. This is fact evidence that we're asking for. When the state jumps up and says it's opinion, that's not what we're asking for. We're asking for who knew what when and how, why an investigation was never done in Brady. If a seasoned prosecutor with 20 years experience testifies that she heard this man say it. And then the case is just given back to the particular prosecutor on this first-degree murder case, seeking death penalty against Mr. Devins. And then she says, well, I looked at the statement and I didn't know about this and I didn't do anything about it. We want to show that nobody did anything about it, and that if she compartmentalizes it into saying, oh, I only do this little bit, so it wasn't my responsibility. And ASA Lucho said on the very day or 2 days later, we had meetings about this with Mr. Pryor, with Ms. Fall. Mr. Keller was notified the same day. Why wasn't there any investigation? And I submit to you the reason is because they didn't want to upset a first-degree murder case that went on in its entirety without this ever coming up. Without, they just did an emergency investigation on allegations of Mr. Devins and him doing something improper with witnesses, witness tampering. Well, they sat for a year and never even bothered to see whether or not one of their own prosecutors' sworn testimony that a lead detective tried to suborn perjury was thrown under the rug and never investigated. So we want to know that. And the way the state is trying to argue why we shouldn't have that is technical procedural stuff under the rule, which is only 5 days. Oh, this is work product. It's not work product. And the 5 days can be waived. And we're 3 days before a jury trial where Mr. Devins has a right to the speedy trial after the mistrial. He never demanded speedy trial. It's a law. There has to be a speedy trial after a mistrial. And all this stuff was brought to our attention less than 10 days ago and up to today. And we're just learning. You're hearing testimony on the right now, the eve of trial as to some of this, and we're getting blocked from the rest of it. And I would ask Your Honor to look at the rules and show that justice requires, and there is good cause to have, Mr. Pryor and Mr. Keller and Ms. Falk come in here and say, what did she say today? Did she say that Moretti said this all, but it was a joke, which is what Ms. Lucho said that she said to others, that the others are the ones that are witnesses can get that evidence. They got that evidence, and we're continuing to forget it because of procedural time restraints on subpoenas when we don't have the time, and we learned of this in an emergency nature without the ability to subpoena these witnesses within the 5 days. So that's where we are right now. Your Honor, in order to be able to make a determination of whether both Ms. Ms. Bradley and the rest of the state attorney should be disqualified or recused is partly based on what Mr. Pryor, Mr. Keller, and Ms. Falk has to say, so we know whether or not they didn't do anything about this, how that could occur for 11 months in a first-degree murder case where there's such an allegation against the lead detective, when they're standing behind mere days of procedure and the wrong interpretation of work product. So I've asked Your Honor to look at this again, and in order to ferret out justice, and not in the name of having the state ram a first-degree murder, the charge of the death penalty through without ferreting out these absolute issues of credibility of the main witness in the case. It's not fair. And so I'm asking you to relook at this.
State Speaker.
Yes, sir. Going back to briefing then, discuss, consulting, and finding, but that is apart from opinion, work on. And it's very difficult to separate out. We must say, well, the fact is what she's told. They're in there talking and they're looking over the entire thing, going over their mental impressions that happened, trying to make decisions. All of this then filters back to Brady, and whether or not it is reasonable. So we're not there. I just believe it's not about Brady. The problem is, and I know I sound repetitious, when this court looks at the motion that they have made to impeach my office, as it stands right now, this court will have no choice but to deny. They need to amend their motion. And we're sitting here today arguing all of this on a motion that is completely and utterly legally insufficient. So I don't see any benefit in going further into the office's, into this, what inner workings of the office and opinion and what work by any of the privileges. When they don't even stand on a proper motion. They're standing, then they come to a statement to itself. Must. So.
Thank you. Anything else, Counsel? Thank you. Do you have any other witnesses?
Only the ones we can't call.
Talking about Mr. Pryor and Ms. Falk and Ms. Keller. Thank you. Counsel, so you know, nobody asked me to set this case down for hearing today. I know the trial's coming up. It's supposed to go on Monday. I set it down for hearing because I was concerned about it because I thought this was something that was very important, needed to get resolved. So I set it down for hearing. Nobody said, time isn't good, i.e. we need more time to do X, Y, or Z, or get subpoenas out, anything like that. I specifically asked Bradley to be here because she's the lead attorney. I looked at her as to these Brady notices because it's her obligation to disclose these things. And I specifically wanted to hear from her. She's a lead attorney, so I had her here. But in any event, regarding the state's objection to the things regarding Mr. Pryor, that objection is sustained, and to Mr. Killer and to Ms. Paul. So I don't know where we're at now. There's no other witnesses for the purpose of this hearing. If you want to, I understand your argument. If you have something you want to argue in addition to what you mentioned and indicated before about disqualifying Ms. Bradley and or the Office of the State Attorney, I'd like to hear it. So if there's anything else you want to say or share with me about the motion, I'd like to hear it.
Well, first of all, Your Honor, the state filed their motion to quash, and they asked for a hearing as soon as possible. We assumed that we were going to be in front of you yesterday, and if that had occurred because they asked for an immediate hearing on it, we would have then been able to say to you, Your Honor, this is the situation we're in. Can you help us out and allow us to get a subpoena within a day? But that did not occur.
It did not occur, and that is my fault, my office's fault. Evidently, it was an email sent to my secretary, Ms. Ingrid, and she showed me a response. Did not see that in the email, didn't show me the email, but didn't bring it to my attention to the request there for hearing. I didn't realize that or didn't see it. Wasn't advised of that. My understanding was there was a phone call regarding hearing. But regardless, there is something in the note, and I saw that this morning, or excuse me, yesterday, before I left, and I told Ingrid to put it on in the morning. So that's how that happened. That was my office, my fault, nobody else's fault. They did request a hearing. It was in an email. I assume you got it, but I didn't see it.
So, Your Honor, with that in mind, our position has to be that we filed the motion, you set the hearing. The amount of time that you gave us for the hearing, as far as when it was set, was within that 5-day period that the rules require us to get notice. Therefore, technically, we could never comply with that rule and be able to get notice. Also, at that same time, contemporaneously, we received notice from the state as to depositions that they will not confer with us as far as depositions, and that we have to subpoena them for everything. So there was a breakdown in us basically being able to call up the state and say, hey, can we get this done? Can we do that? The communications haven't been the greatest. But the bottom line of it is that we expect to be in court on Thursday. And at that time, we would say, Your Honor, we need your help. But we didn't have a hearing yesterday on it. But regardless of it, we still need the court's help. And what the court seems to be saying is, well, I'm not going to help you, and you can't call these witnesses, so go ahead and argue. We didn't do anything to put us in this position, Your Honor. The court set the hearing within 2 days. The rules say that we have to subpoenas that get 5 days notice. The state wouldn't take our subpoenas because of that. We come to court, and the people we want to have testify are in this building, and the court is not exercising its power, which the court does have it, because they are the state, and the state is a party to this. So you have the power to have them come down here, anybody in the state attorney's office. You won't exercise that, and then you're telling me to argue right now. This violates due process, Your Honor. I mean, what due process have we been given? No access to the witnesses. Can't subpoena them. No time to get access to the witnesses, a 2-day notice. We've done everything that we could. You said we had a motion cutoff date, that got extended to tomorrow. We filed everything we could as quickly as possible to give the court as much notice of everything. But for us not to be able to have these witnesses to show the institutional breakdown because of this Brady violation, this prejudices us because the state attorney's office, and there's a case here, is Cuerdo, and I'll get the site in a second for you. In that case, they go into the fact that a prosecutor had been disciplined by the state for other actions, but they kept him on, and then in this case, they go through a laundry list of all the things that he did wrong in the case, and they hold it to the state attorney's office, and they say that under these facts of the case, the state attorney's office itself could have been the one that could have been recused for it, because it was institutional. Well, we only can get to institutional if we can talk to the institutionalists, and that's Ms. Pryor, that's Mr. Pryor, that's Ms. Falk, and Mr. Tillery. And you can only make your decision after you hear that. And we need your help, because if not, our due process rights are being violated, that we can't call the witnesses. Our Sixth Amendment rights are being no confrontation. Our rights are being violated right now unless we get help from this court. Because we didn't set the times, we didn't set the parameters, we're just here doing what the court asks.
No, thank you. Anything else from the defense or state?
They're right, and we did ask for an order to process. And our right to do that, and we did go with that they tried to speak here. And it still stands, the same reason this morning stands down. Counsel continues, again, I know that's not the corporate record, he's talking about the institutional problems, he's citing case law. None of that is in his motion. The four corners, he's gone way outside the four corners of the motion, and that results in prejudice. You don't have all I am, and I have, again, he hasn't set forth any reason, he has shown, conflict, and he says that there's from the state, not the defendant, they didn't show the defendant had actual prejudice for in order to qualify. So I just asked the court to read over my response to Bob's point, and at this point, I don't think there's any legal sufficiency in the motion that they're standing on.
Let me ask you this, the assistant state attorney, Ms. Bradley, they call, the defense calls her as a witness during trial, to rebut or to challenge the credibility of Detective Brady's test his credibility based upon this alleged allegation that happened in front of Ms. Boutros. They call Ms. Boutros, then they want to call Ms. Bradley. Talk about corruption, bias, motivation to testify, things of that nature. Why wouldn't that be allowed? Why wouldn't they be able to cross-examine or put Mr. Moretti's, Secretary Moretti's credibility in question by something that happened previously? I.e. on this November or October 2022 meeting, the allegation where it said that by Ms. Boutros that the witness basically was telling him, I'll do it if you need to, I'll be there if you need me there, or something to that effect. Whatever the language is, goes directly to his credibility. Whether it's true or not, I don't know, but why couldn't they bring that up to attack his credibility?
At that point, first of all, I told for earlier, when, there's a trial bill that they call the state is not objecting to any of that. We agree to it. Right?
Well, how is she ever going to be able to try the case if she is a witness in the case?
Well, if you have this testimony is out there, right? And then you call it detective stand, you can cross, obviously you can cross in or try, this is all theoretical.
It is theoretical, but that's what I'm concerned with is what happens if you have a situation where Detective Moretti's credibility is attacked by this incident that Ms. Boutros testified about today, and she is called as a witness. My understanding from, you may not have seen it, I thought we talked about it this morning, but my understanding is, one of the things that concerned me was defense counsel put down Ms. Bradley as a defense witness for this issue. So if that's the case, and they intend her to call, and there's issues about it because you have two different Brady notices that Ms. Bradley signed, all right, that there's some inherent conflict in that. Why wouldn't they be able to discuss that in front of the jury with Detective Moretti? And if that's the case, and they're telling you that they're going to call her as a witness to do exactly that, why should she be on the case?
And at this point, well, you don't even know, you have no testimony from the detective.
I agree with that. I totally agree with that. I don't know what the detective's going to say.
I just wanted to be completely speculative about what would happen, and I don't know if that is going to, if they, listen, that could happen in any case, they could call a prosecutor saying they wanted to try to do it in lawyers, and it didn't, again, they decided not to. But it is, the case law says that you can call prosecutors to stand, not necessarily. You can call them to stand, and it doesn't provide refusal. So, I think at this point, there's not enough information to be able to give you a solid answer on that, but certainly the case law says, well, you can call a prosecutor to stand, or more than one prosecutor to stand. That doesn't result in automatic disqualification.
We have bar rules that basically says attorneys can't be both advocates and witnesses. There are bar rules, and if you, the better practice is for somebody to be reassigned, get out of the case, if they're going to be a witness in the case. That's nothing new. It's been around for years. And we have something where, in this case, defense counsel listed Ms. Bradley as a witness. And whether or not she's ever going to testify in the case, I don't know. But, they've listed her as a witness. And there's an issue regarding multiple Brady notices that went out. So if she is called as a witness, how is she going to argue, for someone's credibility and basically to dispute or say that whatever Ms. Boutros said, that Ms. Boutros is called is not credible, and Mr. Moretti is, Detective Moretti is credible, or something along those lines. I just see that as being an issue. I don't know how to resolve it.
Well, at this point, I respond to you, look, it is collateral or extrinsic evidence, or questions. So,
How's that collateral? Go through its credibility, protect Murray's credibility. That's
it's
not
extrinsic, you're looking to determine whether or not it's admissible. A lot of times under the rules, there's only certain things you can, cross-examine each other, you did other things you can't. And in this particular case, there's no, right now, there's no crime. So whether or not those things are gonna be admissible or allowed is one thing. We haven't even got to the point of, is it Brady? We didn't get to that point. And add to that, again, okay, I understand, I get it, I get the court.
What do you mean we didn't get to Brady yet? What do you mean we didn't get to Brady?
There's no determination by the court as to whether or not that one statement, which remains the same in all three of the last three that are filed, three down notices, is what, Secretary Reddy allegedly said to the deputy. It's the same, every single one, of course. No, I don't believe the first one of the evidence is before trial. That was back in August 30th. Then there's three after. It's the same thing. That's the Brady. And there has to, is it material? Does it meet all the three problems of Brady? That has to be decided, because if it's Brady, one has to make a decision what's going to do, or they have to think on the decision. If it's not Brady, the problem is, that's why all of this is a problem, because if it's not Brady, that's for the state to decide, right? The state always, people don't like it, that's what the Supreme Court said, the state was it's not Brady. And if it turns out in the end it's not Brady, then the state would have no obligation, at least under the rules, or Brady, after the other. So, that's why today, I just thought we were going sort of in reverse, Department of Courts. We were sort of going toward the Brady issue, instead of looking at the motion to disqualify. Which again, as is Nancy.
Anything else? Anything else?
Just briefly, the case law seems to be very clear that the state attorney's office can continue a prosecution if one of their state attorneys is a witness. But I found no case law that says that a state attorney can be a witness in a trial in which that state attorney is trying the case. I don't believe it exists. I have not been able to find it. So therefore, we start off with the rule of whether the state can still prosecute, and the answer is yes, unless we get to this level of what I've been talking about institutional, I don't use the word corruption, it's not, institutional prejudice. And I think we can establish that if we have these other witnesses. But as to Ms. Bradley, which is what you've been dealing with, yeah, there's a good chance she's going to be called as a witness, because I don't know what Moretti is going to exactly say about these things. I don't know whether it's going to contradict what Ms. Boudreaux said, and Ms. Bradley certainly could be there to either bolster what Ms. Boudreaux says, contradict what Ms. Moretti said, because she has had personal conversations with Moretti, and that may become evidence at trial. There's a good chance she gets home.
Anything else?
No.
Thank you. So, Council, I'm going to defer, we're going to take it under advisement, motion under advisement. I understand that you want to reopen it regarding other witnesses. I understand that. You're not having asked for a continuance. You want to go ahead with your trial. And we're going to do that. We have several motions that are pending. You be prepared to go forward on the motions. State should be prepared to go forward on the motions, and we'll see where it goes. Well, I'll let you know sometime today. All right?
The reason I'm asking around is
I understand why you need to know.
I need to know this.
But I need to think.
No, I understand, but I need to get notices out to them because they're not going to accept anything that's not within 5 days. So I got.
Aren't all whoever you need for the motions to suppress, aren't they all under state subpoena? Would they be available?
Well, those are the motions to suppress. They may be. We're not talking about another motion. Yeah.
What other motions you have?
We have the motion on to dismiss for prosecutorial misconduct. We have several motions in limine, and then we have the motions to suppress evidence.
Understood. I have a list of them. So, you talk it over with the council, you tell me which ones, if there's some agreement as to what you want to have first, who the witnesses are that you need, their availability. And what my understanding is, because the case is set for trial, I would have thought most of the witnesses are available. I could be wrong on that, but that's what I think.
Well, they're being available and being made available to us. Two different things.
They're submitted out to the state for next week. This is pre-qualified for communication, that any witnesses should be available. I need an opportunity to whatever witnesses are needed for these various motions. And we're at 24, and I think now 27 that have been filed by consent. The state has a couple of other motions that I'm trying to get filed. However, I was called to court and needed to do so, that also need to be heard. So there's definitely some time that needs to be on that. We have until October, my timeframe of 21st, to begin jury selections and to start that process. My suggestion would be that we set aside time for a motion to begin next week and try and get those handled, because it is inappropriate trying to pick a jury, and you don't know what the issues or what the evidence of the case will be.
That's what I thought a week, 10 days ago, but you all told me that you wanted to start with the jury, pick a jury, and go on Fridays. That's what I was told.
That's what the defense said. The state suggested that we should do the motion first on that.
Regardless, you talk it over and see what you can resolve and which ones you want to have first. I'm gathering that you want to have the motion to dismiss her first.
Yes.
All right, any objection to that?
But I believe we have a date for the motion to dismiss. It would just be the other motion.
Excuse me, I'm asking you to state what objection to that.
You have a motion to dismiss current set for October 20th, correct?
That's not good enough. All right, yeah, you've got plenty of time to discuss it. We need to move it up. This needs to get expedited. Just take a 2-minute recess. Sure, we'll be in a recess for 10 minutes. Thank you. Mr. Evans, can you go downstairs? Thank you. No recess. Well, when I left, you indicated you want to hear the motion to dismiss first.
I think the motion to dismiss should be heard.
Does they have any objection to that? No. When do you want to hear it? 20th is not, that's too far down the road.
So Judge, we, as the defense speak with the proposition, I guess, Mr. Anderson could communicate on behalf of the defense what we would do that.
We have that 5-day notice that we have, so we are basically recluded from letting tell anything next week on that motion.
Who do you need to call as a witness?
Excuse me?
Who do you need to call as a witness?
Ms. Bradley, Ms. Boutros, Ms. And we probably could adopt some of this testimony we have today. I'm not trying to be redundant, but we're going to need Ms. Falk, we're going to need Mr. Kilburn, and we're going to need Mr. Pryor.
And we can subpoena them first thing Monday, but if you allow it to be heard on next Friday, you're really not upsetting the 5 days other than a few hours.
May I suggest something? That the state tell us when they're available sometime next week, and we'll work around their schedule. I know they're very busy individuals. And if they could just inform us when they're available, we would do that motion.
Well, I think we're going to do that motion. We're going to have to go and revisit the motions for swap and for protect order.
Well, then we're going in a circle. That's just my assessment.
But if we're trying to remedy this argument by the state that we didn't give them adequate.
Counsel, I guess the concern I always had is the timeframe is one thing. The other big issue is how do you get around, how you are able to call Mr. Pryor, I guess, as a witness. I have my own concerns as to how you do that with the elected state attorney. I guess I have to revisit exactly what you put in your motion as to why they need this consultant. I thought it had more to do with the failure of the state to comply with its obligations.
The motion simply is the state failed to provide Brady. Normally, the remedy for failure to provide Brady is a new trial. However, there comes a level of prosecutorial misconduct in which due process is violated. That dismissal is the proper remedy. One of the ways that you get to dismissal is by the fact of showing that it's an institutional defect, basically, institutional prejudice. That's what we're going to be trying to show. So that is the focus of the motion. That does not answer your question as to whether or not we can call Mr. Pryor or not call Mr. Pryor, but that is the focus of the motion. As far as calling Mr. Pryor, I don't see, as they say with Donald Trump every day, he's not above the law. Mr. Pryor is not above the law. He has germane testimony and evidence and information that pertains to the operation of the state attorney's office as it relates to this Brady motion, as it relates to the Brady evidence that was not given out timely for the first trial and that we've just received. He has information as to what he was told his underlings or the people that worked for him and whether that was followed. If it wasn't followed and he allowed it to go by, that also can be looked at as institutional. So we have the right to find out what he did, who he said what to, all the circumstances. And it's not really our right, Your Honor. It's your right also. You have the right, the duty to know all that is going to transpire so that you can make a fair determination of whether the case should be dismissed or not. And the only way you will know all that is by us calling these witnesses.
If I could just interject one thing, Jeff. Ms. Bradley testified that she had meetings with Mr. Pryor. The pleadings on the Brady notices say, and Ms. Boutros said, that she told Mr. Pryor what Detective already said. that he said these things, but it was a joke, but then she changed her mind in the Brady witness. If he's a fact witness as to what this Bradley told him, yes, Mr. Moretti told me that I said if it was a joke, that puts him right there in the middle of what was said to your honor in a Brady filing. And that it was, that there was perjury made by she and Mr. Moretti. So it goes right to the heart of it. They alluded to you a few minutes ago, oh, we don't know if it's Brady yet. So, we have a case law that says that any impeachment evidence such as this is Brady. They sat in for a year. In that year, if Ms. Bradley said to Mr. Pryor, here's what Moretti said, and Mr. Pryor didn't do anything about it when he was notified back in October of 22, I believe that this is one of those rare instances where the elected state attorney is a witness. And that's why we want to call him. That's why we still want to call him. That's why we think his evidence, if we believe that's what he's going to say, goes right to the heart of a motion to dismiss.
There are two cases that have identified the third one, but one is first, and the other one is Logan versus State. And all the reason I'm bringing that out for is in these cases, various state attorneys testified in hearings such as these. So, in fact, here in the first case, 18 Southern 3rd, 975, 2009, the prosecutor, David Ritter, testified at the evidentiary hearing that he never talked to Anthony Williams about his cases and that he never made any promise to him ending the case. I bring that out only to show that the prosecutor testified in these types of hearings. In Kitten versus State, 90 Southern 3rd, 794, 2011. At the evidentiary hearing, Assistant State Attorney Ritter testified that he was unaware of Detective Cosper's handwritten notes of his interviews with David Pound on June blah, blah, blah. What I'm pointing out again, Your Honor, is we can call these people as witnesses if they have evidence that is germane to this issue.
There's no carving out of the elected state attorney is any different than anybody else in his office. And I know it's delicate because he has an office, but that doesn't mean he's immune to being a witness when he is a witness. There's nothing special about it. And we respectfully request that we need to hear what he has to say. If you get excluded after you hear it. But I think what he has to say is going to be very germane and relevant to this.
You have no idea what he's going to say.
I believe he's going to say, based on what Ms. Boutros did, and she told me on the phone that she testified to in the court, that he was told by Ms. Bradley that, yeah, Moretti told me he said this, but he only meant it as a joke. If she said that back then, and then all of a sudden changed her testimony in the latest Brady notice, it shows that she's complicit and is not telling the truth either. And that's why she should be thrown off the case. I know Your Honor hasn't ruled yet, but that goes to the heart of the impeachment testimony and the heart of the prosecutorial misconduct in the case. We believe, based on what Ms. Boutros said and was a part of in that office, that she changed her story and told Mr. Harold Pryor, Moretti told me he said it, but it was a joke. And then she changed her whole thing, and why did Kilburn file this Brady notice that said, just what I'm telling you, it was said. Yeah, he said it, but it was a joke. Where'd that come from? Out of thin air? And then she filed something. I mistakenly said this to, I forgot the exact word, some ridiculous word of I'm changing my testimony now, and Moretti never said it. Where she then admitted that she said it to Mr. Pryor, but now says she did it. That's not relevant to this case. And I'm sorry, just because he's the elected state attorney doesn't mean he shouldn't be held to the same standard as his other ones, and held to the standard of telling the truth about hearing the statement from a prosecutor who either lied then or is lying now. Because it's evident that she, in her own words, said, I said something, I didn't mean it. She's a trained lawyer. She misstated the lead detective in the case, admitted that he tried to have the guy commit perjury, but then she mistakenly meant somebody else said something else. That's preposterous. And it should show you that we, in good faith, need to ferret out what really happened. Because it's both said in some of the various Brady notices that change her story. Yeah.
Yes.
Well, let me start at the court. First concern is good. The attorney, but it's case law dealing with the fact of overreach from the list from the judicial branch on the executive. I need to do research on that. It's the process. There are issues sometimes with the overreach of the judiciary holding the executive. That said, case they cited, it sounds to me as though maybe it could have been a people like, oh, I don't know, please, offhand if they, don't know the side of the report, but it sounds as though the testimony that is 3850. The issue is getting messed up because Brady, right? It's got to be material. And also, Mr. Pryor was not there when the alleged Brady statement was made. Mr. Falk was not there. Mr. Children was not there. They were not there. So you're saying, well, they have nothing but hearsay. And then on top of that, look, if you take that hearsay and the office has to, investigate or to make decisions on Brady, that's all, again, there we go back to the trial. Because how are you trying to tell you how? You've got 100 lawyers in the room. Show this to them. 50 will say, oh, that's not Brady, and 50 will say that's Brady. Because there's not a great understanding of what materiality is and how you make a determination on Brady. So,
Counsel, respectfully, when I hear something about evidence going to the credibility of a lead detective in this case, that to me is important. That's material.
and that may well be, but a strict Brady standard, you have to look at the whole thing and determine whether or not there's a reasonable probability if that had been presented to the jury, that it may have either caused an unfair trial or may have changed the verdict. And that's, that's a lie. That's all speculative. You might not like Richard Ford, but presented to a jury, if it's even, admissible, presented to a jury, well, they might take it into account, they might not. It's not like, okay, the Brady material wasn't like a video to show that the defendant absolutely wasn't at the crime scene that night.
But isn't that missing the point as to what a jury's going to do with the information? That the point is that the jury gets the information. That the jury, the defense gets the information. That they have a choice as to what they do with it if they think it's material based on what it is. That they can present it to the jury possibly. They can make a decision as to that. That's what Brady's all about. It's just you turn over what we have very liberal discovery rules in the state of Florida, and there's a federal case talks about turning over those types of evidence. And it's always been, as far as I know, that when credibility is and impeachment are in question, that's covered under Brady. Those types of information, that type of evidence is covered. If you have something that shows a witness isn't telling the truth or something along those lines, that's Brady material, and that needs to be turned over. At least that's my understanding of it.
Well, and my understanding is, you have to meet the materiality standard that's what in Brady.
It wouldn't
be
be
a probability, there would be a different possibility, the outcome that was achieved, how it would be different than the outcome achieved with it. That's the last part of the problem.
That I agree with.
Actually, Your Honor, that's one of the core can be interpreted. Does it cast a light on it that you can't be comfortable or confident in the verdict?
So we're getting feel. I guess the question really is whether or not, assuming that they subpoenaed the key people in the office, Mr. Falk, Mr. Kilrin, and Mr. Pryor, and you file your motion to quash again, what is the viability of that? And what should my ruling be? I ruled this morning, not the same issue. This has to do with disqualification of the state attorney's office as well as that. But I didn't hear, and I know you're arguing about prejudice. There's no actual prejudice, and that's, you said you wanted me to strike the whole motion. I didn't. I let them put on what they want. And I know they didn't put all the evidence that they thought they needed in here, but I didn't see how we got to allow Mr. Pryor to testify at this point, because it's just an allegation. I haven't seen anything that said that Ms. Boutros or anyone else said that he orchestrated some type of cover-up or told somebody not to testify or don't do this. I didn't hear anything like that. And I heard testimony from Ms. Boutros, who is the main witness regarding this topic, as well as Ms. Bradley. So I don't know where this goes, respectfully. And so what I'd like you to do is to give me some type of short brief. You go ahead and subpoena your people for next Friday hearing. I'm going to tell them if they get subpoenaed out, and I'll hear the motion quash. Let's say on Tuesday, but you get the briefs to me tomorrow, on Monday. Is that enough time for you to do something? Sure. Is that enough time to read?
We're going to get the subpoenas out before that on Monday, or we're going to still be in the same issue.
No, I'm telling you, I'm shorting the time. And if they get a service, they do it. Let's just get it done. I mean, this is not something, I'm not ruling on the motion of your proposed motion to quash the subpoena, but I understand it's coming. I just want this to move along in some type of reasonable manner. Is that all right?
I will get you on Monday. Short around go with our reasoning for why for restraining motion.
That's fine. Then we can do something at the same time. Why I shall allow Mr. Pryor and the powers that be in the state attorney's office to testify. I'll have that chance to do it. We can talk about it on Tuesday, and then just tell Mr. Pryor and Ms. Falk and Mr. Tillery that there's a possibility they could be subpoenaed. The subpoena process is ongoing. There might be a hearing that their testimony would be required on Friday, but I haven't made that decision.
And would you like, just shortly, like, close business on Monday or?
That's fine. Close business. Good for you.
We follow the court says.
All right, so we did it on Friday, and we'll do it, or excuse me, on Monday. I spoke, I apologize. And we'll set something up for a hearing. It's Tuesday, or do you need one to Wednesday? Is that right?
No idea what our schedule is. I know they're supposed to be here, but I'm the supposed to be. I can be here Tuesday.
So that's that's to this motion, that's the plan. And then what about some of these other motions? We have 13 motions to suppress. I know we have a couple of other motions. How are you going to handle those?
With regards to that, there's a couple of different options we can look at if we're going forward on those on the week of the 16th. My suggestion is set 2 or 3 each day so that we can be adequately prepared for them. Some of them may not require testimony on each individual motion. We may do all the testimony on the motions to suppress sometime on the 16th.
Clarence, does that work for you?
Your Honor, as I said, I'll make anything.
So assuming that's the case, now what happens if I grant defendant's request that you're out off the case, Brett? Who's coming in to take over?
We'll address that if we have to, Your Honor.
Pardon me?
We'll address that if we have to.
On that issue, Your Honor, we don't want to play around. We anticipate calling Ms. Bradley.
I think you made that clear to me before. I said that at least
I just want to make it very
3 or 4 times that I received a notice, and I know counsel suggested he wasn't aware of it, but I received a witness list that she was going to be a witness. And when I say witness, I'm talking about your case in chief. That's what your intent is.
Yes.
That was made clear.
My suggestion on that, you know, everyone will put off the short memorandum on that issue.
That's fine. Good. You can do it the same if you want.
Thank you.
Anything else to discuss now?
What are we doing Monday?
No.
Cool. Fair enough. I
All
like
right.
it.
I mean, my understanding is you want to hear the motion. Let's just make sure we have a batting order. You want to hear the motion to dismiss? That's going to be heard on, you said Tuesday. You're going to have a memo to me by Monday, 5 p.m. Do you have that, Travis? That's what everybody agrees on, correct?
No, I thought the actual motion should be next Friday, because we need those witnesses.
Tuesday's motion to quash.
Right.
Your Honor, stated.
Correct.
That's correct.
I apologize. You're right. I misspoke. So the motion to quash will be, there's nothing new in your motion to quash, correct? It's going to be the same basic argument, right? And you'll get that out, and you're going to go ahead and get your speech. So that's on Tuesday, right? You'll have the memos on Monday by 5, and then the motion to dismiss is on Fridays. Is that correct? What date is that?
Can you move that up, Judge? Is we gonna do the motion to quash Tuesday?
I'm just asking you what date you're doing. So we're talking about Tuesday the 10th is a motion to quash. When are we having the motion to dismiss? That's why I thought the council saying you should move it up.
Can we go Wednesday? Would that be a problem? If we know who's gonna testify, why can't we go Wednesday?
Yeah, the attorney has the attorney. I mean, they got it. Right. Yeah, very important.
So you're saying Friday would be better? All right, so Friday, all right? So that's the 13th on the motion to dismiss. And then on the motions to suppress and the motion, there's a couple of motions limiting, I think, as well. We're gonna start those on the 16th. Is that correct?
So that means state suggestion would be that, just based on the number of them, 3 or 4, between each day, Monday, Tuesday, and Wednesday.
Do you need different witnesses for these?
Because there are so many of them, I haven't even fully reviewed each one yet. There are some that would require other witnesses on that. And then the state also has motions that I didn't identify on there, here, so I have to get those completed.
But on the 16th, so you're gonna start with motion to suppress on the 16th. Right. So which order do you want to have the motion done? Which one goes first?
We'll have to go through them and I'll see which ones we can have the most witnesses in common. So we can go through that. I do not have them with me, nor do I have my tablet to be able to pull them up individually.
Judge, Ms. Bradley would speak with me, not in court, but off afterward. I would be happy to speak with her, try to arrange to get which motion to go at what time.
Just help you now. I have a list of the motions here as well as my checklist as to what motions are pending that I understand. If you can go through this, would that assist both of you now?
Your Honor, I think we need to look at the substance of each motion, determine which witnesses and if there's any additional witnesses.
So the answer is no. You want to talk with counsel and then tell me?
Yes.
There's going to be, let's say, 3 motions a day? Is that fair?
I think we can do at least 4.
And Your Honor, some of them will be easy to do more than 3 in a day, because some of them are just facial challenges to the affidavit, and some of the motions in limine are arguments, they're not even testimony. So I think we'll be able to get another.
How many you should do? You'll just agree on which ones you can get done in a day, and you'll do that.
I'm happy to do that via email with Mr. Aronson, and it can respond in that way so that there's a record of it.
Fair enough?
Yeah, I like the old fashioned way of talking to people, but okay.
We'll do it by email.
So, but I just need to get it done. I want everybody to I want to have a hearing set on these things. So you'll do that, arrange that, and then send out the notices of hearing.
Yeah.
Travis, can you give us a notice of hearing on the ones that we talked about today? The motion quash, when they're going to be due on the memo that they're going to do, the 2 memos, as well as the motion for to dismiss. Just give dates for those, please.
He has his motion to suppress. Which I sent over to change yesterday, requested these. I have a motion on the calendar, which would be detective already. A motion on Google Maps, which would be detective already, and a motion regarding games, which would be.
I don't have any issue with having whatever motions are set and filed that you want to have heard. Just that you coordinate the date and time, because there's several motions to get. Council suggested in excess of 25. I don't know how many there are. We just need to get them set and heard, and everything that's filed will get heard. All right? So you'll coordinate that. Mr. Harrison, you're going to coordinate?
I'm going to do my best.
All right. Yes,
I
ma'am.
have one housekeeping issue. We were before the court on my motion to compel, at which time I asked, and the court granted my request to redepose Agent Collins. Ms. Bradley says that's never happened. Before I submitted my order to the court, I just wanted to remind the court to make sure that was the court's ruling, so I can submit my order so we can redepose him. This has been an issue going back and forth with Ms. Bradley for about 3 weeks now. And all we're doing is wasting time. I don't have the discovery I need, and I've now learned, and there's a motion coming later this afternoon, that the discovery that we have got has been handled with.
That I don't know about, but my understanding was that you had asked to take Brendan Collins' deposition again because you didn't have all the material the first time. That's my recollection, and I thought I approved that.
Thank you.
So Your Honor, there was no written motion on that, there was just a motion to compel discovery. The motion for the redeposition was the DNA analyst, Kurt Rhodes, which was without objection from the state on that, so that was only one.
Respectfully, I thought you didn't have an objection to Brendan Collins' deposition as well. That was my thought, but regardless, if she was taking, I don't need to say she, Ms. Liberty was taking the deposition of Brendan Collins without having the information needed to conduct the deposition, that was the way it was, what my understanding was, and that's why I indicated that she, counsel would go ahead and take that deposition over because it was something that was done. This was going on just before trial, or in trial with more evidence. I forget exactly the particulars, but my recollection is I said yes based on what I heard.
Thank you, Judge, that's my view. The organization objection that was not in writing, and her motion was not to compel a second deposition, but to compel additional material that is not in possession of the state.
And Mr. Brady, been argued case law that you can't take the position that's not in possession of the city, in the possession of your witness, must turn it over.
Respectfully, I don't remember all of that. Perhaps you can get a copy of whatever that was in the transcript. My recollection is, though, they would ask for the deposition, and I approved it. I don't remember all the what precipitated immediately before that, but the final result was I thought I lied. But if I'm wrong and you say something, show me a transcript that said my memory of that's wrong. All right, you can just order it. Otherwise, let them take the deposition, Mr. Collins, and whatever that material is that was needed to take his deposition that they didn't have, make sure it's provided.
Understood.
All right. What else do you have, Ms. Bradford?
In terms of, I need a couple of more USBs from defense counsel. My understanding that detectives have dropped off the materials from the search warrant that was executed on Monday for pictures and things that were taken of that. So I need USB from counsel to make copies of that. Just this afternoon at noon, I was going to go to the crime lab, the production of all the DNA was available. It's a voluminous production, so I just need the USB to place on that. So I think that was 256 megabytes on that one.
Who's coordinating that on behalf of the defense?
So the DNA is going to offer you the USB with the DNA.
How many do you need?
And I'm not sure the material has been dropped off in the courtroom. I need one for all the information from the search warrant of Mr. Henry. I need one for the phone calls from the subject as well as the probable cause of the search warrant for Mr. Henry. And then I have additional, that's two, three for the information for the DNA. I would say 4 would be safe, just in case.
Any issue?
Other than that has nothing to do with this case, it's
I have no idea. I'm not familiar with it.
The DNA, that's.
Oh, okay.
Anything else to discuss?
Can we just clarify, I'm sorry, can we just clarify, this is Eric King over here, we just wanted to be, sure. The memoranda for the motion to quash protective order as well as, memoranda concerning.
Monday, Friday.
Monday at 5. and-
Monday, 5.
Okay, and then the, motion to dismiss the schedule for Friday morning at 9 AM.
Yes. Do we have anything on document Monday, Friday, 9 a.m.? Morning? One of the cases prior to that shouldn't take long.
And the motion to quash will be heard on Tuesday.
Yes, 9 a.m.
9 a.m. Thank you.
Anything else? Not hearing anything? Thank you. We're adjourned. Thank you too, guys.
Alrighty, so we just watched the hearing that led to the recusal of prosecutor Bradley for the YNW Millie trial. So we know that there are other or new prosecutors for the second trial that is, as we know, set to start in September of this year. The next hearing for Melly is going to be in February. So y'all know we're gonna be tuning in and watching it. So right now we are actually going to take a quick break, and when we come back, we will start the murder trial for Ahmaud Arbery ahead of Jackie Jenkins' trial. If you don't know, Jackie Jenkins is a DA down in Georgia, and she is being represented by YSL still, y'all. And so I think that it will be good for us to rewatch the murder trial, just so that we have all the pieces to the puzzle. I didn't watch it the first time around, so we're gonna start that, but we're gonna take a break and be back for that. So if you want to stay here and watch with us, you are more than welcome to. If you are watching from YouTube, let's see how many viewers we got. We got about 400 people watching, 409 people, 365 of those are from Twitter. What's up, Twitter? What's going on, X? And we got 44 people watching from YouTube. Hey, Taylor Gang. Make sure that if you are watching from YouTube that you click the X button from the comments and you go out and like the video. All right. If you have time, while we on break, anybody from X, you can go on over to YouTube and like our video as well. But again, we'll take a quick break and then we'll be back to start the trials. So get ready. It is definitely going to be one of the ones. All right, family, we are back. I will just go ahead and press start. So let's get cracking.
For absolutely no reason, because where's Mr. Arbery? Look how far Mr. Arbery is. Mr. Arbery's under attack. He's being driven forward by Mr. Bryan in his pickup truck. He's running away from this pickup truck that's already tried to hit him 4 times toward the McMichaels. Travis McMichael is out of the car with his shotgun. And as Mr. Arbery runs toward him, he pulls up the shotgun and points it at him. Mr. Arbery rounds the corner and is shot the first time, and the struggle ensues. How do you know this was an attack on Mr. Arbery? Because Greg McMichael said it perfectly. Mr. Arbery was trapped like a rat. That's what he told the police. Trapped like a rat. Given the sound and what's going on, I'm going to go ahead and see if this will play. We'll see if it works.
Hello. 911, what's the emergency? I'm not here. Let me have a clear cut. Where at Tacoma Shores? I don't know what's wrong. Sir, hello, sir.
So, ladies and gentlemen, what you heard was, stop, goddammit, stop. That's Mr. Arbery coming around the truck. You heard a little sound. That's the shotgun blast. Travis is after the shotgun blast took place. Greg McMichael, at 1:14 p.m., in about 9 seconds, is making that 911 call. Remember, Mr. Albenze called at 1:08. This is 1:14. Greg McMichael has now made the 911 call. This is after they've all been, Mr. Arbery's been attacked, Mr. Arbery's been chased, Mr. Arbery's been yelled at, Mr. Arbery's life has been threatened, all of this. And what does he say? His emergency is, this is the emergency, ladies and gentlemen, I'm out here in Satilla Shores and there's a black male running down the street. That's the emergency. Ladies and gentlemen, here's some still shots so that you can see. There's Travis McMichael pointing the gun at Mr. Arbery. See how far away he is? There's a better view as Mr. Arbery tries to go this way, go that way. Travis McMichael is blocking the street. His truck's in one lane, he's in the other lane. What's that called? False imprisonment. Mr. Arbery then runs this way to get around the truck. Comes over to the side. Comes around. And ladies and gentlemen, this is really important. What you're seeing here are 2 really, really important things. Right here is Travis McMichael's head. Travis McMichael's head. You see the shadow underneath? This is really important. The reason the shadow is important is because it shows Travis McMichael's shadow. It shows this long thing, the Remington 12-gauge shotgun, and it shows Mr. Arbery right here. This truck blocks exactly what took place. But you can see this is where Travis McMichael is. There's the shotgun, and this is where Mr. Arbery is, right there. In other words, ladies and gentlemen, Travis McMichael did not stay on the driver's side of the pickup truck. He didn't stay right here where his dad was in a higher position. That door is open. What did Travis McMichael do with that shotgun? He stepped around that open door and moved toward Mr. Arbery. He's got his shotgun and he's moving toward him to intercept him. He's right here in front of the car, right? And Mr. Arbery comes around and he shoots him. Shoots him like that. First shotgun blast in the front of that car. Went from there to there. Now, the Glenn County Police wanted to make sure that they could try maybe and enhance this somehow. So they went ahead and they sent it off. It's a little odd to look at, but it's got some enhancements so you can fully see exactly what's happening. Shotgun goes up. Mr. Albenzi's 911 call was at 1:08, as Greg McMichael stated, but the whole thing started when I saw this guy running down the street. No immediate knowledge of any crime having been committed by Mr. Arbery. And here's the truly, truly tragic part of this whole entire thing. Officer Minshew, who was dispatched due to Mr. Albenzi's 911 call, was in Satilla Shores and heard the shots. He was driving about 5 miles an hour down Satilla Drive, looking for the suspicious person. And he heard the shots. The statements of the defendants. One thing I want to be really, really clear with you about, and it's important, is that everything they talk about is what they thought Mr. Arbery was doing that day. That day. Travis McMichael. This is what Travis McMichael says. He runs to the right side of my truck. I stand on the left side of my truck. I'm waiting, get by. Right? As in passenger side? Passenger side. Yes, sir. Running towards the passenger side. Travis McMichael is telling the cops, I was just waiting for the guy to go by. He either came back to the left side or came to the right, and I'm backing up. I'm telling him to quit. Stop coming at me. Stop coming at me. I see where it's going quick. I got the shotgun in my hand. He comes up. Is it pointed at him at that point? Or, yeah, it's pointed at him. He admits he never stopped pointing the shotgun at Mr. Arbery. But here's the problem. Look at this statement. He either came back to the left side or came to the right, and I'm backing up. I'm telling him to quit, to stop coming at me, stop coming at me. Travis McMichael's the one who went to the front of the truck. Mr. Arbery comes around the corner, shotgun immediately happens. And what does Travis McMichael say? And this is at the very beginning of his statement. So this is, he's been read his Miranda rights, he's sitting down with the officers, he's talking to them, and this is the very first thing kind of he starts describing it. He comes up to that driveway, squares up with me, I shoot. Squares up with me. Squares up with me. And don't get me wrong, ladies and gentlemen. During the rest of his statement, Travis McMichael goes on to say that Mr. Arbery attacked him. Okay? He goes on to say that I was acting in self-defense. He goes on to describe his thought process while they were struggling over the shotgun, that Mr. Arbery was going to get the shotgun away from him, and that if Mr. Arbery did, he'd get shot. Okay? But remember, this is 2 hours later at the police station. It's really important to note, ladies and gentlemen, this. The medical examiner is going to come in here and he's going to talk about his opinion as to the order of shots. The very first shot is to the torso. And Travis McMichael acknowledges that. Yeah, I shot him right in the chest. Here's the thing, he didn't hit him in here. He was holding the gun low. When he shot him, it went right here. And when it went right here into him, it actually came out here. So I want you to think about this. Okay? Front to back, no horizontal deviation. Straight through. But it hit him here and came out this way. His torso's turned. Here's the other thing the medical examiner is going to tell you. He was also shot in the wrist at the same time. The shotgun pointed out. His wrist is a mess, but it's not a fatal injury. There's arterial spurt coming out of it. There's heartbeats, but he is shot here. The medical examiner is going to tell you that this motion is consistent. Now, he's also going to tell you it's consistent with him trying to grab it, all that kind of stuff too. But he comes around to find Travis McMichael has moved in on him, and he's shot in the wrist, and then shot in the torso, and all the pellets are right here in his back. When you watch the video, you'll note that he's wearing a white t-shirt, and it starts to expand across his chest as he keeps fighting with Travis over the shotgun. He's been shot. Ladies and gentlemen, this was lethal. This killed him. He just didn't fall down and die right then and there. He went ahead and struggled, as you see in the video, with Travis McMichael over that shotgun. There was a second shot. Do you remember seeing the spray and the stuff? The medical examiner doesn't think that hit anything. And then when they come back in view, they're struggling over the shotgun. The next blast is right here. Major artery here. His arm falls like this. It's useless. And he stumbles away because blood has accumulated from this shot into his stomach cavity. You see, a bunch of ribs got broken, and all this blood is flowing into his stomach cavity at this point in time. But it hasn't stopped his heart, and there's arterial spurt coming out. That's how the medical examiner knows that it was this. At the end of the interview, by Detective No Hilly with Travis McMichael, he asks him this: do you remember if he grabbed the shotgun at all? Because Travis is all over the place. I want to say he did, but I honestly can't remember. Ladies and gentlemen, there's absolutely no evidence that Travis McMichael went, I shot him because he grabbed my shotgun. That's not what Travis McMichael says at all. This isn't about grabbing the shotgun. I want to say he did, but I honestly can't remember. I mean, me and him, we were face to face the entire time. Also of note, Mr. Arbery had nothing on him. No backpack, no bag, no cell phone, no ID, no wallet, no keys, no gun, no weapon. Mr. Arbery couldn't have even called for help if he wanted to, because he had no cell phone on him. There's absolutely no evidence in this case that anyone was making an arrest. Not one single defendant said, Mr. Arbery had a weapon. Not one single defendant said, Mr. Arbery made any verbal threats or gestures. Mr. Arbery said nothing during the 5 minutes he ran from the defendants. Not one single defendant said, I saw him commit the crime of blah, blah, blah today. Mr. Bryan was on his front porch. Travis McMichael was sitting inside his living room. Greg McMichael was in his driveway. What's your emergency? There's a black male running down the street. No one said, I I was making a citizen's arrest today. Not one single person used those words. No one said, I was trying to arrest him for the crime of fill in the blank. No one said that. Not one single defendant ever said, I was trying to arrest him. Or mentioned what crime it is that they actually thought he committed. No one said, I told him that he was under arrest. I mean, come on, how do you arrest somebody? You're under arrest. Put your hands, blah, 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 right? Isn't that how you arrest somebody? You tell them you're under arrest. No one ever said, well, I told the guy he was under arrest for the crime of whatever crime it is. No one ever said that. But here's what Greg McMichael did say, and this is really important because once again, Greg McMichael's talking about February 23rd, 2020. Is he picking up anything, going through anything? You know, not that I recall. I don't think the guy has actually stolen anything out of there. Or if he did, it was early on in the process. No immediate knowledge of any crime in the past or on that day. I don't think the guy has actually stolen anything out of there. Or if he did, it was early on in the process. Meaning I don't have any information about it. I don't know anything about that. No one said we have evidence that he stole items off of Larry English's boat back in November of 2019, so we're trying to arrest him for burglary or theft or anything like that. No one ever talks about Larry English's boat during any of these interviews. Really important. Did this guy break into a house today? Did he commit a burglary today? What did he do today that you have immediate knowledge of? That's just it. I don't know, says Greg McMichael. And look at what he does. He says, well, you know, that's what I told, what's your name out there? I said, listen, you might want to go knock on some doors because, you know, I'm sure he did something. And if you police officers would just go and investigate that, I'm sure you could figure out what crime it was that he committed today. I'm sure you could. Just go out. I mean, you should investigate. Now that we've killed him, figure out what crime it was that he was committing. I said, listen, you might want to go knock on doors down there because this guy just done something because he was fleeing from. I don't know. He might have gone in somebody's house. He might have gone in somebody's house? No immediate knowledge of anything or any crime that Mr. Arbery committed that day. What you don't hear is, I thought he committed a burglary. What you don't hear is criminally attempting to burglarize this person's house, and I personally saw it, like any of these defendants. That's not what you hear from them. The only time Greg McMichael actually uses the word arrest, and he does use the word, uses it one time. But anyway, in my mind, there's a good possibility this guy's armed. That was my thought process. And my intention was to stop this guy, that so he could be arrested or be identified at the very least. Now, let's pick this apart for a minute. But in my mind, there's a good possibility this guy's armed. That was my thought process. The evidence is Greg McMichael needs to be able to explain to the police why he has a gun and why his son has a shotgun. So this is it. I thought he was armed. I really want you to think about this. The evidence is that Greg McMichael assumed the worst. This unknown stranger, this black man who's running down the street, has a gun on him. I want you to think about this. I want you to think about Greg McMichael's.
I object to getting the argument down. We're running an hour and 15 minutes beyond the hour time limit for opening statements.
I'm starting to get into some argument here.
Yes, Judge, I will take it in. The evidence is that Greg McMichael assumed the worst when he said, in my mind, there's a good possibility this guy's armed. This unknown person, he assumes, has a gun on him. And yet his driveway decision is to purposefully chase after and confront a man they now claims he thought was armed. His driveway decision. We'll go ahead and pick apart the statement a little more. And my intention was to stop this guy so that, one, he could be arrested. Notice how he didn't say for what. He didn't say so he could be arrested for the crime of this, the crime of that, or anything. I don't think the guy was actually, the guy has actually stolen anything out of there, or if he did, it was early on in the process. Did this guy break into a house today? That's just it. I don't know. But the alternative for, well, my intention was to stop this guy so they could be arrested, we don't know for what, was, well, he should be identified at the very least. The evidence is that Mr. Arbery is dead because they wanted to know who he was. All right, ladies and gentlemen, we're into the home stretch. So what happens with Glenn County Police Department that evening is they go ahead and they interview everybody. Crime scene tech comes to the scene, takes photos, collects the evidence, collects the shotgun. Body cam video captures initial statements. Travis McMichael is transported down to the police station. He's covered in blood. Greg McMichael leaves the scene with the white pickup truck and drives it back to his house so he can change clothes. Mr. Bryan actually has already left the scene by the time the crime scene tech gets there. You won't see his truck in any of the crime scene photos. He was allowed to leave and go home, which he does, and he begins to work on his porch again. And then they realize, well, maybe we should have done that and asked him to come back to the scene. And then they ask him to please bring his truck to the police station so that they can fingerprint it now. And he did. All three defendants cooperated. Mr. Bryan brought his truck back and showed Detective Lowry, here's where he touched it. Here's the fingerprint place. And they fingerprinted it, and it's Mr. Arbery's palm print on the car. They went ahead and collected the shotgun, took photos of Travis McMichael, interviewed everybody, and then all three defendants went home. The next day, they went and collected video from some people like Mr. Olson. Diego Perez had handed over his video on the day of the shooting. And they reviewed all the video. They reviewed the statements. They even kind of went back out and tried to canvass the neighborhood a little bit. And then the investigation stalled. Now, ladies and gentlemen, the investigation stalling has absolutely nothing to do with whether they're guilty or not guilty. You're going to come back with guilty or not guilty based on their actions on February 23rd, 2020. Suffice it to say, the investigation stalled and nothing happened. Until the GBI got involved. Special Agent Richard Dial of the Georgia Bureau of Investigation was assigned this case on the evening of May 5th of 2020. At that point in time, he reviewed the Glenn County Police Department file and all the videos. The GBI then went over to interview Larry English. They did a thorough canvass of the neighborhood, went through Satilla Shores, talked to everybody. He obtained other evidence to either confirm or debunk tips that were pouring in, speculation that was pouring in, rumor that they wanted to go ahead and investigate. So they do all of those things. Special Agent Richard Dial then made the arrest of Travis and Greg McMichael on May 8th of 2020 for felony murder. Mr. Bryan, who is completely cooperative, Mr. Bryan was really cooperative. He came in to talk to Special Agent Seacrest. Special Agent Seacrest interviewed him on May 11th, then interviewed him again on May 13th. And Mr. Bryan even got in the car with Agent Seacrest and went through a drive through Satilla Shores to show him where he was during this whole entire incident. The problem is by the time we get to May 13th, Mr. Bryan's telling Agent Seacrest, oh, I didn't try and hit him with the car. Arrested defendant Bryan on May 21st, 2020. Ladies and gentlemen, the defendants assumed the worst about Mr. Ahmaud Arbery and made their driveway decisions. They didn't simply follow Mr. Arbery in their truck. There's absolutely no evidence that there was something that kept their white pickup truck from going 5, 6, 7 miles per hour. They didn't just simply follow him. Greg McMichael and Travis McMichael sought to confront Mr. Arbery and took their guns with them to do it. All three of the defendants cut him off with their trucks, or tried to, on Burford. They then used their pickup trucks as lethal weapons. Because when you force somebody off the road, a pedestrian with a pickup truck, you're angling your truck at him, called aggravated assault. All three trapped him like a rat between their two pickup trucks on Holmes. Mr. Bryan coming up from behind, Mr. Arbery running towards Travis McMichael, who's out of the car with the shotgun. Yeah, Greg McMichael's on the phone, finally, with 911 at that point, yes. But Travis McMichael steps out with his shotgun and points it at Mr. Arbery when he's yards and yards away. They worsened the entire situation by threatening to kill him. Stop or I'll blow your fucking head off. That's what Greg McMichael said to.
I'm sorry, I don't mean to interrupt. I hate to interrupt for a moment. This is argument. This is closing argument.
Let's keep it focused on what the state would expect the evidence to show at trial.
Yes, Judge. The evidence that the state expects to show at trial is that Greg McMichael yelled at Ahmaud Arbery, "Stop, or I'll blow your fucking head off." The evidence the state expects to show at trial is this was an attack on Mr. Arbery for 5 minutes, and the only thing Mr. Arbery did was to run away. They assumed that he must have committed some crime that day. "Stop, we want to talk to you," is not an arrest. Ahmaud runs away. They cut him off, try to hit him with the pickup trucks, and the shotgun comes out. Why? Because he wouldn't stop? So they could identify him? So that the police could later investigate what it was that he must have done that day. Ladies and gentlemen, these three defendants committed 4 felonies against Mr. Arbery. And it all started when Greg McMichael saw him running down the street. They committed these 4 felonies in violation of his personal liberty before he finally tried to run around their truck, as you saw in the evidence, and get away from these strangers, complete strangers, who had already told him that they would kill him. And that they killed him. At the end of the presentation of the state's evidence, ladies and gentlemen, the state is going to come back and the state is going to ask you to find them guilty on every single charge in this indictment. Thank you very much.
All right, thank you. Ladies and gentlemen, we're going to take a short recess. Let's plan on about 10 minutes, and we'll continue with the presentations of opening statements. Again, during breaks, do not discuss this case amongst yourselves. Don't go looking for any information about the case. And all of the other instructions that I've provided you will apply. Thank you.
So rise for a jury, please.
So you've been watching our gavel to gavel coverage here of the Ahmaud Arbery.
The remedy that we were seeking. The state said this phrase, "Then the investigation stalled and nothing happened." That was preceded by the state saying that that GCPD let the guys go home. No one was arrested. And then it stalled and nothing happened until the GBI came in and did their work. Ms. Dunikoski did point out that that should not be held against the defense, but I point out that we litigated this issue. The state filed motion 4.54, a motion to exclude mention or reference to any argument concerning George Barnhill's letter to Captain Tom Jump, of the GCPD or his meeting with GCPD about this case or Barnhill's opinion of this case. That got expanded to the notion of whether any discussion about Jackie Johnson, and this was before her arrest, could be addressed. And in open court, the court accepted the agreement between the parties on the record that we would not be addressing the time lapse that was between the date of February 23rd and the May arrest. In fact, we knew that one of the reasons was it was incendiary, and especially after Jackie Johnson's arrest. So it was so important and so critical that we included it in voir dire, and most of the people who responded raised their hands and said that they had an opinion about the lapse of time and were questioned about what they knew about that. And many of them had knowledge of some connection, they believed, to Greg McMichael. And again, I point out the court's bond order denying bond, in which one of the reasons set forth by this court was a connection that this court drew between that lapse of time, Jackie Johnson's decision concerning the way she handled her recusal, and that the McMichaels, specifically Greg McMichael, may have played some role in that. I can pull the bond order up a little later. There's no written order, so we are not moving for a mistrial for the court for the state having violated that agreement that the court accepted as a resolution to the state's motion. But what we are asking is that the court know that the state cannot introduce evidence that suggests that there is a time lapse or that nothing happened or that GCP didn't act, and then just leave it hanging out there for the jury to draw any inference from. There should simply be, based on our discussions with the state, the GCPD investigation, and then whatever it is they believe that's relevant about what the GBI did, with no comment and no evidence concerning that time lapse. That's number one.
Let me just.
Thank you, Your Honor.
We join in the motion, Your Honor, and we might want to address it when she's done.
Well, no, let's address the defense side of it, and let's instead of ping-ponging this back and forth.
May I just go as part of the McMichael team?
May we confer?
No, I don't want to confer. You can make yours. I'm going to make an additional statement. That's all.
Okay.
Go ahead.
Well, if I could have a moment, I want to make sure I'm not mistaken with something.
Just so I understand the request, what I understand is you are trying to put a finer point on and clarify what the agreement was with the state. You're not asking the court at this point, excuse me, for any type of instruction, or I just want to make sure I'm clear, or we're just putting it on the record and making sure that we're all on the same page, as I understand it.
Well, I'm very sure about what the direction was and what the court is making sure that the state intends to comply with that. An opening statement is supposed to be a window into the evidence they're going to present. So it concerns me as if they would be presenting evidence in support of what they argued in their opening statement.
Okay, understand.
You know, my inclination was to go ahead and make the motion for mistrial. I don't know why we're not doing that. I don't think we're going to be able to unring the bell that has been rung by the prosecution a moment ago. And I'm sure there's an explanation for it, but it sure seemed to me like a violation of the prior understandings upon which we would try in this case. I couldn't even begin to suggest a curative instruction. I don't know how you fix the problems. But the bigger issue, for me, Your Honor, beyond that, just anticipating your court's not likely to grant a mistrial before any evidence is actually heard of the case. You know, we had a fairly lengthy discussion the other day. I filed a motion in limine. I sat here with the written motion to sever ready to be filed. And, you know, we backed away from that. I brought to the court my concern about this after the fact conspiracy and how, regardless of the state's intentions, you're not going to be able to separate this thing with Jackie Johnson from the police department from the lapse of time from the other stuff. So, you know, even if the state doesn't grant a mistrial, the state has pushed the Bryan defense closer and closer before they've even started presenting evidence to a severance. Because how would we avoid from Mr. Bryan the spillover effect of all this other prejudicial extraneous matter, which now the state has put out there in opening and cleverly, I think maybe not as clever, I mean, maybe not cleverly, maybe we'll leave that for later. But we have tied in through the voir dire process by implication the knowledge of the jurors about the unindicted fourth defendant and the lapse of time. I think it leads back into all those examinations of the individual jurors. And how do you unring that bell? So, you know, even if the court doesn't grant a mistrial, I just putting the state on notice or the court on notice. I mean, I think at this time, Mr. Bryan's entitled to a severance if he wanted. I haven't had a chance to confer with him, but I mean, they put us in that situation, and it's just unfortunate. And that's that matter. I have a second matter, but I'll sit down while we finish the first.
And I just want to add what I understand to have happened, because we did have this conversation where during the presentation of evidence, the state would question Officer Lowry, Investigator Lowry, about what happened on the 23rd by the Glenn County Police, maybe the 24th, and then just end it. Not talk about the lapse of time as a factor in this matter. And what Ms. Dunikoski, in fact, did is talk about the investigation stalling and nothing happening until the GBI got involved, which is factually incorrect, because we know Glenn County Police sent audio and video off to be enhanced. We know they did other things, canvassing neighborhoods and things like that. So not only has she reneged on our understanding of an agreement, but she's now said something factually incorrect that it's incumbent upon us to correct, which is questioning officers about what they did after February 23rd, after February 24th, 2020, because they in fact did continue to work on the case. Ms. Dunikoski has now misled the jury and rung a bell and asked them not to listen to it.
I'll assume that's.
I'm only standing so that I don't have to.
I know, but Mr. Sheffield had started, so I understand Mr. Rubin addressed the issue. Well,
I'm just gonna.
Yeah. No, I was not suggesting we have two lawyers for the same party jumping up. Okay. All right, from the state.
Thank you, Judge. The state had filed motion 4.54 to exclude mention of reference to our argument regarding District Attorney George Barnhill's letter to Captain Tom Junt, Barnhill's meeting with Glenn County about his case, and Barnhill's opinion about this case. That was the motion in limine. The state did agree that we weren't going to go into Jackie Johnson. This was before her indictment. However, the state objected to the voir dire question about the time lapse, because to the state that inserted the issue in the jurors' minds about the lapse in time. The state felt the question of, do you hold it against the state with the Jackie Johnson situation? Do you know George Barnhill? All those questions, no one from the defense objected to. But Judge, more importantly, it was not the state's intention to put anything before these jurors. We all know that nothing happened after the 23rd and 24th. There are a few things that did take place, and Parker Marcy is going to testify to that, because he did send away video to ROCIC, and they did enhance it, and I just played it. So the things that Glenn County PD did in the time frame between February and May, that's going to come in because Parker Marcy is going to testify about that. I was simply trying to segue between, hey, they took these interviews, they did all this stuff, and then the next thing happened was this. I thought the most delicate way to do that was to say the investigation stalled, nothing happened, the GBI comes in on the 5th. And once again, what I say in opening is not evidence. So right now, in my opinion, I have not violated any agreement I had with the defense in any way, shape, or form by trying to delicately segue between all of this stuff happened on February 23rd and 24th, and then the GBI comes in on the 5th with a simple segue that certainly doesn't open the door to anything they have to rebut and or address, simply because Glenn County is going to talk about what they did in the interim. And we all know that the GBI came in on the 5th. So I didn't mention Jackie Johnson. I didn't mention Barnhill. I didn't mention any of the things Mr. Goff says. So right now, the state's in total disagreement that the state violated any agreement with the defendants. And there's no need for anybody, I think, to introduce any evidence of anything, because we are going to introduce the evidence of what Glenn County did do in that interim. And then the GBI came in on the 5th, and Dial and Seacrest and Kelly will testify to what they did at that point in time. We ask that you deny Mr. Goff's motion for a mistrial or for any other curative instruction. I'm not really sure what the defense is asking for.
Curative instruction, that's what I was clarifying.
Yes, Your Honor, we don't want to re-ring the bell. I respectfully disagree that that was a delicate and smooth way to transition. The delicate and smooth way to transition would be, since this was opening, to let the jury know that she expected the evidence to show here's what GCP did, and then in May, here's what GBI did when they came in. So my request to the court is to either inquire of or to make sure that the order is secure that the court accepted, and that was, we are not going to discuss in any way this period of time and characterize it as a stall, a lapse, or an absence of activity or action.
And I think I heard that from the state. Ms. Tonkowski, I think I also heard that it sounds like there's a disagreement about how artfully the transition was made from the GP, from the Glenn County Police Department portion of the opening to where the GBI came in. Lawyers have a lot of opinions about how artful language may be, and whether it was smooth or not. I think I understand what the motion is. My understanding is that that is not going to be that this period of time that occurred between the initial incident, as I think it was defined, and the arrest was not going to be brought before the jury as a part of the case in chief.
With the exception of whatever Glenn County PD did as part of their investigation, sending things off to RCIC.
Yes, obviously part of the investigation. That's my understanding of where we are.
Thank you.
Okay, so that's clear. As to the mistrial, the court is not going to grant the mistrial on this matter. Or they get another matter.
Yes, Your Honor. Because it's still fresh in our minds, I want the court to note that we're moving the court to reconsider the order granting the state's motion for a 3-hour closing argument, because what we just heard today was an hour and 35-minute opening that had a whole lot of closing in it. So because that's the case, I don't believe there's any legitimate reason to allow the state to do this again, while the court did sustain, I believe, both of our objections to the way that Ms. Dunikoski was presenting the opening statement. The only remedy that makes sense, even though she continued to do it after you sustained the first objection, is to limit the opportunity for her to basically re-close even longer at the end of this trial.
Was that motion? You said the motion will be made. I assume you said the motion will be made.
No, I didn't mean that. I am making the motion now so that you can be aware of it while everything that just happened here during opening is still fresh in your mind. Thank you.
Oh, I'm sorry, I didn't schedule that.
Did you want to comment on that?
No, a different matter. But it's not completely different. I take that back.
I'm assuming if one of the defendants has made a motion that the state's going to have an opportunity to respond before we get into separate matters. When you stand up before the state responds, I assume that you're joining or adding. So from the state.
Thank you, Your Honor. You did sustain both of the defense's objections to my opening. The fact that it took me an hour and 35 minutes to explain all of the evidence I anticipate is actually the reason I need 3 hours for a closing argument. And that closing argument is not going to take place this week and or next week. It will be probably 7 to 10 days from now. So the state requests that 3 hours for closing argument. The state does anticipate splitting that, and hopefully will not use all of it. But the fact that there was this much evidence involved in this case, and it took me that long to get through it, means I really do need those 3 hours. Thank you, Judge.
Yeah, at this point, the court's ruling remains. Motion for reconsideration is denied. We'll get into the evidence. If for some reason the court needs to review that, I'll go ahead and do so. Mr. Sheffield,
Yes.
You had a separate matter?
I had to.
Mr. Goff.
Your Honor, I'm asking that the defense be allowed similar length and latitude in opening statement. And since I know the court is concerned about scheduling, I will be deferring my opening statement to the conclusion of the state's presentation of evidence. And I fully expect the same hour and 15 minutes to hour and 30 minutes that the state took, and the same latitude in statement as opposed to argument that the court so graciously allowed the state.
Sure, how to respond to that. If an objection is made, I would suggest that we stick to what you, let me back up. So I normally don't think it's a terribly, the optics of this in front of the jury, particularly when they're sitting and listening to openings, a lot of interruptions, a lot of objections, because most lawyers that we have, particularly in a case like this, have tried a case before and understand what an opening statement is. A couple objections were made and the court sustained those because we were starting to get into argument. It is an opening statement. So Mr. Goff, if your plan is to get up and argue the facts of the case and you're letting the court know that, I will tell you that the court does not expect you as a seasoned trial lawyer to be arguing the case in opening. I would expect you to do your opening in terms of what you would expect the evidence to be. Tried to guide the state towards that without the court jumping in or having to spend a lot of time on motions. And I hope that everybody else will be able to tailor their statements to the evidence. There's always going to be a little bit of argument in an opening statement. That's just the nature of the beast. That's just what lawyers like to do. But if it looks like we're just arguing the facts of the case, I would suggest that you reconsider what is going to be presented to the jury so the court does not have to interrupt or otherwise get involved, or other counsel doesn't either. Because I think from a jury standpoint, for them, they'd like to just hear the positions of the parties without interruption. And they have been instructed on what an opening statement is. And so they're expecting simply to hear what the evidence will be in the case. And hopefully at this point, they understand that evidence will be presented, and that's up to the advocates here to do. And then you'll have a full opportunity to argue the case once the jury has been presented with the facts.
And rest assured, Your Honor, I have no intention of presenting a closing argument in my opening statement. However, I will be guided by the state's presentation, because as the court well knows, there is sometimes a fine line between a statement and an argument. And I'm just asking for consistency.
I'm done talking about it. I explain what the court is on it. I would like to get through opening statements so that the jury has an understanding of what the party's view of the evidence will be. And the more we simply talk about how that's done, the less time we have to actually bring the jury in and do what we need to do in front of the jury, which is present the case. We've now reached the point where I don't think it's realistic to get into the opening statement from Travis McMichael, because we've managed to push further into the day than I thought we would. So we're going to break for lunch. I assume everybody will be ready to go in an hour, and we'll go ahead with the opening statements in an hour, but I need to bring the jury back in. So I'll bring the jury back in. I'm going to break the jury and let them know that we are taking a lunch break. We can go ahead and get the panel. Yeah, whoever did that, thank you.
In engaging what is now unlawful in the state of Georgia, right? It's important to keep in mind that after Ahmaud Arbery's killing, the state of Georgia outlawed citizens' arrests, right? That they were simply trying to engage in a citizen's arrest because of alleged burglaries that were happening in that neighborhood. You know, the evidence will show that there hadn't been 7 weeks between the previous call for an alleged burglary, right? So how imminent was the danger that these 3 men felt when the previous call for an alleged burglary wasn't but 7 weeks later previous? So there is a mountain of evidence that the defendants need to overcome, and the prosecution did a very good job.
Danielle, we're going to take you right inside the courtroom. They have just begun. Follow with us. Thank you.
Towards me? Okay. Good afternoon. For those of you who may not remember from 2 weeks ago or whom I never met, my name is Bob Rubin. And along with Jason Sheffield, who I think y'all met, we represent Travis McMichael. This case is about duty and responsibility.
I didn't want to interrupt you. I was trying to get your co-counsel, but if you could get, you can understand you may wander. If we could try to get close to the microphone for the court reporter.
Yes, sir. It's about Travis McMichael's duty and responsibility to himself, to his family, and to his neighborhood. And it's about your duty and responsibility as jurors. The state talked about actions based on assumptions. I'm going to talk about facts. Facts in this case. Travis McMichael is 35 years old. He's single, and he has a 5-year-old son named Everett. From 2007 until 2016, Travis McMichael was in the United States Coast Guard. He was a boarding officer in the Coast Guard, which means he was authorized to make arrests. He was authorized to do investigations. He was authorized to do searches. He was authorized to use his weapon when appropriate. In order to become a boarding officer, he attended FLETC in Charleston, the Federal Law Enforcement Training Center. You all know that acronym. At FLETC, he took the training that allowed him to do the law enforcement activities that he did for 10 years or 9 years. He learned how to do searches and seizures. He learned what probable cause was, a legal term that you'll hear more about. He learned how to use firearms in a safe, effective way. He learned how to use force in compliance with his training. The training he had was not just classroom training at FLETC. It is scenario-based training. It is repetitive training so that if you're ever in a real-life situation where you need to make use of force decisions, you're relying not just thinking back, you're relying on muscle memory. Because those split seconds are often the difference between life and death. But not only did Travis McMichael get training at FLETC in all of these law enforcement activities, searches and seizures, investigations, report writing, use of firearms, use of force decision-making, But every year he was in the Coast Guard, he had additional training. And every year in the Coast Guard, when he became efficient enough, he then became a trainer of the trainees. He was training the trainers. He was training his fellow Coast Guardsmen on the law enforcement activities, on how to be a boarding officer. After he left the Coast Guard, and in 2020, Travis was working for Metzen Marine as a coxswain. He's working at the naval base, moving boats around. He was living at home with his mom, Lee, and his father, Greg, his sister, Lindsay, and his son, Everett, who was then 3 years old. He was living at home because the apartment he was living in previously had been sold by his landlord. So he needed to live back at home, save some money so he could go back out on his own again. He was living, as the state told you earlier, in Satilla Shores. This is a low-tech map of Satilla Shores because I don't trust PowerPoint. You'll see a PowerPoint, but I don't trust it that much. So this is a regular map of it. Google Earth map. Highway 17 up here, Satilla Drive here, 230 Satilla Drive. This is just to acclimate you. This is Jones Road, and I know it's hard for all jurors maybe to see this, but you'll see this many times throughout the case. And we'll talk more about the rest of it. But he lived on Satilla Drive in Satilla Shores. Satilla Shores is a quiet, scenic, middle-class neighborhood. The kind of neighborhood where parents let the kids ride around on their bikes. The kind of neighborhood where when you're my age, you go for a walk after dinner. The kind of neighborhood that we all kind of aspire to live in. It's safe, it's beautiful, you work in the yard, you play on the river. This is the family and community that Travis McMichael felt a duty and responsibility to during the course of events in 2019 and 2020. This is the family and community that made him willing to put himself at risk to help the police detain Ahmaud Arbery. The video that you watched probably 5 times in the state's opening statement doesn't even begin to tell the story in this case. It's like looking through that knot hole in the fence and thinking you see the whole baseball field when you really only see the outfield. The case really begins months before in 2019 because Satilla Shores was a neighborhood on edge. Crime had gone up. It wasn't violent crime. It was property crimes. The kind of crimes that are unsettling. The kind of crimes that are scary. Because you don't know who's coming onto your property, who's in your car ransacking it, who's breaking into your buildings, who's stealing your lawnmowers or your guns. And so the neighborhood was on edge. So much so that behaviors began to change by the neighbors. Kids were not allowed, some kids, to play outside after dark. Residents of Satilla Shores installed home surveillance cameras to catch the thieves that were taking their property. And neighbors in Satilla Shores felt a duty and responsibility to each other to post on the neighborhood pages, Facebook and Nextdoor, about the crime that was happening. And you'll hear about that. The types of posts that you saw on these pages includes, "This is ridiculous. My daughter always freaks out. It's getting old. I'm nervous. Lock your cars." These are actual posts from that neighborhood Facebook page. As a result of this uptick in crime, of people being on edge, people were alert to suspicious behavior. In July of 2019, Travis McMichael and Greg McMichael were alert to suspicious behavior, long before ever encountering Ahmaud Arbery. In July of 2019, Travis McMichael, who was at that point running a little charter boat, taking people out, tourists out on the river in the marshes, was on his boat with some guests when he went under the Fancy Bluffs Bridge that you heard about earlier. There he saw a homeless man who had lots of stuff around him in a tarp. Stuff, the kind of stuff that made Travis look twice and made Travis feel suspicious that maybe this was the guy who was taking the stuff out of our neighborhood. So he dropped off his guests eventually, went home, got in the car with his father, Greg, and they drove to the area under the Fancy Bluffs Bridge. There they saw the man. And what you see up here is the call, basically what's called a CAD report. It's basically a report made of Greg McMichael's 911 call to the Glenn County Police to say, hey, basically, there's a guy under the bridge we think is responsible. Could you please investigate? And the police did. They sent an officer out there, and really nothing of note was found. And the investigation ended. But the break-ins, the theft, didn't end, especially for a man named Larry English. For Mr. English, it was only beginning. Larry English, as you heard, lives in Douglas, Georgia. He was so excited to have a weekend home in Satilla Shores on this beautiful little Satilla River. He built a home. He was going to use it for weekends and vacations with his wife, Amy, his daughter, Laura, his son, Hoyt. And so it took time, delays and all that with contractors and himself having issues with health. But he started building a home in Satilla Shores for use as a vacation place, a getaway. He built a dock. His home is right here, the dock on the river. He had a boat on a hoist at the dock, and he had a large offshore boat in his RV garage. In that garage, and I promise not to touch the screen, is this large garage. But that's where he kept, it's called an RV garage, but it's really a boat garage for Mr. English. Eventually, because of some advice from his neighbor, Kenny Wade, who lived next door, he installed a camera at the dock and one on the back of his house, which you can't see from this photo. He was concerned about liability because kids were playing out there and they would take his scraps of wood. They would hang out by the dock. But he was also concerned about theft because he had valuables at his house. He had 2 boats, sometimes 3 boats, and he parked his camper on the property, which you can't see in the picture, but you'll see eventually. His camper that he stayed in, sometimes alone, sometimes with his wife and kids, when they came to the house either to work on it or to play at it. So he was concerned about all of this when he installed those cameras. Over the course of the next 3-4 months, he saw on his cameras at night Ahmaud Arbery 4 times. The first time, and this is the first time his camera alerted at all, was October 25th, 2019. Now remember, he's in Douglas, Georgia. He has a cell phone. When his camera spots somebody, he gets an alert on his cell phone. This is a photograph of Ahmaud Arbery on his dock, October 25th, 2019. He gets this alert. He sees this man. He calls Glenn County Police Department. Can't call 911 because 911 would go to Douglas Police. But he calls the 911 number for Glenn County Police. And he's scared. And he's concerned. What is this guy doing at my house at night? There is no legitimate reason, according to Mr. English, for this man to be at his house where his boats are stored, where his camper is parked at night. And he calls the police. He's concerned not only for his stuff, but he's concerned for his family. Because what if Amy was there at the camper alone? What if his daughter, Laura, was there sleeping there that night? And she walks outside and bumps into this intruder. And he gets scared and he panics and she panics and something really, really awful happens. These are the thoughts that went through Larry English's mind when he sees this intruder in his house on October 25th, 2019. He calls back Glenn County a second time after this initial call. Go back a little bit. Okay. Because he calls the police to tell them that the man who's on the dock, and he describes him as plundering around, describes his tattoos, describes his hair twists. The man who was in his house plundering around has now gone across the street towards his other neighbor's house. He describes it as a, I think, whitish, yellowish house. It's Subi Lawrence's house. It's a neighbor he knows. Subi is a single mom. She's a mother of 3 boys. The boys who play outside and ride their bikes and steal Larry English's scraps of wood for their skateboard ramp or their fort or whatever they're doing. This is who Mr. English sees and who he's concerned about. And he wants the police to confront this man and tell him, don't come back. He doesn't see him take anything. Remember, he's only got cameras on the back of the house right now. 1 camera, back of the house, and 1 camera at the dock. He wants him removed. By the time police come, and I think it's Officer Rash who responds that first time, Robert Rash, and you'll hear from Officer Rash. No sign of Mr. Arbery. It's the man we later find out is Ahmaud Arbery. No sign. Now, he's okay with curiosity seekers coming to his house. We've all done it. See a house under construction. It looks kind of interesting. Oh, what are the neighbors building? What are they adding on? What's the staircase going to look like? He's okay with all that. He's okay with the kids coming in during the daytime, taking the scraps of wood. It didn't matter to him. What concerned him was there is no reason that's legitimate to be there at night. And that's why he calls the police. Sometime after October 25th, Mr. English is on a ladder in his RV garage, looks in his offshore boat, and realizes his satellite system, his Yeti cooler, and his microphone system are gone, taken out of the boat. He doesn't know who did it. He does know the HVAC guys were in that area installing some of the not pipes, some of the system in there. He also knows the black male from October 25th was in there. And so he's suspicious. But what can he do? The next alert on his phone is November 17th. Okay, November 17th, a white couple comes on his property at night, 10 o'clock at night. They park out by the porta potty that you saw in the earlier picture. The man has his belt unbuckled. odd. Comes in the house and he calls 911 and he says, about a week and a half to 2 weeks ago, I had my stuff stolen. This is now November 17th. Week and a half, 2 weeks ago is pretty close to October 25th. I've had my stuff stolen. They're in the same area. They're going around where the boat is in the RV garage. Police send an officer out. Officers go out. The couple's gone. They see nothing. Mr. English is upset and he's frustrated. He has valuables stored at the house. Stuff has been stolen. Now 2 people have been seen on his cameras, 3 people, 2 white people and a black male. And so the next morning, November 18th, he goes and he gets his boat and he hauls it away. Figures, I just can't keep valuables in this house that's open, but is owned by him with his valuables. And so he takes the boat away. That very night, November 18th, he sees the same black male he saw on October 25th. The man we now know is Ahmaud Arbery. He's back again. He's seen around the boat, not the big offshore boat, but the other boats. And according to Mr. English, he's plundering around again. He calls Glenn County Police again. Glenn County Police arrive again. And again, Mr. Arbery gets away without being confronted by the police. And Mr. English is frustrated. Of course. He's so frustrated that the very next day, November 19th, these are all out of order. And this is why we don't use technology. All right, November 18th, 2019. This is the night he sees Ahmaud Arbery for the second time. There's somebody back on the property again tonight. Black man, not wearing a shirt in late November, got tattoos on his arms and a pair of light-colored shorts. He's wandering in the carport, looking in the boat, not the offshore boat, the smaller boat. The same guy that was here about a week and a half, 2 weeks ago. The night before, he's calling police saying, my stuff was stolen a week and a half, 2 weeks before. He kind of looks like he's up to no good. He's on 3 different people's cameras in the neighborhood. This is Larry English's 911 call on November 18th, 2019. November 19th, the very next day, he has an exchange through text message with his 2 doors down neighbor, Diego Perez. Diego Perez is another person who believes it's his duty and responsibility to look out not just for himself, but for his neighbors. And so Diego has this conversation with Larry English. This is a printout from an extraction from Larry English's phone. So, and you'll see this in evidence. And it's out of order, the way it's printed out. So I'm going to kind of walk you through it, because the first exchange is from Larry English. He sends Diego Perez clips of the videos from the white couple on the 17th of November and the black male on the 18th of November. And he says to Diego Perez, who he just knows as Diego Satilla Shores, that's how he's in his phone. They're not friends. They're just neighbors, good neighbors. And he says to Diego, have you seen these people in the neighborhood? And Diego says, no, sir. I can't say I've ever seen them in the neighborhood, but I'll keep an eye out. I can respond in mere seconds because he's only 2 doors down. With your permission. Larry English says, you have my permission. And Diego says, I may be able to intercept them or pen them up for the police. I may be able to intercept them or pen them up for the police. Diego Perez is taking it upon himself, if he can, to perform a citizen's arrest. I'm going to hold them until the police come. And Larry English's response to that, thank you. Because seconds count. Diego Perez knows it. Larry English now knows it. Because 3 times he's tried to catch his intruders, and 3 times he's failed because the police just get there too late. As Diego Perez artfully put it, when seconds count, the police are minutes away. And so he needs the help of Diego Perez and other neighbors. Officer Rash, who responds to these calls, he canvasses the neighborhood. He's trying to catch this guy. And so he canvasses the neighborhood using stills from the video. Have you seen this guy? Do you know him? Can you help me help Larry English? And no one knows him. He's not jogging in the neighborhood. No one's ever seen him. The only time we see Ahmaud Arbery in Satilla Shores is at night on these cameras. And remember, people have cameras in the neighborhood. If he was in there jogging in the daytime, you would see evidence of that. So November 19th, Diego Perez offers to help. Officer Rash canvasses the neighborhood. He's still a mystery. He is at this point a scary mystery because he's plundering around Larry English's house, and now everybody knows it. Officer Rash has canvassed the neighborhood. Larry English is talking to neighbors like Matt Albenzi, like Subi Lawrence, like his neighbor Diego and his wife, Brooke Perez. It's being posted on Facebook, on the neighborhood Facebook page. Word is out that stuff was stolen from Larry English's house, parked in his RV garage. Now, I want to be clear. In May, after Travis McMichael was arrested, Larry English realizes he doesn't really know when the stuff was stolen. It was back in Douglas. It was in the house on Satilla Drive. But what he was telling people in October, November, December, January, February 2020 is that the stuff was taken out of my boat, parked at my house on Satilla Drive. That's what the neighbors knew from Larry English and Officer Rash. He's back at the house, Ahmaud Arbery, on December 17th. This is now the 3rd time seen on camera at Larry English's house. He's at night. He has no legitimate reason for being there. And remember, although you're seeing him through infrared cameras, it is pitch black in that house. There is no light. There's no lights on. There's no light switch, no light bulbs. It is pitch dark. And on December 17th, Ahmaud Arbery is seen plundering around again in the area where the boats were located in that RV garage. Police are not called that night. There's no 911 call. Larry English can't remember why he didn't call police. He may have been sick and not seen this video until much later. And you saw the clip of the video with Ahmaud Arbery walking outside the house, looking around again, and taking off into the neighborhood. And the question remains, was he out for a jog? 10 o'clock at night, December 17th? Or was he doing something else? And we'll never know. But it sure does look suspicious. The next time he's seen in Larry English's house is February 11th, 2020, This is now the 4th time in the house. But this time is different. Because this time it's not Larry English who calls the police. It's Travis McMichael. The state got the facts a little bit wrong. So let me correct them. Travis McMichael was going out that night, about 7:30 at night, it's dark, to get gas, fill up his car before the next day. He had to be at work early, so he was just going to fill up his car that night, so he wouldn't have to wake up so early in the morning the next day. On his way up the street, and he's at 236 Hill, this is the exit up here, this is English's house. As he gets up here, he sees a figure dart across the street. And this figure, now he realizes it's a man, is lurking in the shadows 25 to 30 feet from the street, kind of staying in the shadows very furtively, catches Travis's attention. He has no idea who this is. He's never met Ahmaud Arbery. But he sees this guy, and he sees this guy kind of running across the lawn. It's really initially the house next door, kind of a Spanish-style house. He runs across the yard, and he hides behind that red porta potty that you saw in that photograph. Travis is like, this is not good. We know about a guy intruding in Larry English's house. And he stops his car, and he kind of aims his headlights at the porta potty. And knowing there is no legitimate reason for this man to be there, he starts to get out of his car to ask him why he's there. Well, this guy steps out from the porta potty, and he reaches with his left hand, I believe, into his waist, as if reaching for a weapon. This scares the heck out of Travis. He sees this. He's trying to get out, gets in his car, puts it in reverse, stalls because he's so startled, eventually backs up and gets home, where he calls 911, and this is what he says. This is the 911 call. We're not going to play the whole thing because it's too long.
What's your best of your emergency? It's a former girl, 2:30, for a job. What's going on? We got a friend of hers. I was with my neighborhood, and I just called down, running into a house being built. He's out to the farm from well, I turned around, she took off running into the house. What did you look like? The black male, red shirt, white shorts. And you said the house was being built? It's being built. I'm thinking right now, he's in the house. What's your name on the return? Travis McMichael. 230, 137. All right. Where are you at now? I'm at the city, or across the street, in my truck. Up to the house. Crossing that to the right. I'm here to the right. Where's the property at? Red Thorn. Okay. Are you okay? Yeah, I feel. I just told me, when I turned around, going and backed up, he reached into his pocket and ran into the house. So I don't know if he's armed or not. It looked like he was acting like he was. So, yeah, do more for that. Okay. Which pocket did he reach into? The left, I believe. Okay.
He goes on to say later on, it's about 3 or 4 minutes later, so we don't need to waste your time, is we've been having a lot of burglaries and break-ins around here lately. So now here we are, this guy who has seen Travis see him. and seen Travis drive away still has the audacity, the brazenness to go into the English house. Travis is home calling 911. Greg McMichael overhears and he starts going up to the English house. And he's got his firearm with him. And Travis says, whoa, 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 slow down. Turns out Travis ends up going up there with him, and Travis has his firearm. Diego Perez, who by now has been alerted by Larry English with his video clips, he goes out there, he's armed. These neighbors are going to Larry English's house not because it's fun at 8 o'clock at night in February in Satilla Shores, but because it's their duty and responsibility to each other to protect each other, to do what they can to help the police stop the guy who's plundering around, breaking into Larry English's house. Officer Rash gets called. They are all out. Officer Rash, 2 other officers, Diego Perez, Greg McMichael, Travis McMichael, all out trying to find the guy, Ahmaud Arbery, who's now for the 4th time in Larry English's house. Officer Rash appreciates the help. He never tells Greg McMichael, Travis McMichael, or Diego Perez, hey guys, let the police handle this. We got this. No problem. You guys go home. He never tells them, hey, put those guns away. We don't need guns out here. Don't carry guns around here. He doesn't say that. He doesn't say, no, you guys cannot stop and detain this guy if you catch him. That's a police job because it is a citizen's job to help the police. And the law authorizes that. He tells Greg McMichael and Travis McMichael that Larry English says nothing was stolen. But these guys know stuff was stolen. Everybody knows it. Larry English has already told everybody. Subi, Matt, Diego, Brooke, Annette Beasley, Ronnie Olson, Rash has been around. We all know it. Stuff has been stolen. So now here we are. Here are facts, not assumptions. Travis McMichael has now seen Ahmaud Arbery face to face for the first time. At Larry English's house and then in Larry English's house. He's had a firsthand encounter. He knows that Ahmaud Arbery has been lurking around that house for no legitimate reason. Not authorized to be there. He's not working on the house, not doing anything but plundering around the house. He knows stuff has been stolen. It's probably the power. These things have a mind of their own.
Just want to make sure.
He knows stuff has been stolen because Larry English has told everybody that. He knows this guy has the audacity to go in the house despite knowing people are around and watching him. He knows he's possibly armed because he made that move to his left-hand pocket, waist. He has probable cause to believe a burglary has been committed. What is burglary? Let's go back one slide. Burglary is entering a dwelling, whether occupied or not. The fact that it's open without doors means nothing. It's any dwelling, any building, structure, whether occupied or not, without authority, with the intent to commit a felony or theft. You don't actually, to commit a burglary, have to take anything. It is the intent to take something or to commit another felony that makes it a burglary. Travis McMichael has probable cause, based on his training of what probable cause is, to believe Ahmaud Arbery is a burglar. Probable cause. What does it mean? It is the level of suspicion.
Objection. At this point in time, this is I have an objection at this point in time to this being the law, and the law is going to come from the court. And this has not been, how do I put this, approved on any level by the court.
Well, let me make it clear. This is what Travis McMichael understood from his training was the definition of probable cause.
Okay.
So the evidence
Clarify where we are. Ladies and gentlemen, as I indicated to you, the court will actually charge you on the law. During the presentation here, the representation is made on what the law is. Again, the court, you will receive that from the court. You will not be receiving that from counsel. So if we could please couch the argument in those terms.
Yes, sir.
And this is not what I understand probable cause to be. This is what Travis McMichael, from his 10 years in the Coast Guard, understands probable cause to be. The level of suspicion that would cause a reasonable and prudent person to believe that a crime has been committed under the totality of the circumstances. That's it. It's the level of suspicion that you would need under the totality of the circumstances to believe that a crime was committed. That's where Travis McMichael sat as of February 11th, 2020. The next time we see Ahmaud Arbery in Satilla Shores is February 23rd. It's a beautiful day, kind of a warm February day in Brunswick. Travis McMichael, around midday, around 1 o'clock, is on the couch in his living room trying to get Everett to take a nap, 3-year-old son. So he's doing the strategies that parents do. He has Everett every other week. He shares custody with Everett's mom. On this Sunday, he's trying to get Everett to go to sleep. Greg is in the front yard, in the driveway, reupholstering his boat cushions. It is a pleasant, uneventful Sunday morning leading into Sunday afternoon. While they're doing that, Ahmaud Arbery is walking into the neighborhood, not jogging, not running, walking into the neighborhood, walking into Larry English's front yard. Next. Where he stands there, and this is the view from Ronnie Olson's house across the street, where he stands there, looks around, and walks into the house. While he's doing that, Matt Albenzi is in his yard, down Jones. When he's down here, he can see directly into Larry English's yard. He is aware of the break-ins into Larry English's house. He is aware of the items stolen from Larry English's boat. He's out splitting logs. A tree had fallen in his yard, so he's breaking up the tree. He sees this guy that looks like the guy from the video clips. In fact, is the guy from the video clips, walking into Larry English's house. He grabs his gun, puts it in his pocket, grabs his cell phone, walks down Jones to an oak tree. There it is, across the street from Larry English's house. And he calls 911. While he's calling 911, he sees Ahmaud Arbery through the windows in Larry English's house. He doesn't know what he's doing in there, but he knows this guy's been there at night 4 times prior. He knows stuff is stolen. So he's calling the police. He makes, he believes, eye contact with Ahmaud Arbery. The next thing he sees is Ahmaud Arbery sprint out of that house. He is not jogging. He is running away into the neighborhood, possibly armed, based on prior experience. He is sprinting at what turns out to be about a 6-minute mile. It's fast, and he's got long strides. That view is from Diego Perez's surveillance camera. He runs right past Greg McMichael's yard. Greg McMichael sees him. Greg McMichael is aware of the things that have happened that we've talked about. Greg McMichael sees him tearing, hauling ass down the road. And he knows what's up. And he goes inside and he tells Travis, the guy's running down the street. The guy. They know who it is. They're not guessing. It's not some random guy running down the street. It's the guy. And they turn out to be right. It is the guy, the same guy 4 previous times at night. They grab their guns. Now, why did Travis McMichael grab his shotgun? Because 12 days earlier, he confronts this guy trying to help Larry English. And this guy reaches into his pocket like he has a gun. So he grabs his shotgun for self-protection. And he gets in the car, or he walks out in the yard actually, and he sees Matt Albenzi motioning down the street. Same direction Ahmaud Arbery was running in. So he gets in the car, his dad gets in the truck, I'm sorry, I say car, it's a truck, Ford F-150, and climbs into the car seat because when seconds count, the police are often minutes away. The police are not going to catch this guy at the speed he's running. So they're going to try to detain him for the police. What happens after that's up to the police. So they encounter Ahmaud Arbery on Burford. The first encounter is at 307 Burford. This is what it looks like. You saw the video. Oh, let's go back to there. They're there to detain Ahmaud Arbery for the police. This is what the law allows. A private person may arrest an offender if the offense is committed in his presence or immediate knowledge. And that applies to felonies or misdemeanors. But there's a second sentence the state didn't tell you about. The second sentence is, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. That's why Travis McMichael and Greg McMichael sought to detain Ahmaud Arbery. There was no crime committed in their presence. We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee. That's why citizen's arrest is in this case. There are 3 encounters with Ahmaud Arbery on Burford. The first one is in front of Roddy Bryan's house, William R. Bryan. I shouldn't call him Roddy. I don't know. Mr. Bryan's house. Travis McMichael pulls up alongside Ahmaud Arbery and says, "Stop. Whoa. I want to talk to you. What were you doing back there? What's going on?" And Ahmaud Arbery says, "0." He doesn't say, "Hey, man, I'm just out for a jog." He doesn't say, "Hey, leave me alone." He doesn't say, "Back off." He doesn't say, "Hey, calm." Doesn't say anything. He just looks at Travis and he goes back the other way. Travis backs his truck up. He says, whoa, stop. Let me talk to you. Ahmaud Arbery looks at him and bolts. Doesn't say anything. Doesn't say, "Leave me alone." Doesn't say, "Hey, good morning, good afternoon." He just bolts. At this time, there is no gun. The shotgun that Travis bought is stuck between his seats. Greg's gun is on his holster. There's no gun being pointed at Mr. Arbery. There's no like, "Hey, stop," at the point of a pistol or a shotgun. There's no gun. Mr. Arbery's not even aware of any guns at that point because no gun has been shown. They go down Burford. They pull up to him again. And Burford, by the way, Till the drive turns kind of, the little jog turns into Burford. And they go down Burford a little ways more. Whoa, stop. We want to talk to you. Stop. We called the police. Police are coming. When Mr. Arbery hears Travis McMichael say, we called the police are coming, he bolts back the other way towards Roddy Bryant's house, back towards Satella Drive. They stop the truck, put it in park. Greg McMichael does get out and he gets in the bed because he's cramped into the child seat. Travis McMichael gets out and he looks down the road like, what the heck? I want to talk to this guy. It's just been suspected of coming out of English's house. He sees Al Benzie moving. We know it's the guy from the night 12 days before. He's back again. And he looks down the street and he sees Ahmaud Arbery trying to get into Roddy Bryant's truck, to Mr. Bryant's truck. He's interacting with the truck. And he doesn't know who that black Silverado truck belongs to. He doesn't know Roddy Bryant. He's never met him. He doesn't know his truck. So he sees this black Silverado and he sees Ahmaud Arbery trying to get in it, and he expects to hear a gunshot because he thinks Ahmaud Arbery is armed, like he pretended to be on the 11th. And he's fearful that this guy, whose name he doesn't know, will try to shoot the owner of the truck and take the truck. And so that scares him. This attacking the truck worries him. His dad says, Travis, go back, go back. He says, no, Dad, just go around. We're going to go around Zellwood. You heard the name. Goes down Burford. They're down here. They see this interaction back here. They're going to go around Zellwood. They're going to take a left on Holmes. Now, they don't know where either the black Silverado is or what that has to do with anything or where Ahmaud Arbery is. So going down Holmes is not with the intention of trapping Ahmaud Arbery. It's with the intention of strategically planting yourself so you can kind of help the police see the neighborhood. As they go down Holmes Drive at a slow rate, they see Ahmaud Arbery running in front of the truck. Travis McMichael drives past him, doesn't say anything to Ahmaud Arbery, doesn't shout at him, just kind of drives past him, watching to see what this guy is going to do. Again, no gun, no shotgun, no pistol is brandished, pointed in any way shown to Mr. Arbery. 3 times on Burford, they encountered Mr. Arbery. Now once on Holmes, no gun. They go down to the bottom of Holmes, towards the stop sign, and stop the car. They don't know where Mr. Arbery is at this point because he's around a dog leg. That's the picture of Holmes Drive, looking up it from Travis McMichael's vantage, and you can see where the road kind of dog legs to the right. And past that dog leg, you can't see what's happening. But at that point, Travis McMichael can now strategically see Satilla Drive, his road where his family is located, Burford, and Holmes. So if the police get there, which he thinks they're coming any minute, he can tell them, I don't see him in these directions, he's that way. Or I do see him and he's in one of these streets. That's why he stops. While he stopped there, gets out of his truck, Greg is still in the bed, and they see Ahmaud Arbery coming at him. And Travis is like, whoa, stop, whoa, 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 stop. And Ahmaud Arbery keeps running at him. Travis keeps yelling, stop, stop, stop. And then he reaches into his car, and he sees Ahmaud Arbery flip and go back around the dog leg. Grabs his gun and his cell phone. He says, Dad, when are the police getting here? His dad, I didn't call 911. Travis dials 911 and gives his dad his phone. And that's why we have a 911 call, because Travis McMichael had his phone and thought to call the police. Where are they? It's before the first shot is fired. They call the police. That is not evidence of an intent to murder. While Travis is out there, now he has his gun for protection because this guy has run at him, has acted bizarrely, has not said a word yet that he could tell. And now Ahmaud Arbery is running back. Travis's training taught him to show a weapon. Not to use a weapon, to show a weapon, because that is a way to de-escalate violence. In the normal situation, you show someone you have a weapon, you get compliance. You don't need to go any further. And so he stands there at the low ready position, not pointing his weapon, and Ahmaud Arbery is running. And he's running at Travis McMichael. Stop, stop, get down, stop. And this guy is not stopping. And Travis knows that this guy is not going to stop. He's not predictable. He's going to be on him in seconds if he doesn't do something. It's like, please, please turn, please go up Satilla. This is where we are. Ahmaud Arbery had a clear path to Satilla. Travis is down here. He could have cut across there. He doesn't cut across. He's coming at him. And yes, at about 20 yards, he raises the weapon because he knows Ahmaud Arbery can be on him, and he's hoping that by raising the weapon, he will de-escalate the situation. Who's going to attack a guy pointing a shotgun? If he wanted to kill him, that was an open shot. He didn't shoot. He didn't shoot his weapon. He was trying to de-escalate the situation in compliance with his 9 years of training in the Coast Guard, same training police officers get. You see his, let's go back to the one before. The gun is down, and you saw this a little bit. You can see the white forearm of Travis McMichael. Let me move this map. I apologize.
I think you can probably turn this to give them a better look at it.
Careful.
It doesn't even face them. How can we not turn it? It's on wheels.
I didn't say don't.
Okay.
I said be careful because when we've done that before, we lost.
You'll see this in this
Okay, hold on a second.
I'm sorry.
Next time I ask you to stop, please stop.
Oh, I thought you should just be careful.
No, the point is, let's not keep moving stuff around. If you're going to be doing something, just let everybody know what's going on. Okay?
All right.
The point was, last time this was touched, not by Ms. Dudkowski, but generally in other matters before the court, we've lost it. So if we could, before we just start moving things around, let the court know.
I don't touch it.
Well, I know Mr. Rubin doesn't
I'm
touch
not
it.
touching it.
And I don't mean to call it a show. I'm very touchy about, no pun intended, about some of this electronics in here. As Mr. Rubin has alluded to, we've lost connections and all sorts of problems. So we're trying to make sure these presentations flow. So I didn't mean to go to counsel. But if everybody could let me know if we're doing that.
This is a fuzzy picture. You'll have pictures in the video throughout the course of the trial. His arm is down, and you can see the white forearm. You can see the driveway here. Travis, we
haven't lost the sight line there, have we? You're okay over your shoulder now? Okay, that's the other issues.
And I know it's awkward, yeah.
Yeah, okay.
Speak loud.
Sorry. So there's a driveway here, and Travis McMichael is across from another driveway. You'll see it's about 60 feet, 20 yards away. And he knows how quickly someone can cover 20 yards in seconds. An unarmed person can take a weapon away and kill a police officer or a civilian in seconds, even from 20 yards away. Even an armed person from 20 yards away. So he raises his weapon. In the next slide, and you see the distance, because he wants the guy to stop, not because he wants to hurt Ahmaud Arbery. He's not looking for an encounter. If he wanted to hurt somebody, he would have fired on Burford, on Holmes, or now down here at the bottom. Ahmaud Arbery doesn't stop. He doesn't say, whoa, hey, I'm good. He doesn't say anything. And he doesn't stop. Instead, he goes around the truck to the right-hand side, the passenger side, and at that point, Travis McMichael can't see his hands. Remember, he still thinks this guy could be armed because I saw this guy, at least pretend he was, on the 11th. He doesn't know, and he can't see his hands. And his dad, his 64, 65-year-old dad, who's had a stroke, is on the bed, and Ahmaud Arbery could just yank him down or take a shot at him. He doesn't know. So he goes to the front of the truck to get an eye on him. What's this guy going to do? Good Lord, I hope he just keeps running. Go up Satilla. But he doesn't know. So he goes to the front, and within a split second, Ahmaud Arbery makes a left, not a right. Makes a left and is on Travis, such that Travis has no choice but to fire his weapon in self-defense. And that shot is a contact or near contact wound, meaning Ahmaud Arbery is on him. You will hear that from Brian Leopard of the GBI Crime Lab. That first shot, which we can't really see because it's videotaped through two windshields, Rodney Bryan's windshield and Travis McMichael's windshield. They're in front of the truck. When they collide, when Ahmaud Arbery makes a left, he's on Travis, and Travis has to fire. Because at that point, it's his life or Ahmaud Arbery's life. And the only thing, it's weird the way the mind works, the only thing he can think of at that point is Everett. It kind of flashes through his mind. My three-year-old son. So he fires, he pulls down the weapon, trying to get it away because Ahmaud Arbery's not stopped. That gunshot, which he knows was near his chest, at least he believes it in this melee, he pulls it down, pulls it back. You'll see from the video, he goes backwards out of frame because Arbery is rushing him, pulls it down, he fires another shot off frame. You see smoke, you see something spray. And you see Ahmaud Arbery swinging wildly. And he's hitting Travis. You see him hit with his right hand into Travis's head, neck. He is pounding Travis McMichael while Travis is trying to get the gun away. And Travis fires two more times, and you've seen that. It's a horrible, horrible video. And it's tragic. It's tragic that Ahmaud Arbery lost his life. But at that point, Travis McMichael is acting in self-defense. He did not want to encounter Ahmaud Arbery physically. He was only trying to stop him for the police. Self-defense is defined, and the court will charge you later.
Your Honor, I'm objecting again. Mr. Rubin is now giving them the law in self-defense. So
We are allowed to give a law in opening statement, just as the state did in its opening statement.
We need to be very clear because, again, we haven't gone through a charge conference in this case. So let's be clear about it, that this is not the charge. So
I expect you'll be charged on self-defense. And I expect this is what you'll be called, be charged, be told by the judge. A person is justified in using force which is intended or likely to cause death or great bodily harm only if he reasonably believes that such force is necessary to prevent death or great bodily injury to himself or to a third person. At the time the shots are fired, Travis McMichael reasonably believes, because Ahmaud Arbery is on him, aggressively, swinging wildly, grabbing hold of him, grabbing hold of the gun, reasonably believes he is justified and firing his weapon, knowing it's gonna kill him. It's gonna at least hurt him. He knows that. He has no choice, because if this guy gets his gun, he's dead, or his dad's dead. And what's he taught in the Coast Guard at the Maritime Law Enforcement Academy? Never lose your weapon. And that's why he shoots. Travis McMichael, within seconds, encounters the police. Officer Minshew, Officer Duggan, they arrive on scene. He cooperates fully. He does whatever they tell him to do. When they say speak, he speaks. When they say don't speak, he doesn't speak. Cooperates fully. He's distraught. He's upset. You'll see this on the video, the body cam of the officers. There's no glee at having done what he just did. It's awful. He's covered in blood, Ahmaud Arbery's blood. And then they take him down to the station, and he cooperates fully with the police and answers every question. When they tell him to write a map of where he went, he tries to write a map of where they went when they encountered each other on Burford and Holmes. And when they ask him to write a statement, he does his best to write out everything he knows to tell the police. There's been a lot written about this case and Travis McMichael's actions. Doesn't matter. What matters now is the evidence that you're going to hear, the facts that you're going to hear, and the law that you're going to be given by Judge Walmsley. You are now the judges of the facts and the applicators of the law in this case. The evidence shows overwhelmingly that Travis McMichael honestly and lawfully attempted to detain Ahmaud Arbery according to the law and shot and killed him in self-defense. What we're asking you to do is hard, and it may be unpopular, but we're asking you to recognize your responsibility as jurors and being open to the facts and putting aside emotion and listening to the law and applying that and doing your duty. Because we think the only right verdict is not guilty on each and every count in this indictment. Thank you.
Thank you. All right. Thank you, counsel. Ladies and gentlemen, we're going to take a 15-minute recess, and then we will come back for the continuing of the opening statements. Thank you.
Are new not just to the family of Ahmaud Arbery or the family of the McMichaels and their other supporters in the courtroom, but also to some of these attorneys. I mentioned, during the lunch recess, how a family attorney came out who has been studying this case for now well over a year, for months, said that she learned new things during that opening statement from the prosecutor. So we're going to find out a lot more. We know that there's going to be some body camera images along with some of the other images that we saw, the surveillance from Larry English's home. But a lot left to be discovered.
All right, Alex, stay with us. We're going to take you right back into the courtroom.
He was absolutely certain, and he was absolutely right. The guy he saw was the guy he suspected. On February 23, 2020, Greg McMichael was reupholstering boat cushions on the bed of his truck, parked in his driveway, using it as a workbench, pointed out towards his street in the direction he was looking. A quiet street in a quiet neighborhood. in the midday sun on a pleasant February day in 2020 here in Brunswick, Georgia, when a young man ran past him at a sprint. He was, as Greg described him to police that day, and you've heard it now several times, his words, hauling ass. The young man had it hooked up, Greg said, running at a sprint. As Greg reported to police that same afternoon, he wasn't out for no Sunday jog. That man was the same man whom Greg and others, neighbors, Greg's own son, Travis, had seen in that house just a few doors down from his house on Satilla Drive, the house under construction, where surveillance videos, first one, then a couple, and then several, had video recorded him, as you've seen and heard. Not once or twice, but 4 times at night. Not in the bright light of day, but in the dark of night. So what did Greg believe he was doing, this man, in the house on those occasions? What did he think he was doing? Well, Larry English, the owner of the house, had described him to police as plundering around. That same man, Larry English, had reported this to 911, to Greg's neighbors, and to the Glenn County police officer, Robert Rash. And it got to Greg McMichael. This same man who had been captured on surveillance video. As Mr. Rubin told you, infrared lighting, it's lit up for us to see. But if you were the person in that house in the dark of night, you wouldn't see anything except possibly the little red infrared lights of a camera, if that. Inside that house where, so Greg had been repeatedly told by Larry English, Diego Perez, Officer Robert Rash, where he had been told that thousands of dollars of electronic equipment had gone missing, stolen, from a boat not visible to any camera. And so when Greg McMichael said later to police he had not seen him take anything, well, the camera wasn't on that boat from which all the items were taken. And this happened in a neighborhood that had experienced break-ins and burglaries and thefts over many months. And you saw some of those Facebook postings the neighbors had put up. The same guy that Officer Rash had canvassed the neighborhood with a screenshot of him from one of those surveillance cameras, asking people, knocking on their doors and asking them, have you seen this man? Do you know this man? Showed the screenshot of him to Greg McMichael. That same guy that Officer Rash told Greg McMichael, nobody in the neighborhood knows him, nor had ever seen him before in that neighborhood. And then in December, Officer Rash sent a text to homeowner Larry English. And this is what he told him. Your neighbor at 229 Satilla Drive, and it's actually 230 Satilla Drive, is Greg McMichael. Greg is retired law enforcement and also a retired investigator from the DA's office. He said, please call him day or night when you get action on your camera. His number is, and he gives him his cell phone number.
The same guy in that house that Greg's son Travis saw with his own eyes. At that house, yet again, the night of February 11, 2020, just 12 days before the tragic events that bring us here to this courtroom. And on that occasion, as you've heard already, when Travis saw that same man, he made that furtive movement to his pocket in the dark of night in a situation and circumstance that made Travis think, as you've heard, he might have a gun. And of course, he reported that to his dad, who also thought he may have had a gun that night. A signal to both of these men, that movement, that this man may be armed. So on February 23, 2020, 12 days after that night, when Greg McMichael saw Ahmaud Arbery sprint past him on that sunny Sunday afternoon, not only did Greg recognize him as the same guy, he also believed from the manner of his running, sprinting, and the direction from which he ran, the English house to his left and past him on Satilla Drive deeper into the neighborhood, that, as he told police later that same day, he thought he was running from someone or something, that he was being chased just by the manner in which he was running, sprinting. He thought that he had just been spotted, he told the police, in someone's house, in or around someone, perhaps harming someone. Law enforcement trained and experienced for 30 years. Greg noted specific features that he saw as this running man ran past him that matched precisely the man he'd seen on surveillance video before. Young, black, male, 5 feet, 10 inches, slender, muscular, with short hair that Greg described as short dreads, twists, wearing a white t-shirt. There might be a chance, finally, Greg thought, as he told the police later that day, for the police to question this man, to find out, who are you? Why are you here? No one in the neighborhood knows you. And we've had all of these problems in our neighborhood, specifically at that house, but at many other houses. A man who had eluded police up till then, as Greg said to the police later that day, no one could ever catch him, he said to Officer Brandeberry on the street at the scene that day. If only he could be detained long enough, Greg thought, long enough for the police to arrive. So they're using his truck as a workbench. Greg dropped his tools, left his project, ran into his house, called out to his son, Travis. The same guy is back. The same guy is back. Let's go. Believing that he was the man who had burglarized Larry English's house, believing that Larry English's house had in fact been burglarized. He had never been told anything different, never been told there were other places Larry English had taken his boat where his stuff might have been taken. He had never been told anything different. Believing that he may be armed, wearing pants with pockets, Greg grabbed his gun, Travis too, and they piled into Travis's truck, parked there at the house near Greg's truck. And you can see it on video. You'll see it later. They piled into the truck, Travis in the driver's seat. And as you've already heard, Greg, all 230 pounds of him then, he's smaller now, stuffed into a child's car seat, and really not into it, but on top of it. His face almost in the windshield as he's sitting on top of this car seat, strapped into the passenger seat. He couldn't just snatch it out and then jump in and sit in the seat. It was locked in. And as they pulled out to the street to turn right to pursue this running man that they suspected to be a burglar, there stood down the street, not very far away, Matt Albenzi. Matt Albenzi, you've heard, and you'll hear from him. A man who had walked up his street, had seen Ahmaud Arbery in the house, had taken his cell phone, had called the police, and while standing near a tree, looking at the house, locked eyes with Ahmaud Arbery, who ducked down and then came out of the house, and you saw the still photo, was off, running. And when Greg and Travis got into Travis's truck, and we all know this, speech occurs not only with the words that come from our mouth, but with the expressions on our face, the hand signals we give, many of which we know speak words. Matt Albenzi, who was walking up the street, went like that to Travis and Greg. And there he goes. In fact, he's saying on the 911 call that he's on, there he goes. He's running. Waving his arm in a motion that conveyed a clear message to these men that he is the same guy. Matt Albenzi had seen and heard about this guy in that house too. There he goes. The same man. In just a few short minutes, they would catch up to Ahmaud Arbery on Burford. And you saw the one still photo from Mr. Bryan's house, the motion detected photo of the truck and Mr. Arbery. They would catch up to him and they would have the conversations Mr. Rubens just replayed for you and that you'll hear in this case. On Burford Road, tell him to stop. We want to talk to you. Tell him the police have been called. And when Ahmaud Arbery turned ultimately from them without saying a word and ran back the way he'd come, Travis stopped his truck. Greg took that opportunity to get himself out of that car seat and climbed the best he could into the bed of the truck where there's a toolbox that he could sit on. And there he sat, and as Travis drove the direction that has been described, the opposite direction from Ahmaud Arbery, who has by now run back to Satilla Drive while Travis and Greg drive the opposite direction to Zellwood Drive. They're going in opposite directions. And Mr. Arbery is turning back in the direction from which he had come. Mr. Bryan is behind him, watching him, apparently. And Travis drives his truck around Zellwood, not knowing which way Ahmaud Arbery would run, not knowing that he would turn off Satilla and run down Holmes. And up on Holmes, Travis turns. And Ahmaud Arbery and Travis McMichael with Greg in the truck, now in the back of the truck, pass each other. like this. And ultimately, and you'll hear more details throughout the case, Travis parks the truck, stops, and Ahmaud Arbery's out of sight around that dog leg you've seen. And there stood Greg in the back of the truck. And you've heard already from Mr. Rubin that Travis thought Greg had called 911. Greg didn't have a phone on him. Travis dialed it and handed it to his father. And that's where you see him standing in the bed of Travis's truck, looking back now towards Ahmaud Arbery, who's turned around. When you saw the video earlier when the state played it, when Mr. Arbery turns around, he turns back toward the McMichaels. They're already stopped up on Holmes. They're already there. They've passed him. And they're now waiting for the police to come, keeping an eye out for which direction he may go. They can't even see him. And then here he comes back. And there's Greg with his phone to his ear on the 911 call. And as Ahmaud runs towards the truck on the video we've all seen, that's been seen everywhere, that you're going to see many times, no doubt, in this trial. He's on the phone. He's describing to the person at 911 where they are best he can. He doesn't even know the name of the street. He just tells them Satilla Shores near his house. And then you hear him, as Ahmaud gets close to the back of the truck, you hear him yell, "Stop right there. Damn it. Stop." And then the next thing you hear, and the last word you hear him say on that phone is, "Travis." Because by then, Greg has turned as Ahmaud Arbery is running past the truck, and he sees him turn towards his only son. He drops that phone to the floor of the truck, in the bed of the truck. He's now in abject fear that he is about to witness his only son possibly be shot and killed in front of his very eyes. And then that man did something so unexpected to Greg McMichael, so incomprehensible to him. He turned sharp left. He didn't cut right, go across the yard to Satilla Shores and down the street and on his way. The direction, as you've heard, is the only way into that neighborhood with police on the way. No, he turned left towards a man with a shotgun. And he was on Travis instantly. Clearly, it seemed to Greg McMichael, attempting to take the gun from his son. And as any reasonable person would believe, he would take that gun if he could, and he would use it to shoot his son. What happened in this case will, for the most part, though there will be some dispute, but for the most part, be without dispute. The facts, what happened in this case. The why it happened is what this case is about. This case turns on intent, beliefs, knowledge, reasons for those beliefs, whether they were true or not. Were there good reasons to believe them? Were there good reasons to believe that this young man, Ahmaud Arbery, had been in this house where things had been taken and that he may have been the person who took them? Were there good reasons to believe that as he ran past Greg McMichael that day, that he was fleeing from someone or something who had seen him in that house or near that house, which turned out to be exactly what happened? That afternoon, after the tragedy unfolded that we're here for, Greg sat down to give a lengthy interview to police officer Parker Marcy. And Officer Marcy asked Greg, and these are his words, "What was your intent? Should this guy have stopped?" Greg's answer, "To hold him till you come check him out." There was no doubt in my mind, having seen the videos, who this guy was. Still quoting, "My intention was to stop this guy so he could be arrested or be identified at the very least." On that day, at that place, at that time, Greg McMichael was absolutely sure this was the guy. The same guy he had seen on surveillance videos inside a house multiple times where Greg had sound reasons to believe theft had occurred, burglary. Greg was absolutely sure. He was absolutely certain. His suspicions were well-founded. And I'm a criminal defense lawyer. I've been doing this a long time, and I consider a room like this, an American courtroom, to be practically a sacred place. It's in here that the facts will unfold for you. It's in this room where you will decide the truth. And ladies and gentlemen, I submit to you the truth of this case is that Greg McMichael is not guilty of any of these crimes.
Thank you, Mr. Hogue. Mr. Goff, ready to proceed?
Your Honor, we need to take something up outside the record.
Ladies and gentlemen, if you could go ahead and retire to the jury room, we'll just take a brief recess, 10 minutes or so, and then we will continue with opening arguments.
What was going to happen and the order in which they were going to go with those attorneys for making their opening statements. Again, we have heard from the prosecution. We have heard from attorneys from two of the defendants there, the McMichaels, father and son. Again, when it comes to this trial, it's 9 counts, including malice murder, felony murder, aggravated assault, false imprisonment, among several others. The jury was just brought back in after that little housekeeping in the court. And we go back to Judge Walmsley, who's about to call, as the prosecution is about to call, the first witness in this case.
On behalf of defendant William Roderick Bryan, we reserve, that is, defer our opening statement in this matter.
All right, with Mr. Bryan reserving opening statement, is the state ready to proceed with evidence?
Yes, Your Honor, we are.
From the state.
Thank you, Your Honor. At this time, the state will call William Duggan.
I see counsel briefly. Yes, you can go ahead and see.
Now, are you staying?
No one told me anything, so I'm.
All right, we got a little sidebar here. Again, we had the jury come back into the courtroom, and then we saw William Roddy Bryan's attorney there notify the court of that delay formally so the jury could hear that as well. As we see this sidebar, we don't know exactly what's being discussed. Maybe we'll find out. Maybe we won't, but we see the lead prosecutor there speaking with the judge, the defense all listening intently as well. We're getting to the first witness here. It is almost, 4 o'clock here in the East. Shauna Lord, as we see, actually, I'm going to go back into the courtroom, everyone.
We kind of fits and starts sometimes. I'm going to ask that you go ahead and take a step outside the courtroom. You're going to be coming back in just a moment. Thank you.
All right, for jury, please. All right, please.
All right, and we are back because apparently a little up and down for the jury. They were back in their seats for probably only about 20 seconds before Judge Walmsley told them that he needed them out of the room after that sidebar from attorneys. It looks like they have a court matter to take care of. Shauna, I have to ask you, when it comes to Judge Walmsley and every judge, we know, especially in high-profile murder cases, they want to make sure they go by the book.
If I could please just have you exit.
Let's take a listen for just a quick second.
Coming right back in. I just need to address the matter with counsel.
And there you have it. He just said he's got to address a matter with counsel. So we're hopefully about to hear what that matter.
Truth and nothing but the truth.
Yes, sir.
Go ahead, have a seat. Your witness.
Thank you, Judge. All right, please state your name for the record and spell it for our court reporter.
William Duggan, William Duggan.
And it's Officer Duggan, isn't it?
Yes, ma'am.
All right. Is there a special designation that I'm missing, like sergeant or lieutenant or something like that?
No, ma'am.
All right. And how are you currently employed?
With the Glenn County Police Department.
How long have you been with the Glenn County Police Department?
Just over 12 years.
All right. And have you been in law enforcement all those 12 years, or is there some law enforcement before joining Glenn County?
Before that.
All right. So how many years in total have you been with law enforcement?
14 years.
All right. So let's talk about what your current job duties and responsibilities are with the Glenn County Police Department.
Yes, ma'am. I'm assigned to the patrol division. I've been there for my 12 years with the department. It involves regular routine calls, day-to-day calls, thefts, violent felonies, misdemeanors, traffic accidents, etc. Anything that comes our way.
So does the patrol division, is that the division that usually responds to like 911 calls?
Yes, ma'am.
Okay. Any kind of 911 call?
That is correct, from 911 hangups to anything else that's going on.
All right. Now, within the Glenn County system, when you respond to a 911 call, is a report generated based on the 911 call?
Yes, ma'am.
All right. So what happens if the 911 call is kind of maybe unfounded, or like, for instance, you get a call for a burglary, but you get there and it turns out it's nothing. There's an alarm going off.
We would change the title of it with our CAD system, which is the computer-aided dispatch, through our dispatcher, and we would close it out unfounded or something else if it was something not a burglary.
Okay. So you get a response for one type of call, and it turns out it's a different kind of call.
Yes.
All right. Now, have you attended classes or trainings with the Georgia Peace Officer Standards Training Council?
Yes, ma'am, I have.
All right. And we commonly call that POST?
That is correct.
All right. So are you, in fact, a post-certified law enforcement officer?
Yes, ma'am, I am.
All right. So as a post-certified law enforcement officer, what do you have to do to maintain your post-certification?
Standard right now per year is a minimum mandatory 20 hours of in-service training. In-service training is sometimes required courses, which is mandated by post each year, such as de-escalation, use of force, firearms training, and most officers will get more than the 20 hours per year.
Okay. And you maintain your training?
Yes.
All right. Now, have you had any training in the medical field?
Yes, ma'am, I have.
All right. Tell the jury about your training within the medical field.
Since I've been employed or through post-training and other training, I've had at least a minimum of 184 hours of medical training. That ranges from basic first aid, CPR, first responder training, which would be the next level up for more serious injuries that a first responder as a police officer would handle, getting to a scene of an accident or a stabbing or just somebody falling off of a ladder. Also done officer survival, which has a basis in that course of taking care of serious injuries. Active shooter response, which also involves dealing with traumatic injuries, and tactical first aid, which would be dealing with serious injuries, gunshots, whatnot, in an active shooter situation where you have to move and try and assist the survival of somebody during a shooting.
Okay, so when you get called to a scene of, say, a shooting, what's the priority at the scene?
Upon first arriving on a scene of a shooting, you want to make sure it's safe for the officer and for the citizens around you. Once it's determined to be safe by yourself or other officers, then you would secure the crime scene. That could be putting up tape and whatnot and preserving the evidence that is at the scene so it can be processed, analyzed, investigated by follow-up officers and investigators.
Okay, so officer safety is first priority.
Yes, ma'am.
Okay, so even if someone's injured, but it's still a dangerous scene, what happens?
You can't help them if something happens to you, so you got to make sure you're safe first.
Got it. Now, in the patrol division, is the patrol division divided up in the Glenn County Police Department by like areas or zones?
Yes, ma'am.
And what are some of those areas and zones?
They go there's no zone 3, but we have 1 through 11. And they're in various parts of the county. The southern part of the county is what we call as a Baker 9, around the exit 29 area of 95. The northern part would be exit 36. That encompasses Baker 6, Baker 11. To the western part of the county is Baker 8. The southern part, or the southern part from the interchange, exit 36 would be at Baker 6. And then the eastern side would be Baker 5 and 10. And then the island, St. Simon's Island, Sea Island, comprises Baker 1, 2, and 4.
All right, so the Satilla Shores neighborhood, is that Baker 9?
Yes, ma'am, that is Baker 9.
All right, and in your experience, 12 years on patrol, how bad is Baker 9 as far as crime in general?
It has its fair share of calls. It's one of our biggest territories for the Baker, which would have 1 officer assigned to it. It's a large territory, which is usually handled by that 1 officer due to the lack of call volume that is down there.
Okay. So let me try to get this right. Baker 9, which covers the southern part, including Satilla Shores,
yes,
on any 8-hour shift has how many officers assigned in a patrol car?
Usually 1, unless there's an overlapping shift.
Okay. Low call volume.
Pretty much, yes, ma'am.
Okay. All right. So now, as a post-certified law enforcement officer, what do you normally drive?
Usually a marked patrol car, has Glenn County on the side, says police with the emblems, lights on top, visible, not hidden lights. Currently, I'm driving a 2015 Dodge Charger.
All right. And what do you generally wear as a post-certified law enforcement officer?
On patrol, it's full uniform with shoulder patches, a badge present, gun belt, pretty much it.
Do you also wear body cam?
I do. Yes, ma'am.
All right, so let's go ahead and talk about the Satilla Shores neighborhood. What county does Satilla Shores fall into?
That is Glenn County, Georgia.
All right, Glenn County. And back in 2019 or 2020, were you patrolling Baker 9?
No, I was not.
All right. Prior to February of 2020, did you know defendant William R. Bryan? seated over there?
No, ma'am.
Yeah, so you didn't know him prior to that?
No.
All right. Did you know Travis McMichael?
No, ma'am.
All right. Did you know Greg McMichael?
Where's he at?
If you could stand up, I know it's my court reporter there to get the whole thing.
Yes, ma'am. I've had an occasion to meet him.
All right. And when you say occasions to meet him, was that in your capacity as a law enforcement officer?
Yes, ma'am.
All right. And on the realm of scales of relationships, from really, really close best friend over to someone I maybe knew their first name to wave at, where did he fall?
Knew his first name.
Okay. All right, I'm going to direct your attention specifically right now to Sunday, February 23rd, 2020, at approximately 1 to 1:15 p.m. in the afternoon that day. Were you actually working that day as a Glenn County police officer or in some other capacity?
Another capacity.
And tell the jury what that capacity was.
We have our primary functions as police officers, and the community, businesses, organizations will hire us in an off-duty capacity, but with the presence of a full uniform and a marked patrol car for traffic duties, security duties, banks, churches, et cetera, like that. On that day, I was working, or I had completed a shift working for a local church.
So sort of an approved second job as service to the community, like at the church?
Yes, ma'am. Correct.
All right. So how were you dressed that day?
Full uniform as previously described.
All right. And what vehicle were you in?
I was in a 2015 fully marked Dodge Charger.
All right. So I'm going to ask you this. Did you respond to the homicide scene at the corner of Holmes and Satilla Drive in the Satilla Shores neighborhood on February 23rd, 2020?
I did, yes.
All right. So where were you at and why did you go to that location?
On the way home from the off-duty job that I was working, I had stopped at a local business to pick up some lunch, and had gone across the street to pick up some drinks. And while I was obtaining my stuff in the drive-through, the radio was on as required, and I heard Officer Minshew come across the radio advising of shots fired, and a person was down on the ground in the street. I knew where he was located at, which was approximately maybe 2 miles away. The jurisdiction, the location of his beat, Baker 9, I knew the closest backup unit to him was probably 9 to 10 miles away at the closest. They would have to come from exit 36 area. So I immediately responded to assist him.
All right. What did you find when you arrived at the corner of Holmes and Satilla Drive on February 23rd, 2020? Just describe it for the jury.
When I arrived, there was Officer Minshew's patrol car was parked at the intersection. I parked a little bit to the right back of him. I saw him out walking around. I believe he was beginning to take some pictures of the scene. I did see a black male laying on the ground in the middle of the roadway on the pavement. There were a couple of other people walking around, milling around. There was a vehicle in the road further back past the person that was down on the ground.
Did you see any firearms or weapons?
Immediately upon arriving, I did not notice anything at the initial on-scene response.
Okay. And the only officer there when you arrived was who?
Officer Minshew.
All right. Prior to coming in today, you and I have spoken, obviously.
Yes, ma'am.
All right. And did you get the opportunity to review your body cam video from that day?
Yes, I did.
All right. When I showed it to you, was it a fair and accurate depiction of the body cam video of your actions on the afternoon of Sunday, February 23rd, 2020?
Yes.
Now, with body cam, when you hit the button and it started, what kind of technical issue with your body cam happens?
When they're in the on position, to activate them manually, you'll double press, double tap the center of the camera, which will activate it. You'll hear a beep, and then it'll start recording audio and video. Prior to that, in standby mode, when it's on a continuous loop, which means it's always recording, but with no audio. Upon activating it, either by lights or some other technology that'll activate it simultaneously, it'll record 30 seconds prior to with no audio upon activation. So the last 30 seconds I was just talking to you, if I had my body camera in standby mode, you would see my hands moving, people blinking and whatnot, but no audio. And upon activating it, the audio would start from there with 30 seconds prior of no audio.
Is that what happened with your body cam video?
Yes, ma'am.
All right, at this time, the state would tender into evidence State's Exhibit 219, Officer Duggan's body cam video.
No objection.
Subject to the court's prior rulings. And may I say, could we get the mic a little closer? It's very difficult to hear this far away.
Okay, for the corner, and I've checked with the deputies a couple times. I know that we're not having, I understand everybody can hear on the jury panel, so we're good there. It must be that corner.
I think it's this corner, maybe the acoustics. Thank you, Your Honor.
Yeah, if we could, or if there's any way to turn that mic up, we'll try to do that. If I could just get you to speak right into that mic so we can get you.
Yes, sir.
No objection, subject to the previous rule.
Thank you. All right, it's admitted. What's that number again?
This is State's 219.
Thank you.
I believe you'll be able to see it right there in the monitor.
Okay.
Let's stop it right here. At this point, when you were moving your hand and pointing it.
Hold on a second. Let's see if that catches up. That's off. That's something that's already been loaded onto the board, right?
Yes.
Okay.
Yeah, mine was kind of, Your Honor,
Is yours,
also
yeah, yours is jumping?
It was jumping around a lot.
That one's jumping and mine's jumping.
Oh, there's a little lag on that television?
Yeah.
All right, cool. Hopefully it'll load up while I'm asking the question.
Yeah, let's see what happens.
Okay. So, Officer Duggan, at this point in time, you see the man here. And
Yes.
is there another person seated over here?
I believe so, yes, there was. I see the one in front of me with the jeans and the light colored shirt. And I believe there was a second person over in the shadows. And
What did you say to the second person over in the shadows, if anything?
I know I made a motion to the gentleman walking towards me to just hang back. And I'm pretty sure at the time when I saw Mr. Junior on the side, didn't know who he was at the time, but I could see he was covered in blood. There was blood all over. And I remember at some point asking if he was okay.
And what did that man covered in blood, seated over there, say to you when you asked him, "Are you okay?"
It was a quick reply of basically, "No, I'm not okay. I just effing killed somebody."
And do you use that profanity with the F word?
Yes, ma'am.
Yeah, I know. They're trying to do something for him.
Let's
It's like,
shut it down for a second. Let's keep, I want to move, just either, we need to figure out, there's a delay there, there's a delay. Are you still seeing a delay?
Yeah, still seeing a delay and the audio was skipping.
It's skipping.
We need technical support since I did vote it onto them on the
Yep.
board.
All right, ladies and gentlemen, I'm going to ask that you go ahead and take a step into the jury room for just a moment, please.
All right, for jury.
You're watching our gavel-to-gavel coverage of day one of the murder trial and the death of Ahmaud Arbery. We are listening to the very first state's witness. The direct examination has been going for a few minutes now. And we also saw, as we bring in Shauna Lloyd, our ABC News contributor, and Alex Brachet, who's outside the courtroom, that we are seeing for the first time.
So you always want to be mindful about that, especially in front of the jury.
All right, Shauna, thank you. Let's go right back into the courtroom. Judge Walmsley.
So the witness has obviously seen the body cam, testified to as much when the video was admitted. The video is going to be played. I'm just going to have him stand if he needs to watch or look at whatever he may be being asked about on the video itself. And I'm going to confirm that the two jurors sitting in the gallery have a clear view of the large board before we go any further. Assuming that they do, I think we've got enough to get through this witness, and over the weekend or later today, we'll figure out what it's going to take to possibly hardwire all of this in order to make sure that we're having fewer technical issues. So that's the plan. That being the case, anything from the state?
We'll go all the way to complete this witness today.
Yeah, I plan on getting this witness done. I've got a timing wise, I think this is probably the only witness we're going to get through today. Okay. So I understand nothing from Travis McMichael, Greg McMichael, or Mr. Bryan, ready to proceed. All right. Let's get Officer Duggan.
I just want to make sure if I'm standing here, those two jurors will be able to see that.
Yeah.
Oh.
All right. Thank you, officer. So what we're doing, you didn't hear what I was saying. Since you've already seen the video, we're limited to the large monitor. You may be asked some questions about the video itself. If you need to stand up and look at what's on the big monitor, you're welcome to do so. You don't need my permission to be up and down. Okay, thank you.
Yeah, I don't want to fall out of it.
This works. All right, let's go get the panel.
To stand to see the body camera video that they're about to go through, he can. So we expect that we're about to see more images. Again, we warn you that some of these images may contain explicit languages or visuals. Let's go back in the courtroom.
We probably need them on this end. Yep. Well, if I would prefer them at the state's table, then if you drop your laptop screens and anything else that may be on that table just to get through this video. Okay, thank you. Okay, we're back on. Officer, I remind you that you're under oath. I just want to confirm to the two of you that are sitting there in the gallery, right now we're going to be limited to using this large board. Can both of you see that large board? If at any point during the presentation of evidence, the two of you or any one of you has a problem seeing the evidence as it is being presented, as I said in my preliminary charge, please let me know, and we'll do whatever we need to make sure that you have a clear view of the evidence as it is presented. Okay, everybody understand? Ma'am, right on the end there, do you have any issues seeing the large board? Yep. You can see it. Okay, thank you. Your witness.
Thank you. So once again, I think we're back at State's Exhibit 219. Who is that gentleman right there?
That would be Officer Minshew.
Yeah, I know. They're trying to do something for him. So I get these balls up. Ready for a second? Hey, what they're talking is girls? I think my card. White balance in the center console, please. You don't wipe off once. Get here. Just stay over there for us. Just over there. I know. I'm behind you now. Michael. Stay up. Alright. Sanders, nothing I can do for this gentleman. I have more tape. Yeah, I got some for you. I have more tape if Seven is fine.
Duggan at this point in time?
Center test, he was on the stomach. That here, I rolled him over, he stopped breathing, a couple minutes.
So, Officer Duggan, I'm going to stop this right now and ask you a question. Does the sound appear to be a little off on this, not capturing everything?
That is correct.
Okay, and so we're not hearing actually everything through the sound system right now that is on this body cam video, are we?
That is correct.
Is it fair and accurate as far as depicting what is going on as far as the people in the scene, meaning Officer Minshew and the other people who are in where the crime scene tape is?
Yes,
Okay, so the video that we're seeing right now is very accurate, is that right?
that is correct.
Okay, but these are the EMS people that we're looking at right now?
EMS and fire, yes, ma'am, that are right on scene.
All right. And the problem, of course, that we're seeing with the playing of this right now is they were actually speaking to you, saying some things, but we were not hearing that. Is that right?
That is correct.
Okay. And for right now, Officer Duggan, let's go ahead and continue with the video. At this point in time, are you communicating to EMS what you had done as far as tending to Mr. Arbery's body?
Yes.
This last. Stop the
And had you made an earlier determination that there was nothing else you could do for Mr. Arbery?
Yes, ma'am.
Okay. And why did you make that determination?
For the amount of blood loss that I observed on the scene, the lack of rise and descent of his.
Yeah, he's touched on this. Pause the video, call for question form.
So at that point, when you had made that determination, it was because of blood loss, what else?
The amount of blood loss I saw on the scene, the lack of rise and fall of the chest, and basically the gaping wound that I saw in his chest. There was nothing I could do for him.
The nature and extent of that wound?
Yes, ma'am.
All right. Now, at this point in time, are other officers beginning to arrive on scene?
Yes, ma'am.
So these would be other officers who had responded to Minshew's call out, is that correct?
Yes, the ones that were on duty on his shift, yes.
All right. In addition, when we go back and here we are at minute 4:31, at any point in time, this gentleman standing here, did you ever know who that was or interview him or anything along those lines?
No, ma'am.
Is it uncommon for people to come to scenes like this?
No, it is not.
At this point in time? At that point in time, when you turned around to look behind you, was someone actually standing behind you?
Yes, ma'am.
And who was that?
Junior, Mr. McMichael.
All right. And did you know where Greg McMichael was at this point in time?
I believe he was still across the street. I'm not sure.
So when we're looking here, when you say across the street, are you talking about Officer Jackson and Mr. McMichael over here?
Yes, ma'am. Across from behind. I wasn't aware at the time then who was behind me.
At this point, you shut off your body cam.
That's correct.
And did you then stay at the scene for any length of time?
For a few minutes after that, to debrief the responding supervisor and to have permission to exit the scene and leave.
Right. And did you write a report in conjunction with the work that you had done that day in responding to Holmes and Satilla Drive on February 23rd, 2020?
Yes, ma'am, I did.
All right. In addition, when you got there via your car, how does dash cam work in a patrol car?
The cameras that we had at the time were linked to usually the lights and the sirens. More importantly, the switches on our console that activate our lights. When we activate the lights, if the camera is on, it will activate the camera to start recording. The system that I had in my car at the time was a watch guard camera system. It has a separate shoulder mounted mic, which I was not wearing that day as I was in an off-duty capacity and often did not wear because I had an actual body camera that would capture the audio. So therefore, there was no audio to the video that was captured when I departed out of the restaurant parking lot and responded to the scene.
And with regard to State's Exhibit 220, which contains 5 videos from your dash cam, have you had the opportunity to review State's Exhibit 220 and those 5 dash cam videos?
Yes, ma'am.
Are they fair and accurate?
Yes, they are.
Any alterations?
No, ma'am.
All right, this time the state would tender into evidence State's Exhibit 220.
You're asking about his dash cam?
Correct.
Yes, no objection.
No objection.
No objection. It's admitted.
Thank you. At this time, the state will publish. Where are we? Right here, Officer Duggan.
This is traveling northbound on 17, going towards Satilla Shores, just passed underneath the I-95 overpass. Frontage road on the right where McDonald's is. Coming up to the Satilla Shores neighborhood on the right-hand side.
And were your sirens going this entire time?
Yes, ma'am, and lights.
Is that a red porta potty?
That appears to be so, yes, ma'am.
Was that a man on a bicycle waving at you?
Yes, it appeared to be.
Once again, who is that officer?
That's Officer Minshew.
And who just came into frame?
That'd be myself.
video 2 of State's Exhibit 220. Over to the right, the person pacing back and forth.
I believe that is Mr. Travis McMichael.
Now, I'm going to pause here at 211, 214. This person who just walked from over here to over here, who's that?
I believe that's Mr. McMichael Sr.
All right. And the individual back over here, you can barely see. Did you even notice him when you were there at the scene?
No, ma'am, I have my back to him.
Okay. Do you know who that person is now?
I believe so, yes.
And who is that?
The third party over here.
Mr. Ryan?
That's correct. There he is.
State's third video of State's Exhibit 220. At this point in time, do you actually know where Greg McMichael or William Bryan are?
No, I don't know.
State's Exhibit 4, State's Exhibit 220, video number 4. Who are these gentlemen who are coming into scene here at second 24?
Glenn County EMS.
Who are these two officers, if you know?
Officer Roberts and Brandon Berry.
Who is this officer crossing right now?
I think that was Officer Brandon Berry.
And these two gentlemen approaching Mr. Arbery's body?
Fire rescue paramedics.
And lastly, video number 5, State's Exhibit 220. Do you know who this gentleman is who's just walked up and is speaking to Officer Brandon Berry?
No, ma'am, I do not.
Stopping now, right here at 120. Person over here in this corner. You see where I'm pointing?
Yes, ma'am.
All right, so I'm gonna back it up a touch in 1 minute and 18 seconds. Who is that person?
I'm not sure. I can't really tell from here.
Okay.
I'm thinking it's Mr. McMichael Sr.
All right. And the man he's talking to over here in the blue shirt, did you know who that was?
No, ma'am.
That concludes State's Exhibit 220. Your body cam was uploaded and made part of this case file?
Yes, ma'am, it was.
All right. And in the report that you wrote in conjunction with this activity, did you include in there what Mr. Travis McMichael had said to you?
I did.
Right. And after this, what we saw in this video, did you receive authorization from Sergeant Leska to then leave the scene?
Yes, I did.
Right. I may have a moment. I will pass the witness, Your Honor.
Legal tracks. Yes, sir. Thank you.
Good early evening, Officer Duggan.
Good evening, sir.
We've had a chance to talk just a little bit before you testified. Is that correct?
That is correct.
Okay. We hadn't really talked before then.
Not at all.
Not at all, yeah. So you know me as Jason Sheffitt. I represent Travis McMichael.
Yes, sir.
Okay. So as I understand it, when you arrived on the scene, you're going to follow a protocol that essentially tells you what you need to do first, second, and third. Is that fair?
Yes, it is.
All right. So first on the list is officer safety. You'd agree?
Yes, sir.
All right. The safety of yourself and others that could be in harm's way.
That is correct.
All right. Then once you establish that you're safe, that others are safe, and there's no present danger or threat, then it becomes about scene integrity.
That is correct.
So as we see you step into the scene on the video, these are the things that are running through your mind.
That is correct.
Is it fair to say that when you see Officer Minshew, who was the first officer to arrive on scene, that you're looking at him to see at what phase he might be in about assessing safety and whether or not it's safe to enter the scene?
That is correct.
Okay. Did you trust that Officer Minshew had made enough of a determination to feel safe to be out on the scene and start to assess things yourself?
Yes, sir.
Okay. The second thing that you then sort of undertook when you got into the scene was to do an assessment of Mr. Arbery. Is that fair?
Yes, it is.
Okay. And now you have had a lot of medical training, 184 hours, I believe is what you testified to.
Yes.
Okay. Which includes assessing the health and wellness of people who have been shot by guns.
That is correct.
Okay. In your time doing that, have you come to understand about wounds and gunshot wounds and blood loss?
Yes, I have.
All right. Is it fair to say that you have made observations in the past about the amount of blood loss a person can endure before it becomes fatal?
Yes, sir.
Okay. When you had arrived at the point where you were going to be assessing Mr. Arbery, and before you turned him over to really check and look at wounds, there was a lot of blood that you noticed on the ground.
That is correct.
Okay. And was it your opinion at that moment, before you even flipped him over, that the volume of blood loss could have been such a complete volume that he would have been deceased at that moment?
It could have.
Okay. And when you turned him over, one of the things that I think you noticed, and I'll just say this, you wrote a report in this case, right?
That is correct.
You and I discussed the report that you wrote.
Yes, sir.
Okay. And in that report, really, you wrote a lot of your observations about that day.
That is correct.
Okay. And those observations include observations about Mr. Arbery when you came up to first encounter him.
That is correct.
Okay. And one of the things that you noted was that he had fixed eyes.
That is correct.
Okay. And fixed eyes is a sign of brain death. You familiar with that?
Not particularly, no.
Okay. You noted fixed eyes as something that indicated that his eyes were not reacting to light.
Correct.
Right. His pupils were not opening or narrowing. Right.
Correct.
Okay. And that's what you mean by fixed.
Correct.
And that his gaze was also not moving. His eyeballs were not looking around or doing anything like that.
Correct.
Okay. And I believe that you made the conclusion that there was nothing that you could do to do any form of resuscitation.
That is correct.
Okay. You were also asked about Baker 9. Baker 9 being the area that includes Satilla Shores and the Exit 29 area, right?
Yes, sir.
Okay. And is it my understanding that you are one of the officers that works the Baker 9 area?
No, sir, I'm not.
Okay, but the Baker 9 area is an area that's worked, and I think your testimony was by one officer at a time. Is that fair to say?
Usually, yes, sir.
Usually is. And is that because there's a population size that determines Baker 9 and one officer is enough to work that particular Baker?
Not particularly the population. It does have a factor in that. It'd be fair to say population size for that is sparse in that area.
Okay.
More concentrated near the interchange area and going west. And then it's dense populated or relatively
more densely populated after night. Okay. Are there some Bakers where one officer works multiple Bakers?
on occasion, yes.
Okay. And I think your initial statement when the state was asking you is that there are a quote unquote fair share of calls in the Baker 9 area.
That is correct.
And what you mean by that is people calling 911 for whatever problems that it is that they're having that they need law enforcement assistance with.
Correct.
Okay, very good. Now, one of the things that you also did when you came onto the scene is you made some observations about Travis McMichael, who you've been kind of referring to as Junior.
That is correct.
Okay. And what you mean by Junior is that he's the son of Mr. McMichael.
That is correct.
Okay. And one of the things that you observed about him was that he was very upset.
He appeared, yes.
Yes, that's something that you noted in your report. You wrote the words very upset. Is that correct?
Correct.
And you also talked about the fact that he was sitting kind of off to the side by himself, correct?
I believe so, yes, sir.
Okay. And that he was doing a lot of pacing, right?
I don't recall him doing a whole lot of pacing.
I thought we just watched the video where you saw him kind of pacing back and forth.
On the video, I saw that.
Okay, so the point that you're trying to make is maybe you don't independently recall that, but now that you've watched the video, you see that there was a lot of pacing going on.
Yes, sir.
Okay, but you did notice that he was covered. He was covered in blood.
That is correct.
Do you recall seeing that he had also had blood on the back of his neck? Do you remember seeing that?
No, sir.
Okay. One of the things that you did at some point, I think we may even see you do it on the video, is you kind of indicate over here, and you asked Travis if he is okay. Is that correct?
That's correct.
Okay. And what you meant by is he okay essentially is because he has blood on him and because he's there at this scene of the shooting, you want to know if he's got a physical problem ongoing at that moment, right?
That was the meaning of my question.
That was the meaning of your question, but he interpreted that in his response to you with kind of an emotional response by saying, no, I just killed someone.
That's correct.
Okay. And as you and I were talking, and I was asking you to help me understand how you interpreted his emotional response, I believe what you shared with me is that it was like a driver of a car who had just hit a child and then asking that driver after that accident, are you okay? And the person says, no, I'm not okay. I just killed a child. That's how you kind of likened it to me. Is that fair?
That's correct.
Okay. Now, one of the things that the state asked you about was your training. And after 12 years of training, part of that includes use of force training, right?
That is correct.
When to use particular styles of policing to try to either, number one, de-escalate a situation, right?
Correct.
Or to have to use a particular level of force to either protect others or yourself. Fair?
That's correct.
Okay. One of the things that I think you've been taught is leaps. Does that term have meaning to you? Leaps, L-E-A-P-S.
Not familiar, no, sir.
Okay. Are you familiar with, in terms of when you begin to investigate a situation, that you would use something that's called LEAPS that stands for, I'll expand it for you, listening, empathizing, asking questions, paraphrasing, and summarizing. Is that a technique that you're familiar with when it comes to engaging with either a suspect or somebody that you might be investigating?
No, sir.
Okay, so how about this? When you're investigating a particular person that you may think has done something wrong, one of the techniques that you might do is to come up and talk to that person.
Correct.
Okay, you might ask them questions.
Yes.
To try to understand what's going on.
Correct.
And this is something that you've been taught to do as a police officer, right?
Correct.
Don't just assume the worst. Let's begin with or attempt to have a conversation.
That is right.
Okay. And you might try to empathize with that person to try to see it from their perspective a little bit as a way to potentially keep things from rising up and getting heated.
Correct.
Okay. The other thing that you would certainly be taking stock of is the mental state of the person, right?
At this point, I'm going to go ahead and object to relevancy of what the officer dug in his training as far as all of these things have to do with his responding to the scene of this homicide.
My response is, Your Honor, this officer was asked about his training. He's on cross-examination about that and about his approach, and I feel it's a fair area for cross-examination.
The objection sustained. We've seen what his involvement was as far as this particular case, unless you can work me through exactly what this would be relevant to in his role in this case.
Yeah, we have an officer who's been trained, who's gotten training in use of force and de-escalation. He has a knowledge to answer some of these questions. And as the court knows, this case is going to be about use of force and de-escalation.
The objection sustained.
Okay. So you're not allowing me to ask him any more questions about his training? Is that what I understand?
I didn't say that. The objection to your question was sustained about the line of questioning that you're going down.
All right. One of the things that you do as an officer, though, is if you can't have questions necessarily answered by someone, you're also, though, paying attention to how they're interacting with you.
I'm going to object to this entire line of questioning as relevancy for this officer. He didn't interact with any witnesses, and we object to relevancy.
I just sustain the objection on that line of questioning.
Okay. When you arrived at the scene, you're looking at Travis McMichael, right?
Correct.
You're looking at Greg McMichael, right?
Correct.
All right. You're looking to see who else is around you, right?
Yes.
And as you're assessing officer safety, you're looking at their conduct and behavior.
Correct.
All right. You obviously have now seen Officer Minshew show up on the scene, and you've made an assessment of that he may have done that, assessed the behavior of people.
Correct.
But as you're arriving on the scene, you're also going to make your own assessment.
Correct.
Okay. And you're going to look to see the behavior of Travis McMichael and Greg McMichael as you approach and enter into that scene, right?
That is right.
You're going to be looking to see if there's any aggressive movements by them.
Yes.
You're looking to see if they approach you.
Correct.
You're looking to see if they respond to you when you talk to them.
Correct.
You're looking to assess their level of mental acuity so that you can determine if there's anything wrong with them.
To an extent, yes.
Right. And so one of the things you might do is ask them questions to see how they respond to you.
Correct.
Okay. And so also, at no point did you have to use with Travis or Greg McMichael any kind of verbal commands against them to try to de-escalate them in any way.
Correct.
Okay. You didn't have to say something like, stop, don't come any closer.
I didn't.
You did not.
I did have Mr. Michael, Mr. Senior.
Okay. There was a moment where you were close to Mr. Arbery that Mr. Greg McMichael started to walk towards you a little bit.
I believe there were 2 times, yes.
Okay. And you put your hand out and you said, you need to just stand back for a minute.
That is correct.
So that's an example of how you might use a verbal command to keep some distance between you and another person. In this case, Mr. Greg McMichael.
That is correct.
Okay, but at the time that he walked to you, he wasn't doing anything like reaching into pockets or holding any kind of a weapon.
No, he was not.
Okay, you were essentially trying to assess Mr. Arbery at that moment.
Yes.
Okay. And so for the entirety of your time on the scene, you never had to say to Travis, stop or don't come closer to me.
Correct.
He was very cooperative and kind of waited over to the side.
That is correct.
Okay. 1 second, please. I don't have anything further for the witness. Thank you, Your Honor.
Thank you very much. No questions. Anything from Mr. Bryan?
No questions.
All right. Anything then further from the state?
No, Your Honor.
All right. Thank you, officer. You can go ahead and step down.
Your Honor, for the record, we are not releasing any of our witnesses from subpoenas, and all of our witnesses have been informed they are not to discuss their testimony, and we're reserving the right to recall Officer Duggan if necessary.
All right, Officer Duggan, you are subject to recall. Thank you.
We were going to ask that you not be released, but it sounds like you're not.
Okay. All right. Yeah, you're released for the day. You're just subject to recall. Thank you. I think that was misinterpreted as a mistake. All right, ladies and gentlemen, we are at a good breaking point for the day. So what we're going to do at this point is
all right. I love that he used my line because we are at a natural stopping point for the day, y'all. So shout out to my family over there on Twitter. Like, shout out to the Twitter family because it's 471 of y'all tuning in right now. And I appreciate your viewership. So shout out to y'all. So what is going to be coming up this week on this channel is that we will, yes, son, just 1 second, okay? Okay, 1 minute. This week we are going to be rewatching this trial from beginning to end. We were actually graced with the presence of Ahmad's aunt, who's in our chat right now over here on YouTube. That's what I'm trying to tell y'all. If y'all want to come and communicate with us, all you got to do is come up here on YouTube and talk to us in the chat because it goes down over here. But she did provide us with a little blurb that she will be going live to discuss this trial from beginning to end, the inside and the outside of the courtroom. So we are watching this as like a prerequisite for the upcoming trial for Ms. Jackie Johnson, who is or was the DA that recused herself from prosecuting this trial because Greg, the father, was the investigator who used to work for her. So again, that's why we're watching this trial. We're going to rewatch it. Also, I will be creating a Taylor Unbridge calendar. So I'm going to be putting that out. I might even put it out this week to let y'all know what we're going to be watching, our start times, our end times, etc. If you have not done so already and you are watching, make sure that you like and subscribe to my channel. And then if you have, more power to you. Thank you for supporting us. So we'll end for today. I will see y'all tomorrow. We're going to pick right back up on day 2. I'll actually even get us pre-scheduled so you can, click notify and get your notification whenever we go live tomorrow morning. So I will see you guys then. I hope you all have a good, safe, blessed, and happy evening. And I'll see y'all tomorrow, Taylor Gang. And just pray that they send these kids to school tomorrow, because if my son called my name one more time.